purtroppo. Vabbè, e vediamo come vogliono far loro. Senta, grazie di tutto Concita, Grazie.
Uh, Dear all, can I ask you kindly please to be seated? We are on the verge of starting. Thank you. Good morning and welcome to the final conference of the European project of CrossJustice. It's an honor and a pleasure to leave the floor to Professor Giovanni Molari, the rector, the magnificent rector of the University of Bologna. Please, Giovanni.
Good morning to everyone. Dear authorities, dear minister, dear students, dear colleagues, dear speakers. We are here today to celebrate the final day of the CrossJustice project. This is a research project financed by the European Commission that links two areas that are different from each other. The first one is regarding legal reasoning. The project is in fact focalized on the field of the accused defense rights as regulated by the European level in a multidisciplinary level and integrated system. The second one regards the use of artificial intelligence systems to promote better knowledge and the application of legal rules. The importance of the topic and its innovation is demonstrated by the number of universities and research institutions involved and by the prestige of speakers present here. In expressing my word of welcome, I would also like to take this opportunity to renew my invitation to all our colleagues to compete in the field of international and European research by setting up networks and projects that deserve to be found by the European Union. In this moment, in which we have a lot of opportunities due to next generation Europe, we should not reduce our commitment to the EU projects. More in general, we must not reduce the long-term research capable of producing lasting results, as is clear from the work carried out with this project. This project shows the importance of an integrated approach between academia and civil society. Thanks to the multidisciplinary methodology, the project managed to meet the need of legal professionals with the result of academic research, providing a practical tool and showing the capacity of the university to effectively contribute to social development. The project also stresses the importance of our university to place itself in the international and the European community in terms of creating stable and fruitful relationship between partners from other countries. It also shows how it provides funds to support the research within the European Union context. That is a dimension which is today essential for our academic. At the end, I also would like to thank Professor Sartor for the organization of this meeting and to congratulate him for the recent nomination in the scientific board of ERC. A special thanks also to the Italian Minister of Justice to be connected with us today and to be with us in this important conference. I wish you a fruitful day and I hope you enjoy your time in Bologna for this meeting. Thank you very much.
Thank you, Professor Molari. And now it's a deep honor and pleasure to give the word to our Minister of Justice, the Minister of the Italian Republic, Professor Marta Cartabia. Please, Professor and Minister.
Thank you so much for inviting me to this important conference. I have an echo. I don't know if somebody can turn off the micro. Maybe it's better now. Okay. Thank you so much. My respectful greetings to the Rector of the University of Bologna, Professor Molari, the Director of the Department of Law and the Principal Investigator of this important research, Professor Caianello, Professor Sartor, and all the colleagues, the authority present to the conference, and all the people that are connected to listen to the result of this important project on CrossJustice. The invitation you have addressed to me gave me the opportunity to get to know the idea and the result of a research that I consider an original one, a path-breaking, really a pioneer in the field of putting together and linking the competencies of new technologies and law and jurisdiction and the practice of administration of justice with the purpose of enhancing the protection of fundamental rights and especially with the idea of focusing on the protection of the rights of the accused and the indicted people in the context of the European Union. I think that the idea of setting up this database, this intelligent database, not an ordinary one, in order to measure and to evaluate the level of compliance of our legal order with the European Union is a very, very promising one, a useful tool for citizens, lawyers, judges, and in general, all the decision maker people that have to take decision. And so by means of this new instrument, we have the opportunity of relying on a more complete information regarding the level of accomplishment and of our system to the directive of the European Union. You take into consideration 6 important directives that touch upon the fundamental rights and the rights to defend of those who are subject to a criminal proceeding. That touches upon interpretation and translation, information, access to justice and to the defense, presumption of innocence, and legal aid. You touch upon also the right of the underage people and in general vulnerable people that get in touch with the criminal justice. Let me say that I very much appreciate the idea of developing new tools, new technological tools in order to improve the performance of our justice system. This is also part of the big reform that we are trying to putting into place, especially concerning the criminal law justice after the Delegation Law 134 of 2021, where an important chapter of the new criminal process will be exactly the relying of the possibilities and the capabilities of information and technology in order to have a more modern criminal system. This opportunity, this occasion of presenting the result of your important research gives me the opportunity to say just a few words about one of the chapters that is not included in the big reform, but it's something that is taking place in the last months with the Decree Law 188 of 2021 concerning the presumption of innocence. This is one piece of legislation that was indispensable and necessary in order to have our legal system conform with the European Union. This is not an idea of the Minister Cartabia or of the government or whatever you want. This was a necessary act in order to get our system compliant with the European Union. There is a directive dating back to 2016 that was still waiting to be adopted and translated into national legislation. Why this piece of legislation was so much discussed and criticized even today in some newspaper? I would like to stress the fact that this piece of legislation is meant to balance two important and unavoidable principles of our democracies and our constitutions. The right to information, the right to be informed of the citizens and of the media, and the right of the persons that are subject to a criminal procedure not to be portrayed as the right of innocence of those people before the end of the process. We have to take very seriously these rights, both these rights, and to find a new balance in a context where the power of media is very much enhanced by the new media that can multiply the effect of the information that can be spread very quickly and with enormous powerful system all over the web and reach a huge number of people. So it is not the idea, there is no doubt that the right to inform is a fundamental pillar of our democracy. The only problem is to adapt how to inform in order to preserve the right to presumption of innocence that is there since century in our democracy, and we do not want to dismiss in front of the new power of the new media. After all, this piece of legislation is nothing more than the execution of this European directive that was executing, taking into consideration some practices and some soft law that was already organized by the judicial office in some parts of Italy. Rights are to be taken seriously. Ronald Dworkin said some years ago. This is something that we have always to keep in mind, and the changing context asks us to reshape also the old rights, because when history and the context change, also the modality of preserving these rights has to follow. So I very much appreciate and I congratulate all the University of Bologna for this very, very important research, and I thank you also for the opportunity of getting to know the result of this research that will be very useful also for the work that this government and this Minister of Justice want to continue to the service of a better service of justice and to a better spread of information also as far as the result of justice are concerned. Good luck, good work, and congratulations to the staff and to the people that have worked to this group of research. Thank you very much.
Thank you. Thank you very much, Madam Minister, for being with us, for the word you just spent. We know how much you're doing for reforming our system of justice. We are deeply involved in your task, and we will be honored to take the lead of another great project you planned in these months, the building up of the officer's process, in which system of EI and legal informatics will be melted together with an improved respect and implementation of rights of the citizens in both civil and criminal proceedings. It's an honor to serve with you, Madam Minister. Thank you.
Thank you.
Well, and now I have to tell you that Professor Rubertini couldn't be here because he is contagious, one of the last chance of contagion by the virus, but he is well. So we wish him the best. And it's my turn to close the welcome words and to say some word about the research. So the mine will be the last welcome words, but also the introduction of the project of which I am the PI, not worthily, but nonetheless, the PI. So this is the final conference, and welcome to it, Empowering Defense Rights Through Algorithms and Artificial Intelligence. Well, take into account that I do not know most of the things about which I will speak, and the responsible of these ideas are young researchers sitting among you who planned, thought, and realized the outcomes. I'm just taking the prestige, but they conducted the research. So we started just realizing that we have a certain degree of harmonization in the European Union concerning rights, at least on the paper. We have directives and we have legal implementation by national states. But nonetheless, we have disparities in the application, in the practical application of rights. The minister herself said that one thing is implementing one directive, such as, for example, the presumption of innocence directive. Another is in practice how to protect the same right. So what can we do? Can we do something to improve the things? And here is where Giulia and Giuseppe came to me and Giovanni to proposing that we could do something new and melting together legal perspective, traditional perspective in interpreting, examining the words of the legislation, and on the other side, using the computational system to put the two techniques together and try to improve the way in which we defend rights in practice. We had to focus, well, I just forgot to tell you that the research started in September 2019 and is ending at the end of this month, so in February or March 2022, I don't remember exactly. I should know, it's February, it's just a few days. Okay, and we started in focusing on the defense rights directives adopted by the Commission and the European Union legislator according to the Stockholm Programme. The first directive concerns the Interpretation and Translation Directive. Then in 2012, we had the Right to Information Directive. Then in 2013, the crucial directive concerning the access to counsel. And finally, in 2016, a package of 3 directives, one concerning the presumption of innocence, the other concerning the juvenile and vulnerable defendants, and the last one regarding the directive on legal aid. So we wanted to know if member states of the European Union, or at least a set of member states, were implementing and protecting in practice in the same way these fundamental rights. And how did we do? So it is 24 months of research plus 6 months that were allowed by the Commission because of the pandemic contagion and the difficulties of ending the project within 24 months. So we were allowed a further time. We collected relevant data in the old way, that is asking partners of the other university, of the other research institution to help us in determining jurisprudence, legislation, academical thinking about how the rights were implemented in their country and writing reports about them. But we also developed an ontology And a natural language processing, I really don't know exactly what does it mean, but you are supposed to learn in the second part of this conference exactly how this works, but we transform this information in computational data that can be used by computer machines. And we created a platform and developed its function. Then we tested the capacities of this platform, and in the end, we tried to conduct an analysis that was conducted on both sides in the traditional manner, in making comparative law, but also using the new AI system that we created thanks to our friends in informatics. Here you may see that we dealt with 11 legal orders plus the European Union legal order, of course. So there are 12 legal orders that are Bulgaria, Croatia, France, Germany, Sweden, Romania, Italy, Poland, the Netherlands, Portugal, Spain, and the European Union. And here are the partners who participate with us in this research. We have 5 universities or research institutions, the University of Zagreb in Croatia, the University of Leiden in the Netherlands, the UI institution in Florence, the Wrocław University of Poland, and the University of Bologna, who also is the leader of the project, in the both offices of the Department of Legal Studies and the Alma Human AI Center. But we also had involved, on the part of the informatics, the University of Turin in Italy and the APIS Europe institution, that is a leader institution in developing platform and a computational system in law, especially in law. They were pioneers in this field. So the platform is something that we like a lot, although I'm not able to use it completely, but I always need someone who helps me, but it's their merit to have built up the platform. So what is the methodology we used? We identified first the gaps and problems in transposition of the directive, both in the 2 ways, the traditional way, but also the automated ways. Then we improved the knowledge across system and potentially in transnational cooperation. So we thought that if we can have a more harmonized and practice system of defending the defendant rights, we could also improve mutual trust and judicial cooperation among the states. This is a very traditional starting point of the whole reform involved in criminal procedure at the level of the European Union. Then we developed an online platform to support the effectivity of defense rights at the domestic and transnational level. And this platform is open to the access of anyone. That means professionals, bar members, citizens, students, academics, NGOs, and whoever wants to experiment how this platform works. But how this platform is conceived? Well, we have a semantic analysis of legislative text and the natural language processing that is implemented in the platform, but also we have national reports. In the website of the project, you will find national reports written down in the old ways that describe how the defense rights are implemented at a national level. So we have on the one side the online platform, on the other the comparative analysis translated in data, and we have 3 different automated user support tools in the platform: the legal database module and the advisory module, separated in single case assessment and in mass testing assessment. And if you look at this picture, you may see that you may find a sort of creation of harmonization index. So from a first glance, you may see if a certain national state is compliant with the defense of a certain specific right. And you may see in 2 ways. The one is the old one, the one I like more, in which you have a sort of assessment expressed in words, like a high level of implementation, or a medium level of implementation, or a low level of implementation. But on the other side, you have a heat map, which highlights the passage in which the directive is correctly or highly implemented, and the one in which the implementation is poor or completely lacking. And the final goal is to increase the capacity to implement the right of suspects and defendants in criminal proceedings, to strengthen cooperation and mutual trust among the states, and identify new implementation techniques that may consistently improve the way in which we work. Some days ago, my father underwent a surgery operation, very simple one, so he is fine. There's an intervention to the coronaries. And the charming thing was that I discovered, but it's very an ordinary thing, is that two doctors worked to conduct the exam and decide if they had to intervene to open the coronaries or not. But on the same level, in parallel, a computer was analyzing the same data, giving a parallel suggestions. And in the end, both the doctor reached the one conclusion, but also they compared that conclusion with the one reached by the computer, and then they decided if an intervention was necessary or not. So our goal is to do something similar. So can we put together human legal thinking with the help also and the confrontation, the parallel with also the computational legal thinking, just to have a better, more harmonized way of implementing and enforcing the rights. And this is what we did in these months to spread knowledge about what we created. We organized various events to explain, and this is the last event, about how to explain and spread knowledge about what we reached in our research. So let me say with some final consideration about it. This research has something fantastic for my perspective, and the fantastic thing is that sometimes happens in academia that, well, it's just 9 centuries, 934 centuries, Mr. Rector. Tomorrow will be the 924th inauguration academic year, in which generation passes knowledge from one generation to the other. And, well, this is very usual of human beings to pass the knowledge. But what is special about academia is that sometimes the reverse happens, that the younger generation passes their knowledge to the older generation. And this is very good. They take you by hands and lead you to the new world. Well, it happens, not very often, something similar to parenthood, but more rational and complex. And as long as we are able to continue to involve the young generation, but also to leave the things to the youngest that make things better, well, there is reason to hope, despite all this and rudimental method like violence, desire of power, overcoming human beings. Well, everything in the end, I think, can be overcome as long as we think and put our bets on the translation of knowledge and the cooperation between generations. And that's it. So enjoy the conference. Welcome to Bologna. And one last thank, I'm sorry I was forgetting, to the partners who made possible this research, our institution who put the data, the knowledge, the capacity, the prestige of the conference. So we are so honored and pleased to have worked with you. Thanks to Giovanni Sartor, who was a companion, a co-leader, a friend with which sharing knowledge. Thanks to our special guests, because we are here because in your field you open new path. In a way, we tried to follow you because we understood that we could change the things because you started first. And lastly, thanks to Giulia and Giuseppe, who are the new generation who presented us new possibilities and are heart and souls and backbones of this research. So welcome here, have a nice work, and I now leave the floors to our guest speaker.
It's nice to go back, to go home. Thank you very much to Michele Caglianello and to the organizer of this important conference. It's really a pleasure to be here again with friends and in a very delicate moment. We are maybe going to see today that we are having problem for the European arrest warrants in some member states, such as Poland, Romania, and Hungary. But I think that those member states that now are some of them refusing the primacy of EU law and even the fundamental values of the European Union today should be would probably be in a position as is Ukraine today. So the membership to the European Union is a value that we have to defend. Having said so, it is a great pleasure to introduce the panelists of this this important panel. We start with Mr. Danilo Ceccarelli, who is the Italian member of the European Public Prosecutor Office. I'm particularly proud to say that Danilo is also a former student of mine many years ago at the University of Urbino. And Mr. Ceccarelli will speak of the rights of defense, of course, in the framework of European Public Prosecutor Office transnational inquest. All the panelists have around 15 minutes. If you manage to keep the time, we have some time left for questions from the public. Danilo, you have the floor.
Yeah, sorry. That is competent in respect of offenses that affect the financial interest of the Union. And that is the first ever supranational prosecutor's office with authority and investigative powers and prosecuting powers in all the member states that take part to the enhanced cooperation of the EPPO, which is 22 member states. Well, when we started our operations, and even before, we were in touch, and we still are in touch, with the associations of defense counsels. And they came to us expressing concern about some hot points. Access to case file, for example, which is very different in different member states. The decision to allocate the case where more than one state has jurisdiction. Our decision to allocate the case, which is based on criteria that are in the regulation, but there's a lot of flexibility. And of course, the concern was about forum shopping, the decision of going and allocating the case to the member state where it's easier to investigate. We took on board everything. We have an open dialogue. We still talking to the associations, and we exchange ideas continuously. However, one of the most obvious added value of the EPPO is transnational character. Inside the 22 member states that take part into the enhanced cooperation of the EPPO, it didn't make any sense to continue using the traditional instruments of mutual legal assistance and mutual recognition. It was already established a body with authority, direct authority in the 22 member states. As you know, we are established by regulation, so it's immediately applicable to the member states. So the legislator well thought of creating a new system for cross-border investigation. Actually, the funny thing is that we have a regulation which is composed by 120 articles, and we have about 43 articles that deal with data protection, and Article 31, that talks about cross-border investigation. Well, if you think about the legal instruments that have been developed throughout the years in the European Union to reinforce mutual legal assistance and mutual recognition, and the fact that on the other side we have one article that is supposed to regulate everything, you might start to understand that there is something wrong here, right? Article 31 is based on some basic principles, and some of them do not create problems. For example, Article 31, paragraph 2 of the regulation states that the justification and the adoption of the measures is governed by the law of the member state of the handling European delegated prosecutor. The way it works is like that. We have a central office, we have European delegated prosecutors in the 22 member states. They are in charge of the investigation. When there is an investigation that has cross-border dimension, the handling European delegated prosecutor, the one who is in charge of the investigation in one member state, does not request the other ADP to undertake a measure, assigns the ADP, or he or she assigns the measure to the other European delegated prosecutor, and the other European delegated prosecutor simply undertakes the measure. This is managed at a central level within the spirit of a single office. If there is need for consultation, talking, or there are issues, legal issues or operational issues to resolve, it's the central office that makes a decision. That's the spirit of having a single prosecutor's office throughout the member states with competence and jurisdiction all over the member states. So very simple, and actually it is very effective. It's very swift, it's very quick. You assign the measure, the assisting European delegated prosecutor executes the measure. And we know that the justification and adoption of the measure is ruled by the legislation of the handling EDP. So it's quite easy. We stick to those rules, and we execute. Problem is that the regulation kind of forgot the judges. Not a little problem, right? Because most of the investigative measures require the authorization of a judge. If I have to interview a witness or a defendant, well, there's no problem. If I'm looking for documents in a public institution, there is no problem. But what about a search? What about seizure? What about freezing? What about interceptions? All very invasive investigative measures. So the regulation says something about that, which is bizarre, I would say. The regulation states that if judicial authorization is required under the law of the member state of the assisting ADP, the assisting ADP shall obtain this authorization. So this is not a problem, of course. Already in the system of the European investigation order is like that. We request search in another member states, and the requested authority, if they need an order from the judge, they go to the judge. But everything is based on the legislation of the requesting authority. That's in the traditional system. The regulation also states that if judicial authorization is not required in the member state of the assisting ADP, and it is required in the member state of the handling ADP, it is required in that member state. No problem, again, that's fine. But then the regulation said something quite astonishing. It says, anyway, there must be only one judicial authorization. That is a big problem, because if we have judicial authorization only in the member state of the assisting ADP, and we have nothing. In the member state of the handling ADP, who assesses what? Where are the legal remedies? What the defense can do to challenge the authorization? Because in the member state of the assisting ADP, you cannot assess the merits, the substantive reasons. It is impossible. You don't even have the case file. I cannot give you folders and binders in another language. That's not effective. That cannot work. And the same goes with the freezing. Think about the freezing. We have a system that is based traditionally on mutual legal recognition. You have a certificate that is issued by a judge in the requesting member state and is transmitted to the other member state. The other judge just takes note, issues the authorization that rules the execution, the implementation, does not assess again the substantive reasons. We don't have that, because this system also includes freezings of proceed of crimes, which is anyway is not an investigative measure, is a tool to recover proceeds of crime, which is different. So I don't know what artificial intelligence would make of this, actually. But we had to, we started working, we went to the judges, to the investigative judges and pre-trial judges, and they said, well, what I am supposed to do, that doesn't work. Where's the certificate? Where is the authorization of the other judge? Or even a search order issued by the prosecutor in the other member state? Not even that, it's not foreseen. So we had to work on this and created a working group and tried to find a way, a workaround. And while we were working on this, the Court of Justice on 11 November issued a judgment on a European investigation order, judgment Gavanosov, which talks exactly about that, legal remedies, basically, right? The judgment is made of two parts. We will talk only about the first part, search and seizure, which is relevant to us. The second part is much more controversial. We are not talking about that now. But the Court of Justice says something which, to me, it seemed very obvious, and which is any European investigation order that involves search and seizure are entitled to, the defendants are entitled to legal remedies against the investigative measure in the member state that issued the European investigation order. Because this is the only member state where the necessity, the legality, the substantive reason of the measure can be assessed and challenged. There is no other way. And that goes also for the system of Article 31. We read the regulation. If you read the regulation, you understand that the legislature took away from the defendant, from the suspect, the right to legal remedies altogether in the system of Article 31. This cannot work. So recently, in January, we issued guidelines saying that in any case we need to have two authorizations, always in the member state of the handling ADP, and where necessary, also in the member state of the assisting ADP, according to the national rules. And the substantive reasons should be assessed, and legal remedies should be allowed for this reason, for the substantive reasons, in the member state of the handling ADP. This is what we wrote. These are just guidelines internal to the prosecutor's office. Of course, they are not binding to the judge. We are waiting for, we really very much look forward to the Court of Justice to give interpretation, because this is what we need. Article 31 is an article with 4 or 5 paragraphs that substitutes altogether a traditional system of mutual legal assistance, mutual cooperation that has been built throughout 25, 30 years, right? So that we really do need that. Well, one of the most obvious fears that we have is that we are going to have a lot of different jurisprudences. We work into 22 member states. We have judges from 22 member states, judges from small tribunals for high courts, doesn't matter. the competence is exercised before the competent national judge. So it could be anywhere. In this moment, for example, in Italy, we exercise our competence before 140 different tribunals. So the competence for the judge didn't change. It's as it is. It didn't change at all, right? So we really need the judges to read recital 88 of the regulation, which states that national courts should always refer preliminary question to the Court of Justice when they entertain doubts about the validity of these acts, investigative acts of the EPPO vis-a-vis union law. This is really, really important to us. We really look forward to having a consolidated interpretation and a consistent interpretation given by the Court of Justice. We are really thinking that maybe in the near future, the Court of Justice might establish a specialized unit for criminal law, because these cases will be coming up more and more frequently. I hope I've been within the 15 minutes. Thanks a lot.
Thank you very much, Mr. Ceccarelli. Dear Danilo, I'm afraid that the Court of Justice is not going to establish any special section. This is not the way we work. We are really very contrary to that. We must really be, we can't just deal with a specific topic. Why? Because we need the general principle, the horizontal. For instance, the Charter of Fundamental Rights. All the criminal matters, not only the criminal matters, are governed by Article 47 of the Charter, not only Article 47. And we apply this article under many facets, under many aspects. We need to develop, of course, a case law on the European Public Prosecutor Office, on the new regulation. This is a new piece of legislation. And of course, the court gives answer if there are questions, because we cannot ourselves decide. So I think that we will have sooner or later we have to settle many issues, and we always try to balance the two different values of security, of course, and rights of defense, fundamental rights. This is our exercise. I maybe can tell you something about the presentation of Francesco Vigano about this new judgment of European arrest warrant. If Francesco is not dealing himself with that, is a very recent judgment of February 22. So maybe, I don't know whether you know. I will tell you something about this judgment that is a demonstration how we try to balance these two values. And now we have Francesco Vigano, who is not only a judge of the Italian Constitutional Court, is only a very known scholar in criminal law, a professor of criminal law. And he's going to speak of recent preliminary rulings on a CONSOB case, on European arrest warrant, in the light of the role of the national courts, constitutional court, and also ordinary courts in the dialogue with our Court of Justice. You have the floor, Francesco.
Okay, thank you, Mrs. Chair. Thank you, dear Judge Professor Rossi, and thank you very much to Professor Caianello and all the organizers of this remarkable conference on a really crucial topic regarding cooperation in criminal matters in the European legal space. The key question of my brief intervention is, what is the role of a constitutional court like mine in enforcing and empowering defense rights in national legal systems, particularly with regard to the rights enshrined in the 6 directives enacted from 2010 to 2016 as a part of a roadway decided in the European Council of December 2009. Needless to say, what I'm going to say only express my personal opinion and does not necessarily reflect the position of the institution I'm a member of. Well, my starting point is rather obvious. The implementation of these directives is mainly a task for legislators, for national legislators. A task which has been undertaken throughout the European legal space, of course, with different degrees of effectiveness and of compliance, as shown by the chapters I've had the pleasure to read of your book. But courts in general and possibly constitutional courts have also an important role to play in this respect. Let me start with ordinary courts, whose role is really crucial. First of all, criminal courts are called upon to interpret national legislation in the light of the obligations enshrined in the 6 directives, irrespective of the fact whether the legislation they are called upon to interpret has been adopted as a transposition of this directive, or of the fact that it was simply pre-existing to these directives. There is an obligation of conforming interpretation as set by the Court of Justice in famous judgments. And this is, I think, a powerful tool to enforce those rights in practice. And then courts have a second powerful tool, the possibility to directly apply, in the case at issue, those provisions that confer a right to the individual concerned, to the accused person or to the victim. When the provision contained in a directive, of course, is sufficiently clear and precise in its terms, so that no significant room for legislation for legislative discretion is left, and provided that there's no need for legislative mediation, let's say. If the preconditions for a direct effect of these directives are met, then the criminal court and the proceeding authorities are under an obligation to directly apply their provisions, if necessary, by setting aside any contrasting piece of national legislation. And then a third tool, both in order to proceed to a conforming interpretation and to proceed to a direct application of the provisions contained in this directive, the proceeding court, the criminal court, has the power to refer a preliminary question to the Court of Justice, of course, as to the interpretation of these provisions. And these provisions must, on their part, be read in conformity in the light of the rich jurisprudence of the European Court for Human Rights, and particularly in the light of the jurisprudence on Article 6 of the Convention. And finally, a fourth and important tool, which is the tool which concerns the constitutional courts in particular. A criminal court, a proceeding court, has the possibility to refer a question to the constitutional court regarding the compatibility of the national relevant piece of legislation with the European obligation, with the obligation deriving from the directives in question. This last observation leads me to consider what my court, what a constitutional court can do in practice in order to enhance and to enforce the rights enshrined in these 6 directives in the national legal order. Let me just say, as a way of clarification for the esteemed non-Italian colleagues, that the Italian system of constitutional justice does not include a possibility of direct access to the Constitutional Court by the individual concerned. So we have nothing similar to the Verfassungsbeschwerde in Germany or to recurso de amparo in the Spanish legal system. The task of the Italian Constitutional Court is just to receive preliminary questions from courts, from proceeding courts, and to assess whether the national law which must be applied in the main proceeding is compatible with the Constitution. But we have interpreted this power in an extensive way, so as to embrace as well, to cover as well the compatibility of the national pieces of legislation with EU law and with the obligations flowing from international human rights law, and particularly from the European Convention of Human Rights. So, and this at least starting from the twin judgments of 2007, which are well known by any Italian scholar and jurist. And this review, of course, can be performed on the basis of the relevant constitutional provisions, but for example, in this case, on the basis of Article 24 of the Constitution, which recognizes the right of defense, and Article 111 of the Italian Constitution, recognizing the fair processes rights. But we can perform this task also looking at Article 6 of the European Convention, at Articles 47 or 48 of the Charter, and of course, looking at the rights recognized in the 6 directives, which are at the center of our Congress today. And as to EU law, the traditional position of the court has been, of course, not to allow constitutional challenges against national law based on their contrast with EU law having direct effect. The traditional position has been that it is a task for ordinary courts to solve these antinomies by disapplying any piece of internal legislation which is not in compliance with EU norms having a direct effect. Whereas the task of the Constitutional Court has been intended in the past as limited to assess the compatibility with national law with EU norms not having a direct effect. But this position has recently changed, starting from a judgment, an important judgment in 2017. The court, the Constitutional Court, has held that it is competent to adjudicate matters or challenges of constitutionality of Italian pieces of legislation in respect of the contrast to the provision, to the rights enshrined in the Charter of Fundamental Rights of the European Union, irrespective of the fact whether they have or not direct effect into the national legal orders. And a judgment in 2019 has decided a challenge brought against a national law based on its contrast with a piece of secondary legislation of the EU, and the court hasn't asked whether this piece of legislation had or didn't have any direct effect. So we can say that this limitation of the control performed by the Constitutional Court in regard of the conformity of national laws with EU law is not limited anymore by the fact that the relevant EU law has or doesn't have any direct effect. So there's no obstacle, in my opinion, but this is my personal opinion, of course, that future challenges may be brought to the Constitutional Court precisely because of an incompatibility between a procedural law and the obligations set forth in the 6 directives. The fact is that the Constitutional Court has not received so far any such request. So we didn't have to assess so far the compatibility of Italian procedural laws with the rights enshrined in the 6 directives, but we have some significant examples in the fields of procedural rights where the Constitutional Court has raised preliminary questions to the Court of Justice regarding precisely the compatibility of Italian law with the rights enshrined in the Charter and indirectly with the corresponding provision of the European Convention of Human Rights. For example, in 2019, the Italian Constitutional Court has raised to the Court of Justice a preliminary question regarding the extension of the right to silence to administrative proceedings potentially leading to the imposition of sanctions of punitive nature. And we substantiated the referral with extensive references to the Strasbourg jurisprudence on Article 6, of course. And the Court of Justice decided in its judgment Consob in 2021 that this traditional right of the defense must be recognized as well in that kind of administrative proceedings of criminal nature. This recognition, which was originated by a referral by the Italian Constitutional Court, is now valid for the whole EU legal order, thanks to the Court of Justice decision. And then last November, we raised two other preliminary questions regarding procedural rights within the context of the European arrest warrant. In the first referral, we asked basically whether the lack of any provision, both in the national and in the framework decision on the European arrest warrant, of a ground of refusal to execute a warrant when the surrender would expose a person suffering from a chronic and irreversible disease to a serious risk to his health, is compatible with his fundamental rights as recognized by Article 3, 4, and 35 of the Charter, taking into account the relevant Strasbourg jurisprudence on Article 3 and 8 of the Convention. And in the second question, in the second referral, we ask whether the national law implementing the framework decision on the arrest warrant is compatible with Article 7 of the Charter and with the very same fundamental right, and with the very same, framework decision, in as far as it doesn't provide any ground of refusal to surrender third country national, irrespective of his link to the territory of the requested state. So, for example, if he resides, or if he's been residing for a very long time in the territory, if he has a family or social relationships in this country. So I do hope, and I'm concluding my intervention, that these referrals will be a good opportunity to reflect together and to elaborate together at the EU level on the standards of protection of fundamental rights, which must be guaranteed throughout the whole EU legal space in order to enhance mutual trust, which is obviously an essential precondition for a smooth functioning of recognition of judicial decision and effective cooperation in criminal matters among member states. But to enhance this whole process, I think a better and deeper knowledge of those instruments, of those 6 directives is probably needed. Italian courts have finally become more familiar with the European Convention jurisprudence. In practically every referral to the Constitutional Court, we found now, in the recent years, quotations of the Strasbourg jurisprudence, of relevant articles of the Convention, but we don't find, or we very rarely find, reference to the EU legal instruments protecting procedural rights. And that shows, I think, a lack of knowledge, a lack of familiarity with those instruments, which must be filled by legal doctrine and by legal scholars. So my call upon you is really, we have to work on this point, because I think the enforcement of these directives, and then I'm come back to my original starting point, the enforcement and the effectiveness of these directives can be guaranteed not only through legislative decision, but first and foremost by a constant practice by criminal courts and by criminal judicial and non-judicial actors. Thank you very much for your attention.
Thank you very much, Francesco. You raise so many interesting questions and points who take 1 hour to answer. But let me say that the dialogue with the national judges in general, but notably with the constitutional courts, is absolutely quintessential. For us, as you know, in Taricom Assembly, the dialogue produces a reconsideration on the part of the Court of Justice of the previous position. And this is very useful, and this is necessary. We are having now some national constitutional court just refusing the primacy as such. And we issued a very, hard judgment in the case Eurobox and Associatia. We say that the national judge must respect the EU law. Of course, they can ask the National Court of Constitutional Court whether there is a problem of constitutionality, but in that case was a Romanian case. The Constitutional Court said that once they excluded an incompatibility with the Constitution, the national judge was precluded to refer to the Court of Justice. This is not acceptable. This is a part of rule of law. So we really need a dialogue and mutual comprehension. And also, you mentioned the European arrest warrant. This new judgment, the case, the name was Open Bar Ministry, but with this disgraceful anonymization that the court is going to do is now is XY. The number is C 562/21 and 563 Lex 21 urgent procedure. In this case, we face a great problem. We are now having in some member states, notably in the Netherlands, but not only in the Netherlands, but very frequent in the Netherlands, where the requested authority, the authorities, judicial authority of execution, when the requests come from Poland or other states where there are problems of rule of law, they want to refuse the European arrest warrant in general. So here we have to really balance different values. And if you read this judgment, it may seem, I'm aware of that, complicate, maybe not coherent with what with our very hard position on rule of law. But we consider that there are the rights of the defendant, of course, but also the rights of the victims. So we can't allow the judges, in that case, the Dutch judges, just to refuse a priori an European arrest warrant. And the court stressed that there must be provided a test in 2 steps. First, the requested authority must, the authority of the execution must assess whether there is a systemic problem of rule of law, notably of the independence and impartiality of judges. And the second step, if in that particular case, that particular person runs a real risk of breach of his fundamental rights of defense. And now the platform could be useful. Why? Because in this judgment says something that I personally don't fully share, even if I understand that it must also be the person concerned that must provide the relevant element, not only to show that there is a systemic deficiency. This is quite easy. We all know where there are systemic deficiencies, but also, above all, the person must show, must prove that, must at least say, must submit that the panel of the judges that will deal in case of if has to be adjudicated in the state of surrender, then the composition of the tribunal is not impartial, is not independent. That is not always easy to do. But I think that at least in the criteria of the platform, you could also insert such a requirement, which is a totally new requirement, of course, in cases like that of a European arrest warrant and other pieces of legislation requiring the surrendering of a person. Well, excuse me for this, for taking too much time. Now it's a pleasure to give the floor to Mrs. Margherita Cassano, who is Vice President of our Corte di Cassazione, and welcome to this, virtually welcome to this panel. I didn't receive the topic of your presentation, but I think that you are going to speak of the case law and the problem that the Corte di Cassazione encounters towards this regulations and directive and legislation. And you have the floor.
Thank you to University of Bologna for this important research and for the opportunity I had some problem of connection. Thanks to everybody for this important research and for the opportunity to take part to this final conference. The cognitive, organizational, professional, and institutional potential opened up by the digital technology and artificial intelligence is undoubted. It poses, however, many complex questions concerning the delicate balance between the use of technological and computational tools, which are totally new for all stakeholders, the bench, the bar, the administrative staff, the quality of the services offered thanks to them, and the respect for the fundamental safeguards of individuals. First point, uses technology to streamline institutional action. The use of new technologies can certainly make the performance of many daily activities at office more effective and prompt, both by judges and the administrative staff. Increase the effectiveness of the service render and its ability to respond to citizens' needs and demands, with a consequent increase in the effectiveness and prestige of the judiciary and in the strengthening of the rule of law. Analyze the relationships between resources invested and the results achieved, curb resources and public expenditure. Second point, the use of technology to ensure access and transparency regarding information and decision making. Technology can represent a mechanism for reducing the cost of access to information concerning the decision-making process. Technology can therefore help transparency and legitimation by activating form of public accountability that mean accounting for one's action, making decisions understandable to those who are not insiders. All institutions, including the judiciary, must be transparent and accountable to citizens. This is established by the rules governing the right of access to information pertaining to the public administration and the rules safeguarding the right to a fair trial. It's not enough, however, to enshrine these rights. They must be translated into concrete actions which ensure that non-expert citizens can understand and decide whether to take legal action to protect their rights, and that the actions of judges are subject to supervision and review. In my opinion, it's important that citizens are guaranteed the possibility to know and discuss not only the content of decision as a result of the development of judicial proceeding, but also the logical paths followed for rendering judgments. In this regard, we have to ask ourselves where citizens, although they have access to documents posted online or to the consultation of case law databases, are really able to understand those documents independently without the assistance of professionals and to understand any criticality of the decision-making process. Third point, optimization of internal decision-making process in the administration of justice. Internal decision-making process can be eased by a high degree of specialization and also by the creation of databases of case law accessible by the various judicial stakeholders. Their creation allows for more effective coordination, reduces the time needed to exchange or pass on information and documents, and increases the overall efficiency and services. Fourth point, efficiency and guarantees. The efficiency of the organization cannot, however, be conceived purely in quantitative terms, and therefore be correlated to the number of decisions rendered by judicial offices in a given period of time. Such a conclusion will not follow the constitutional principle with a combines reasonable duration with respect for due process. The due process principle requires the necessary in-depth examination, the weighing of all the elements submitted by the parties to judicial proceeding, to whom actually and effective cross-examination is to be guaranteed, along with the formation, acquisition, and evaluation of evidence, and the reasoning complying with the legislation. Pursuant to a modern idea of organization, therefore, efficiency can never be to the detriment of the safeguards concerning fair trial, starting from the effectiveness of the right of defense and the method of cross-examination as pre-requirement for assuring a decision based on careful examination of all elements submitted by the parties to judicial proceeding, a complete and rational response to all their requests and consideration that contributes to development of well-considered interpretation choices, complying with the legislative criteria and supported by solid logical arguments. Fifth point, technology used for cooperation between judicial offices. A modern idea of judicial service requires judges to overcome narrow and individualistic vision, limited to the dimensions of the offices where they work, and to establish institutional forms of cooperation and dialogue with the other offices involved in judicial proceeding, also with a view to adopting the organizational measures necessary to resolve critical issues that may adversely affect the overall effectiveness of judicial action. It's therefore necessary that judges interpret their role in a dynamic way, paying attention to the outcome of judicial proceeding in the following judicial instances in order not to repeat errors that affect the quality and timing of judicial response. Judges should also focus on their training about the development in case law and the legal literature. This is the only way, in my opinion, to lay the foundation of predictability and stability of case law that can safeguard the principle of equality of all citizens before the law and effectiveness in the right of defense. Critical approach, training, and a shared database thus turn out as a pillars of a management system of the new phenomenon, the algorithmic justice, so that this technological progress is not a promise of coexistence between human beings without intermediaries and without law, forgetting that man is a political animal. Sixth point, the information shared thanks to technology should concern the percentage of decision upholding or reversing a previous judicial measures at the following judicial instance. This is a significant macro datum that should be known in every office and should stimulate and guide reflection in every office in order to improve quality of the service. 7 point, technology and quality of jurisdiction. The integration into the system of increasingly intelligent technologies can be great help in examining case law. Today, this enormous instrument is largely used only to settle individual dispute. Actually, the value that a judicial decision has or can have is much wider in terms of the principle it sets out, the case it resolves, and the reasoning and explanation it contains. Renew attention to the reason of judicial decision and to the principle of exhaustiveness, completeness of arguments, clarity, and conciseness that must characterize them helps to give concrete effect at the following principle. It makes the right of defense effective, since the smooth reconstruction of the ratio decidendi and the concise illustration of the reasoning passages of the decision is the activity of the defense counsel in identifying the essential aspect of the case and the correct contentious start of trials. It implements the principle of due process, central on the adversarial method and the right to evidence, since the reasons are needed to substantiate the assessment of the evidence taken at the initiative of the parties to the judicial proceeding. It guarantees the reasonable duration of trials, understood as an ordered series of coordinated acts, each of which is conditioned by those that preceded it and is conditional in turn on those that follow. Measures that are coherently structured with respect of their function support the efficiency of service, contribute to the proper functioning of judicial system, help to save time, energy, and available resources. Complete but concise reasons for judicial decision, which are compliant with evidence, able to respond to all the parties' questions and expressed in a clear language, helps parties to formulate specific ground for their appeals. Moreover, it can strengthen the dialogue between courts of first and second instance and courts dealing with the question of law, the use of correct interpretive methods, and where individual exegetic choice as propulsive factors of the living law that is in principle predictable and which in turn is instrumental to guarantee the effectiveness of the right of defense and the quality of all citizens before the law. Finally, the rationality of the structure of judgments and the clarity of the language can spur research and in-depth study through case law databases, stimulating attention to legal informant technology. I had two important experiences. During my term as president of Court of Appeal of Florence, I promoted a self-training workshop of the reasoning for measures involving all the district judges. The working group, after an intense collective activity, shared guidelines aimed at facilitating the reading of judicial measures, both by judicial stakeholders and by the scientific community, and more general by society. I launched a similar experience in 2021 at the Italian Supreme Court of Cassation. The aim of this work is to share the structure and the logical organization of the decision in order to ease the reading and understanding of the principle of law set out in the judgments and of the concrete cases to which they refer. It also seeks to encourage reflection on the legal language that can be an objective obstacle to dialogue between judicial institutions and citizens. Thank you.
See how our Corte di Cassazione is really engaged in obtaining a better and better quality of judgments and also deep judgments. Not only you are, I think, a record in Europe as a quantity of judgments delivered per year, but also the quality is impressive, not only the quantity. So congratulations for that. And thank you again for your speech. We have now someone finally speaking of artificial intelligence. After such introduction, such a very interesting introduction of Professor Caianiello, we have now Mr. Federico Cappelletti, who is in charge of the Observatory of European Matters in the penal chambers, if I understand well. And Mr. Cappelletti is going to speak of defense perspective on transnational criminal proceedings and artificial intelligence. You have the floor, Mr. Cappelletti.
Thank you, Professor Rossi. Esteemed academics, judges, colleagues, and participants, it is a privilege for me to take part in this session, so I would like to thank the University of Bologna for inviting me. I would also like to thank the organizing committee, Professor Sartor, and my dear friends, Professors Michele Caianiello and Vittorio Manes, and their staff for making this event possible. I am honored to participate today on behalf of the Unione delle Camere Penali Italiane, the Union of the Italian Criminal Chambers, of which I am in charge of its Europe Observatory. And it's an association that has been founded 40 years ago in 1982, counting 131 local associations and more of 8,000 members all lawyers practicing in criminal matters. It promotes the knowledge, practical implementation, and protection of the fundamental values of criminal law and fair and equitable criminal trials by developing studies and implementing cultural and political initiatives aimed at improving the criminal justice system, and also with reference to the implementation and the transposition, the proper transposition in Italy of the relevant EU legislation. The range of action of its Europe Observatory includes networking with other European associations and organizations of lawyers, and the collaboration with European and international organizations. Lobbying, in particular, on the decision-making process of the European Union in the field of justice is also an important part of its work. As defense lawyer, we firmly believe that we are, to all the intents and purposes, human rights defenders because of the activity we carry out every day in the courtrooms and in the civil society, both as individuals and in associations in which we are active. For this reason, we promote the culture of the defense of fundamental rights, on the one hand, through workshops and training courses aimed at forging an European and international criminal lawyer, on the other hand, through the dialogue with international institutions. Moving on to the theme of this session, and more broadly to the headline of this final conference of the CrossJustice project, I would like to share some thoughts and experiences on the defense perspective on cross-border proceedings and artificial intelligence. Empowering defense rights, first of all, implies an efficient and, above all, effective defense. A strong defense is a vital component of a fair trial. As we all know, the European Court of Human Rights often recalls that the Convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. Therefore, the mere appointment of a lawyer does not ensure effective assistance if he or she shirks his or her duties, including those of competence and professional updating. And when it comes to transnational criminal proceedings in the EU, it is not enough for us lawyers to be familiar with the national criminal procedure, but we must necessarily deal with that of the other member states and with the implementation and transposition of the relevant EU law into their own legal systems. It is a matter of fact, indeed, that procedural safeguards for persons suspected or accused of a crime, also after the introduction of the EU directives derived from the Stockholm Programme, and the rights of defense as well, are regulated in many different ways among member states. This fragmentation of the legal framework undermines mutual trust and the achievement of a genuine area of freedom, security, and justice. We are aware, in fact, that in some member states, the participation of the accused or his lawyer in the pretrial proceedings is limited, even if it is then mitigated by procedural rules. In other member states, on the other hand, extensive use of pretrial evidence is allowed, but also the participation of the defense in gathering it. It is precisely the lack of a common and certain minimum standard on the active participation of the defense lawyers in cross-border proceedings and in EPPO investigations that leads to a different and arbitrary level of protection of a right that should instead be granted equally in all the member states. This won't be the case as long as in EU cross-border proceedings it is left essentially to the prosecutor's office to adjust the active participation of the lawyers and thus the right of the accused according to the chosen jurisdiction, which undoubtedly meets the need for investigative efficiency, but also greatly limits the fundamental rights of the accused. So how can the defense in cross-border proceedings can be truly effective? As I had the opportunity of pointing out to the expert of the Council of the European Union during the meeting held in Rome in the month of September last year, in the 9th round of mutual evaluations with reference to the framework decisions complementary or substitutive to the European arrest warrant, where I was invited to attend by the Italian Ministry of Justice, the right to dual or multiple legal assistance in cross-border cases and legal aid as well that are currently only provided for the European arrest warrant should be extended to all the mechanisms of judicial cooperation. It should be noted, inter alia, that very often in cross-border cases, clients' funds are frozen and there are no common rules or no rules at all on whether money from frozen funds can be used to pay lawyers' fees. And this, of course, inevitably affects an effective defense given the inequality of resources with the public prosecution. It is also essential that provisions are put in place to counterbalance the additional difficulties faced by the defense in the context of cross-border cases due to the legal fragmentation and geographical, cultural, and language barriers, so that in any event, it should be not less effective than in domestic cases. Furthermore, I believe that an effective legal assistance cannot be achieved without requiring lawyers in the member states to have highly specialized training and proficiency of at least one of the working language of the European institution in order to be able to act in cross-border cases. Unlike the prosecution that can rely on institutions specifically conceived to work on transnational cases as Eurojust or Europol with shared databases, the defense has no coordination at the European level. A good practice among lawyers who normally deal with judicial cooperation in criminal matters is to benefit from networks of European lawyers, such as the European Criminal Bar Association, of which the Union of the Italian Criminal Chambers is a collective member. Through its web tool called Find a Lawyer, it is also possible to get in touch with colleagues from all around Europe and to choose them according to the city where they practice and the language they speak. Although the experience of highly specialized colleagues in one or more of the member states involved in cross-border cases is in many ways irreplaceable, an effective defense must still be able to find its way through the relevant national legislations. And this is where artificial intelligence comes in. On this specific issue, we are all aware about the concerns expressed by the European Parliament in its resolution of 6th of October 2021 on artificial intelligence in criminal law and its use by police and judicial authorities in criminal matters in light of the number of potentially high risks for the protection of fundamental rights of individuals that the use of the artificial intelligence in law enforcement entails, such as an opaque decision-making process, different types of discrimination and errors, risks to privacy and data protection, freedom of expression and information, the presumption of innocence, the right to an effective remedy and fair trial, and risks to freedom and security of individuals. But there is also a bright side of the moon. The use of technology for a better implementation of judicial cooperation instruments in criminal matters, as well as fundamental rights in the European Union, is at the heart of many IT tools available today for legal practitioners. For example, among the former are those that can be found on the website of the European Judicial Network. Among the latter are those available on the European e-Justice portal, such as the Fundamental Rights Interactive Tool and the Charter Click Checklist, which allows users to check whether a specific case falls within the scope of the Charter. It should be noted that many of these IT tools have been deservedly funded by the European Union in order to promote the consolidation of the area of freedom, justice, and security, as in the case of the cross-border project platforms. What was in fact needed was an IT tool that would allow legal actors to identify which legislation and thus which procedural rights are available to persons suspected or accused of a crime in specific cases, overcoming language barriers and specificities of different national legal systems. This is why the platform developed by CrossJustice project is an innovative and sustainable tool that will definitely support legal practitioners and in particular lawyers to be more and more qualified to perform their role as guarantors of the effectiveness of people's rights. To conclude, I would like to express my sincere appreciation to the coordinators and partners for having conceived this project, which I hope will be as soon as possible extended to other instruments of judicial cooperation in criminal matters, as well as for their attention and foresight to involve lawyers as key players in the jurisdiction in this path aimed at improving the standard of protection of fundamental rights in the European Union context through the knowledge and the implementation of the instruments taken into account. A path in which the Union of the Italian Criminal Chambers and its Europe Observatory will always be willing to offer their contribution. Thank you.
Thank you very much. You rightly pointed out the fact that artificial intelligence looks like a two-edged sword. And I must confess that the first time Michele spoke me about artificial intelligence, I said I was quite scared because we are accustomed to think that artificial intelligence is something that we must be aware from. But I see that it can be this platform I connected yesterday in order to try to understand what we are speaking about, and I see that after all it is just an intelligent database. I mean, such tools are very useful and are not now we call it artificial intelligence. Maybe we could call them algorithms, but well, I'm not an expert on these topics. So thank you again for your presentation. And we have now Mr. Filippo Spiezia, who is Deputy Chief of Eurojust and was a national anti-mafia prosecutor, so a judge with a very long rich experience in criminal law. I didn't receive the title of your presentation, but I guess that you are going to speak of the Eurojust profiles of these topics. So welcome, Mr. Spiezian, and you have the floor.
Thank you very much, Madam Chair, Professor Rossi. I hope that you can hear me. Very good morning to... Okay, thank you. Thank you for giving me the floor, and thank you to Professor Caianello, Professor Manes, and all the organizers for inviting me to this very, very interesting meeting today. Also, would like to present my apologies if I was not able to reach you in Bologna as I would have wished because of concurrent meetings I should attend also this morning for operational purposes. So I will present some considerations in relation to your research and your topic, which in my opinion are very crucial. Yes, you're right. I will try to address some of the topics that you are considering in your meeting from the Eurojust perspective. I'm currently covering the position of Italian national member at Eurojust, and we have recently published the annual report of Eurojust. I assume that all the participants know very well what Eurojust is about. Is the European judicial body entitled to support and to reinforce the coordination of investigation for cross-border crimes and in the matter of international terrorism. And from our practice, I can see very clearly how much important are the topics that you are addressing today in this conference. Just to mention some figures concerning the operational outcomes of 2021. We have dealt with more than 10,000 operational cases only in 2021, concerning the position of 85,000 suspects. We have dealt with more than 570 European arrest warrant and with 4,319 cases of European investigation orders, only in 2021, without mentioning the operational experience of joint investigation team and other activities related to our main mission. So I can say that the Eurojust overview of our operational cases can confirm one of the main conclusions of your research, that the level of the implementation of fundamental rights and the directive concerning the procedural rights of suspects is very uneven at EU level in EU member states. The situation is very dishomogeneous due to several reasons that you have properly addressed in your research. So I share with you the conclusion of your study that this homogeneous situation is depending, first of all, on the quality of the directive in itself in relation to specific terminologies or legal concepts that are included in the directive. You mentioned in your research, Professor, in absentia, the concept of effective remedy, the concept of essential or non-essential document to be translated. So you see that we have sometimes in the directives some very vague concepts which allow a different interpretation and a different implementation when it comes to the implementation in the EU member states. Then we have also the problem of the diverging transposition in EU member states concerning specific formulations. And I completely share what I saw in one of the main chapter of your research that this process of implementation is strongly affected by the diversity of the legal culture in our national system. I see clearly from our observatory how the difference, for example, between the adversary trial and the inquisitory trial affect the way we apply, the way we interpret it, the way we implement these directives. One example, one clear example for me is the presence of a defense lawyer when we talk about questioning and interrogation in front of the police, where the system where the previous statements during the investigation cannot be used in front of the judge, foreseen a completely different solution in the system where all the materials, all the statements made before the court, before the police, can be used also for the judgment. I come from a very recent example. 3 days ago, I chaired a coordination meeting concerning a joint investigation team between Italy and Romania, a case which was also presented to the press for a violation to EU funds, where we see surprisingly that all the testimonies and all the information collected by the Romanian police cannot be transformed in an oral witness in front of the Italian judge, because there is a clear prohibition from the Romanian legal system to admit such testimony. So we invented, from Eurojust perspective, and I will come to the experience of Eurojust, some creative solution in order to overcome such legal difficulties. But it is a fact that when we see from a general perspective the level of implementation of fundamental rights, of the procedural rights of the suspect, we are very far from an acceptable standard at EU level. So from my perspective, from my point of view, the way we assess the EU area of legal, of the EU freedom, security, and justice is very far from reaching a very mature state of implementation. This triggered the question how we can enhance the system. This aspect for me is even more clear when we compare the state of play of procedural rights in respect to investigative measures, because sometimes the rules governing investigative measures by definition are considered in their cross-border dimensions, while procedural rights are more tuned on the national dimension, on the domestic dimensions. So in principle, sometimes we have more precise regulation concerning cross-border investigative measures in respect to the question of procedural rights. So I very easily recognize the big value of your research. Try to find, thanks to the automatic analysis through the intelligence, in artificial intelligence, this semantic value of the discrepancies in the state of play of the implementation of the directive on procedural rights. Although, in my opinion, the approach should be always to integrate the intelligent analysis with the human analysis. I don't think that in this field we can completely put aside the assessment from the jurist, because simply because, for example, we need to take into account the case law, the jurisprudence at national level, which is something that cannot be necessarily be considered when we proceed with in intelligent analysis. So the question is how we can enhance the system. You have indicated in your research different models. We have the top-down approach, means from the directive to the implementation at the national level, with all the limitations that we know and also other brilliant speakers have already explained. But we have also the opposite approach from the bottom up to the Court of Justice. And we heard from our constitutional judge how this process suffer limitations also in terms of familiarity of defense lawyers and I would say in general terms practitioners in relation to this specific topic. So one important tool indeed is the judicial cooperation procedures as an horizontal tool to enhance the system, because it's undoubtedly that when we have to apply judicial cooperation instruments, then we can have the reaction from the executing authority, which could refuse the implementation of some requests if the requests are not compliant with the fundamental rights, are not compliant with some procedural rights in their member states, in the executing member states. And at Eurojust, we can account, I would say, hundreds of such examples. For example, in relation to the implementation of the European Investigation Order, where we see clearly a lack of respect of the principle of proportionality in requesting some specific measure. And Eurojust is, I would say, on a daily basis requested by the executing authority to support the dialogue with the issuing authority in order to reconsider the request, in order to specify or to reduce the scope of the initial request in order to comply with some fundamental rights and with procedural guarantees. And we have clear a legal basis in order to do that, because I see that there is a clear references in Article 9 of the European Investigation Order Directive, because the executing authority shall comply with the formalities and procedure expressly indicated by the issuing authority when are not in contrast with fundamental principle of law of the executing state. So there is always time, always space in order to give room to these aspects. But I fully share the position expressed by Avvocato Cappelletti in order in relation to the limit of such system, because this system rely on the, I would say, familiarities of practitioners, on the sensibility of the interpreters. We need something different. We need a system which is structured in a way where the implementation of these fundamental rights, of the implementation of these procedural rights are applied. So I think that after 20 years, more than 20 years of the creation of this EU area of security, freedom, security, justice, times has come to reconsider the system. I think that in this respect, I don't see any opposition between the efficiency of the system and the respect of fundamental rights, the respect of procedural guarantees. This is also, I would say, the mantra of Eurojust. The efficiency of our action goes hand in hand also with respect of fundamental rights. But how we can, looking forward to the future, how we can improve the system. I'm just concluding my intervention, say that I think that as far as these topics, we should question ourselves and the EU legislator if we should not reconsider the legal basis for the implementation of fundamental rights and procedural guarantees for the suspects, because the system of directive leave too much interpretation, too much discretionality to the interpretation of national system. Probably when it comes to the rights of the accused person, and I would also include the topic of the admissibility of the evidence. Probably these two topics should be find a different legal basis, regulation instead of directive. What I'm saying, what I'm advocating is a European system where this fundamental aspect, admissibility of evidence and fundamental rights, are governed by different legal basis through regulation instead of a directive. This could enhance the system overall in all the components, not only from the perspective of defense lawyers, but also from the perspective of prosecutors. I don't see opposition in this. I think that the system should be seen as a whole in a comprehensive way. Just to conclude, I would like to invite the organizer of this meeting to share the final result, the main relevant documents with Eurojust, because I think that the topics that you have addressed in your research are vital for our daily work. And I invite you, please, to consider to share the conclusion of your meeting with our agency, because this could be a very important moment also for Eurojust College members, and will be my care, my duty also to present the result of this meeting to my colleagues. Thank you very much for your attention.
As you rightly pointed out, harmonization can be bottom-up or top-down. Top-down harmonization is in a field that is relatively new, is not completed still. And you know there are states with opting out still, opting in, opting out, Ireland, Denmark. The freedom, security and justice area is not so far developed and is not so far developed as the rest of the area of EU law. And probably we need more legislation, of course, top down, but also the practice of the daily practice of judges is very important, and can, with the good networking and also with the help of new horizontal tools, really determine a sort of bottom-up harmonization, as you pointed out. So I totally agree with you, and with just a little, I mean, precision that where there is an harmonization imposing, for instance, the European arrest warrant, a judge to deliver, this is a serious, I mean, obligation, and we cannot fragment it in many different subsystems according to the national systems of guarantees. This is the only remark, but generally speaking, I very much agree with you. So we have now maybe some minutes for questions, and I dare say to shy students that given the composition of the panels, you also may raise questions in Italian if you prefer. Yes? Yes, you should come and speak in the micro. If not, who is at distance can hear you. Yes, please.
Okay. 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 I'm Emanuele Gatto. I'm a PhD in criminal procedural law, and I have a question for Dr. Ceccarelli. Also based on what said Dr. Spezia, and on the basis of the Apple regulation, in particular Article 26 and 37, the vague criterion, general interest of the justice and sufficiently justified grounds, which allow the Apple to bring the case to the prosecution in a different member state, and the lack of involved the defense of the choice of the competent court, and on which both procedural and substantial rules depend, we are concerned about the risk that right of the defense at the initial stage and the most right-sensitive stage of the proceeding may be undermined. Which is your personal opinion on this type? Thank you.
Yeah, thanks. Very interesting question, actually. As I said, this is 26.4, basically, is one of the hot topics that Association of Defense Councils put forward, and we understand that, right? That's a concern and fear of forum shopping, wherever you go, right? It's a problem. There's no doubt about that. There's criteria in the regulation. There's two main criteria, which is the bulk of the offenses or where most of the offenses have been committed, and there's subsidiary criteria. So of course we follow that. There is no doubt about this. Anyway, you have to consider that it is true that the defense is not involved in that choice. It's a choice that, let's say, is focusing on the investigative phase. And actually, even allocation and reallocations are terms that are used in the regulation already at the moment when the case is registered. You know, when you receive the criminal report, the initial criminal report, and nobody knows about that because you have to start investigation. And of course, investigation by their own nature are characterized by confidentiality, right? Because search, interceptions, all this kind of investigative activities are confidential, and so you cannot involve the defense. At that stage, there is no doubt about that. So there is a moment when there is disclosure. There is a moment when there is disclosure, and we are really open, and we also told defense counsels not to fear requests for reallocation if they think that we made a mistake. There is no doubt. Also, I have to say that the regulation here introduces a procedural tool. I think this is one of the few cases where the regulation really says explicitly that the decision to allocate a case to a certain member state can be challenged by the parties at the latest at the trial stage. It is explicit. For example, the decision on whether the PPO exercise the competence or the national prosecutor, well, that cannot be challenged. Anyway, it's a prosecution. That doesn't involve the rights of the parties. But this does involve the right of the parties. There's no doubt. So the regulation introduces a system which, being a regulation, is applicable immediately in all the member states to challenge these decisions. But we have to make this decision at a certain stage when the investigation is most probably confidential. Also, talking to the Association of the Defense Counsel, we told them that if we have to make a decision on reallocation when disclosure is already there is no reason why we should not involve or ask for their opinion. It's not in the regulation, but it's not forbidden. So we are very aware of the problems that this kind of situation creates. Also, you have to consider that, well, nobody really thinks about that, but the problem of jurisdiction and which member state should prosecute when more than one member state has jurisdiction. Okay, because if only one member state has jurisdiction, no problem, right? But here, more than one member state has jurisdiction, and you have to decide who has to prosecute. Article 21 of the Convention of the Council of Europe of 1959 already foresees this kind of mechanism of transfer of proceeding. Eurojust has been dealing with this, Filippo can confirm that, for a long time. Transfer of proceeding from one member state to the other, actually not from one member state, that's the Council of Europe, so it's more countries there. And when more than one has jurisdiction, so that's an old problem to a certain extent. Of course, here within the PPO, it comes to surface as something major, but we have to work and see how it goes.
Any further question? It doesn't seem the case. So let me thank all the speakers of this panel again on behalf of what is still my university. It was very, very interesting. Thank you very much again to everybody. We have now, I think, a coffee break of 15 minutes. So thank you again to our panelists.
Perhaps we can start. Can you hear me? Okay, now we can start the second panel of this morning. But before starting, I would just say a few words to thank Professor Michele Caianiello and all the organizers for the invitation to this conference, the final conference of the CrossJustice project. It's really a pleasure and a privilege to be here with so much colleagues and friends and to listen to the results of this pioneeristic project. To introduce this second panel, it is important to remark that in the first one, we focus the procedural rights issue from the institutional perspective. We listen to many public actors of the criminal justice system and, of course, of the mechanism of the international cooperation in criminal matters, with the exception, of course, of Mr. Cappelletti, who is a defense lawyer, so he is, of course, a private subject. Now we have to move to change the perspective, focusing our attention to the passive subject of the criminal proceeding, the accused person or the suspect, and to procedural rights that we should grant to that person in the domestic criminal proceeding, but also in the transnational criminal proceeding. And when I say transnational criminal proceeding, of course, I make reference to proceeding involving the use of mechanism of international cooperation in criminal matters, judicial cooperation in criminal matters in the European Union framework, of course, but we could also speak about other instruments applied outside of the European Union, but we are focused on the European Union, of course. I make reference, of course, it was just to remember to the several fair trial rights enshrined in the directives adopted under the Stockholm program, but we could also remember the presumption of innocence as promoted by the directive of 2016. As you know, especially this one, I think could be interesting for us. As you know, a recent report of the European Commission points out that in some member states, this directive has been implemented not in the proper way. And a number of infringement procedure, as I know 7, if I'm not wrong, have been initiated against some member states. So in the light of these developments, I'm really interested in listening to the experience of other member states. We are here for national experts of different states, Poland, Croatia, France, and Spain. So I think we will speak about this. But now we can move to the first speaker. And before starting, I remember them to all the speakers around this table that due to time limits, I ask them to try to stick to time limits, 20 minutes for each person. The first speaker is Professor Karolina Kremenc, University of Wrocław in Poland. Karolina is currently the head of the Digital Justice Center of the University of Wrocław, which is the right pronunciation, Wrocław in Poland. She has also experience as associate prosecutor, and he has great experience in research, in comparative and international criminal procedure, and on the impact of technological tools on the criminal justice process. Carolina, you have the floor. Thank you.
Thank you very much for the introduction. The technology, right? Thank you so much for the invitation for the conference. I am delighted to say that I'm a part of the Polish team that we were working together on this project. The CrossJustice is one of the great adventures that we had at the University of Wrocław to focus on the implementation of the EU directives and the impact of new technologies on the criminal justice systems. So I would like to express on behalf of the whole Polish team that I had the privilege and honor to lead throughout those 2.5 years. I would like to thank Michele Caianiello, Giovanni Sartor, and most of all, Giulia Lasagni and Giuseppe Contisa for inviting us, and we are looking forward to work with you in the future. This is a very difficult moment also for us in Poland. I have to say that with the invasion of Ukraine by Russia, it's really hard for me to provide the presentation today, but I hope that you will be understanding if my focus will not be total. Okay, starting with some general explanation on what I will be focusing today. The title of the presentation already shows you that the Polish perspective on the implementation of EU directives is not very optimistic. The downfall, the setback, the backslide, as we have established during our research, is, I would say that this is a fact. So throughout my presentation, I will be trying to show you how Polish system, being maybe not fully in compliance at the very beginning of the implementation process with the first directives, now is shifting a little bit backwards with the transposition process. Throughout our research, we discovered that there are several structural deficiencies, also incidental deficiencies, as we have called them. The incidental deficiencies that I will refer very briefly at the very end of my presentation today are focused on those small provisions that are throughout the Code of Criminal Procedure in Poland and also other legal acts, that if we change a little bit the system, or a little bit those provisions, we could say that the transposition of EU directives into the Polish system may be in compliance, fully in compliance. However, due to what we call structural deficiencies, the implementation cannot be called at any stage as, in case of all directives, as full. There is, of course, a big difference among the implementation process regarding certain directives. They are different. The diversity in the level of the transposition, whether it's partial or not, is I would say that is very very different. So first, I will focus a little bit more on the first structural deficiency that is more like, should be treated more like a translation problem. And due to the strict rules on the time limits, I will not focus too much on I will not focus at all on the second issue, which refers to lack of protection for the vulnerable suspect in general in Polish system, with some just few exceptions. And I will move to something that we decided that we will be focusing today on the setback in the quality of the transposition process. Not only the process is being, not only the directives are not being transposed properly, but we also see how the system deteriorates in that regard. So the first issue that I would like to point out to you is the improper interpretation of the term suspect as used in the EU directives from the Polish perspective. This is, someone could say that this is just a mistake or a translational interpretation problem. The direct translation, as you would see in every single dictionary in Poland, or well, Polish English dictionary, every single dictionary would call suspect podejrzany, which causes certain problems because the understanding on the level of EU directives of the term is so different from what we understand, maybe not so different, but is different enough to change the situation of a person during the early stage of criminal process very much. It demands few words of explanation. When we are talking in Poland about podejrzany, this is the person that has been facing the formal charges. So this is the moment where we are calling a person in, the police or the prosecutor calls the person in, present the charges, asks the person what the person believes, whether the person is guilty or not, writes the protocol, and also interrogates this person, which is from that moment called podejrzany. If we directly translate it once again into the English language, this is a suspect. Only from this very moment, the suspect, podejrzany, gets all the rights that are attached to that person. Right to remain silent, right not to incriminate oneself, right to legal aid, right to defense counsel, right to defend oneself. So this is the full package that generally EU directives and all other international instruments attach to suspect. However, before the person is formally charged with a crime, we are looking at this person as someone else. We are calling this person osoba podejrzana, which could be translated easily to English language as a suspected person, before a person is formally charged in. Despite the fact that the investigation can be already focusing on that person at this very moment, so it can be very early in the process of criminal investigation, or also later if the police or prosecutor did not decide yet to present the charges against this person, osoba podejrzana, suspected person, is not covered with the same rights, or in fact is treated just like a witness throughout the early stage of criminal process. And of course, if the person is later on presented with those charges, the person is called podejrzany, suspect, and the charges and all the rights are being attached to that person. So from this, you can already see that the person that is called osoba podejrzana, even though the criminal investigation is focused on that person, is deprived of the rights of the person that is called suspect in the context of all EU directives. This is causing certain problems for accepting the idea that EU directives are transposed effectively in Polish system, because we are depriving this person at the very early stage of criminal process against what EU directives demand from us, from all the rights that are necessary. And of course, we can discuss that during the arrest, when the person, osoba podejrzana, suspected person, is being arrested, some rights do attach to that person. Yet still, those are not the same. This is not the same package of rights that EU directives on all levels, in all situations, attach to that person. The reason why we have this strange formal procedure of attaching charges to the person is connected with the idea that the person learns at that point what are exactly the charges. But again, it destroys the whole idea that the person might be not yet presented with charges and still already being a suspect. Therefore, this misunderstanding, as some call it, between EU directives and Polish law, who is a suspect, exists. This is not to say that the Polish government is not aware, that the Polish government is mistaken. Several times, Polish ombudsmen, NGOs, Helsinki Foundation for Human Rights in Poland have flagged, put red flag on in different opinions and letters addressed to the Ministry of Justice, saying that this is a difficult situation and we are not covering. The directives are not transposed for that suspected person at the very early stage of criminal process. Despite that, the Polish government decided to disregard, claiming that, well, if we are talking about suspect, which is podejrzany, we have all the necessary rights being attached to that person. Therefore, for that reason, we believe in our team, but this is also a view of other scholars in Poland, we believe that for that single reason, we cannot call EU directives as being transposed, implemented in the Polish system at this part of the criminal process to the person that we call not yet a podejrzany, but still this person is a suspect in the meaning of the EU directives. You might wonder whether it affects certain rights that we provide in the EU directives. And we stand on the position that probably every single of those directives, 6 directives that we were researching, is affected to the huge extent by the lack of acceptance that the suspect is someone else in Polish law than the person that we are talking about in the EU directives. So saying that, I'm just moving quickly to the next issue, which is the central point of my today's presentation. And I would like to start with discussing that there is a that there is a variety of level of implementation of EU directives with regard to those that we are seeing. Those two earliest directives are considered, putting aside for a moment the discussion on the translation of the word suspect, are generally implemented. Of course, there are some minor, or as we call it, incidental problems with the implementation. So, for example, with regard to one of the directives, there is an absence of procedure of asserting the capacity of the suspect or accused person to speak and understand the language of proceeding, as well as in other situations, or there's the lack of specific measures allowing the quality of interpretation or translation to be challenged. So there are some minor flaws also in the implementation of the two first directives. But we have to remember that the deadline for the implementation of those was just before the change of the government in 2015. And therefore, the former government was still working hard on accepting the idea of properly implementing the EU directives. With regard to the EU Directive 2016/343, we can say that, in our opinion, this is only a partial implementation. So there are some, again, problems with regard to the translation of the word suspect into the Polish language. However, also there are some challenges concerning the contact in between the lawyer and the client before the first interrogation. For example, there is a problem with failure of the attorney not appearing during interrogation, not being a problem for still conducting the interrogation in Poland. The directives, the core rights of the 2013/48, 2016/99 are not transposed to the Polish system. There are some provisions that we consider as being transposed, but generally the core rights have serious problems with that. And finally, the newest, I would say, the newest EU directive concerning children or minors during criminal process, we believe that this EU directive was not even transposed. What are the reasons? And you can see that we are going lowering down the level of transposition. And if you're more interested, there is the full report available on the website of the CrossJustice, and of course in the tables we explain each provision one after the other, how the situation looks for this. So what are the reasons for that? And of course, we can set a political situation in Poland, and especially feelings of the current Polish government towards the EU standards and protection of Polish citizens or people under the criminal investigation with regard to the EU directives. Of course, for the past 6 years, the Polish Ombudsman again and NGOs have addressed the Minister of Justice and Prime Minister not only with regard to the translational problems, but also with regard to the need to update Polish system to the level that is expected. These notifications have been continuously ignored, and we do not see any change in that matter. So the stage in which we are looking at this right now is something that I guess the government, the authorities got used to. Also, the big problem in our research that we were holding with regard to the EU directives and the level of implementation of them in Poland, we encountered serious problems with identifying which certain provisions in Polish Code of Criminal Procedure are reflecting the provisions of the EU directive. At the very beginning, with regard to the first two directives, the government at least was establishing, was providing in the justification to the bills information which provision is implementing which right. Later on, when the government did try to implement other directives, there was just a general information in the Polish Code of Criminal Procedure saying we are implementing this directive. And very often the Polish government, in official notifications to the parliament members asking whether this directive and pointing out that this directive is not implemented, the answer was our system was already in compliance with the standard provided by the EU directive even before the EU directive was presented to be implemented. So there is no, from the side of the Polish government, there is no information on how the procedure went and where are the provisions that we should be talking about. So for us, it is not, however, even clear throughout which provisions in the code the process was accomplished. With regard to the last directive, the directive on children, we are seeing the problem that neither the Code of Criminal Procedure nor any bill that is currently proceeded through the Parliament is bringing any information on that. And finally, we discovered throughout the process of our research throughout those 2 years that the system is even going backwards. With regard to the first directive, the second directive, 2012-13, the right of a detained person to access the case file at the beginning was implemented in a proper way, and the standard was established by us as met. However, in 2016, so just a few months after the government has changed, the government introduced new regulations that put a significant restrictions on access to case file by a suspect, and will also introduce the trials in absentia to the broader level. So this is a problem that we have encountered, and all this together, unfortunately, adds up to a sad picture of gradual distancing of Poland from EU standards in criminal matters. So, what are the conclusions? And they are, as I said, not very optimistic. The general approach that we accepted throughout our research is that the transposition of EU directives concerning rights of suspects and accused persons in criminal proceedings into Polish law is far from satisfactory. Not only the translational problems that I discussed a moment ago, but also with regard to the transposition of certain provisions that are available in the directives. And of course, the level of implementation is different. As I said, those that were introduced at the very beginning are much better implemented when we compare them to those who are implemented later. We've seen in the past year the attempts, we can call it at least an attempt, to properly implement the directive on the child. There is a bill that was passed through the government, and we can see this on the website, that such bill from July 2021 is available. However, we have seen half of a year without any activity to that regard. And of course, the justification to that bill, and again, the bill was prepared by the government. So in the justification, we can find arguments that we have to bring this project to the Parliament because we are not in compliance yet with the EU directive on the rights of children. However, no activity to that matter is being seen. Certainly, the most important structural problem is the insufficient protection of the suspect's rights at the very early stage of criminal investigation. However, we are not seeing this to be discussed at all on the governmental or parliamentary level. Whether we have any hopes for changes in that context of the crisis of the rule of law, I would say that they are not very high. We can see this not only with relation to the implementation of EU directives, we see this also with regard to the problems with protection of the rule of law in general, or respect for the rule of law in Poland. The last year's decision of the so-called currently Polish Constitutional Court that decided to find the provisions of the EU treaties incompatible with the Polish Constitution show also the approach that Polish authorities have towards the European Union. Does it affect the simple life of every accused or a suspect in Poland? Certainly yes. Especially this is well visible in the context of mutual trust and mutual recognition of judgments, and especially in the context of European arrest warrants. We have a long history for several years now of courts from Germany and the Netherlands questioning whether the suspect, the accused, can have a fair trial in Poland, and in some cases the proceedings were suspended, the requested persons were not transferred to Poland. So therefore, the atmosphere of the lack of respect to EU law is affecting not only the EU directives and the level of their implementation, but this is a broader, I would say right now, a systematic problem in Poland. So whether we have a hope for changes like that with regard to the position of judges and the courts, whether the burden of protecting rights of the accused and suspects rests upon is fulfilled by Polish courts? And again, the answer is unfortunately no. It stems from different reasons. Well, there is no comprehensive study in Poland conducted yet on why the Polish courts are not invoking EU directives directly, why they are not trying to bring the rights that are within EU directives directly from the provisions regarding certain rights. But we kind of think that this might be a result of a short time since Poland is in the EU, and also the lack of training and lack of scholarship on the issue, and especially lack of training for the judges that are sitting on cases, and they did not probably have proper EU law training when they were still at the law school. And even if this situation is changing for, well, within those 18 years as we are in the European Union, still the respect for the usefulness of the EU law is very low throughout the Polish courts. Also, perhaps the provisions of the EU directives and different regulations on the rights are rather vague, so judges might be also reluctant to use them directly to protect the suspects and accused. But we had also discussions within the team and within practitioners that even if the certain rule is provided by the defense counsel and shown to the judge, sometimes judges, well, usually judges are refraining from accepting that they are necessary to be used directly. Therefore, since none of the directives were fully and properly transposed to Polish law, the burden should rest upon the courts, but we do not find that they fulfill the obligation that is put on them. So the dominating Eurosceptic narrative of the governing majority in Poland is not a friendly environment for introducing necessary corrections at this point, and we don't see the perspective for the proper transposition of the EU directives, both on the structural level, but also this incidental level. Unfortunately, the case law and the behavior of the lack of activity of courts in Poland gives also only little hope. Therefore, regrettably, it is hard to expect in the near future any changes in that and an improvement for the standard of protection of defense rights in criminal procedure in Poland. So on behalf of the Polish team, and we are all here, and we are happy that we can be in Bologna for the closing conference, I would like to thank you once again very much for bringing us to the CrossJustice project. I'm really grateful personally. You know, Michele, Giulia, Giuseppe, my affection towards University of Bologna Faculty of Law, and you all. Thank you very much, and I'm open for questions.
Thank you very much, Carolina, for this rich and complete presentation that, from my point of view, goes directly to a crucial point when we speak about effective protection of procedural rights. The notion of suspect. The notion of suspect is fundamental, is a precondition for the protection, because this status is essential to trigger all procedural rights, as you said. Who is the suspect? Should we consider as suspect only the person after charging or under detention, as Carolina said, or should we consider also person de facto suspect, as for example in the Italian system? Should we prefer a formal approach or a substantial approach? If we consider a suspect who is de facto under investigation, the substantial approach, of course, the protection can be effective. Otherwise, it's just a formal protection, but not a proper protection. And I think that under the European Union law, we should prefer the de facto approach, not the formal approach. I think we can develop this discussion with the second speaker, Professor Zoran Buric of the University of Zagreb. Professor Buric is Associate Professor at the University of Zagreb, and he also the head of the Institute of Criminal Science. His main field of research are European criminal law and procedure, also in the perspective, of course, of human rights protection. Professor Buric is going to speak about controversial issues in relation to the implementation of a presumption of innocence directive in the Republic of Croatia. So I think we will see other critical issues also from the Polish perspective. Thank you very much. Professor Buric, you have the floor.
Oh, thank you. Thank you. Thank you for the introduction. It's very nice to be in Bologna. I'm here presenting the Croatian team. Unfortunately, we are not all here. A very important member of our team, Professor Zlata Đurđević, couldn't be with us today. So therefore, I'm taking the floor and I will be giving you the Croatian perspective on the transposition of the directives. I won't be talking about the presumption of innocence. Last night, I changed my topic. I will be talking about the suspect. So what Carolina was telling you about, it's a very good, I'm sorry, it's a very good introduction into it was a great presentation, but also a very good introduction. Yeah, but it's also a very good introduction into what I will be talking about with you today. So the situation was pretty similar, in fact, to the Polish one. There are, of course, slight differences in the understanding of who is a suspect or whatever. There, lawyers tend to invent all these very sophisticated terms, and in Croatia, of course, there is a very sophisticated understanding of who the suspect is and who the accused person is, and especially when should fundamental procedural guarantees or the effective protection of fundamental procedural guarantees be afforded to a person. This is the crucial question. So in Croatia, traditionally, I would say, like from the socialist period, we had, but we still have, but this is slightly changing, and it changed also with the transposition of the directives. We have a very interesting, I would say, differentiation between an informal and a formal criminal proceedings. So, or the inquiries and the investigation. Inquiries are something which is dominated by police work in relation to criminal proceedings. And it's characterized by the factual position of a person who is the suspect of a criminal offense. And then on the other hand, we have a very formal investigation into the criminal offense, which starts with the formal, or started with the formal understanding of the suspect. After the police have done all the work, have collected all the crucial evidence, have interrogated the person, possibly in the absence of a lawyer. So the case is more or less solved already at that point, and then the person actually only after that point gets all the guarantees of fundamental rights protection. So this was very typical for Croatian procedure, but there was also a further elaboration why this is good for the suspect. And the elaboration was that the results of police interrogation of the suspect or the arrested person may not be used as evidence before the court. Actually, I must correct myself, not the results of the interrogation, but the statement which the suspect or the arrested person gave to the police while being interrogated was not admitted into the evidence after the proceedings came to a court phase of the procedure that is much more later in the proceedings. So it was considered, and then after that it was considered that police investigation or police inquiries into the criminal offense are not really that relevant for the criminal procedure because what the suspect tells to the police while being interrogated, his or her statement cannot be used as evidence before the court. Well, this means this is not important, right? Well, of course not, because the police work is crucial, and what the police does during the inquiries of the criminal offense, it determines the outcome of the criminal procedure. But anyway, this was the situation in Croatia at the moment when the time came for us to transpose the EU directives on the fundamental rights of defense. And when this process started, which was back in 2012, 2013, initially the understanding that this should not significantly affect the police inquiries into the criminal offense, because what the police does is not formal procedure. It is just something what happens before the formal investigation. So this understanding kind of prevailed. There were some slight changes when it came to the transposition of the directive on the right to translation and the right to information, but not major changes. This did not affect significantly this part of the criminal proceedings in Croatia. But then the time came to transpose the directive on the right of access to a lawyer. And in Croatia, unlike, if I understood you correctly, unlike in Poland, when there is time to transpose a certain directive, the ministry takes, our Ministry of Justice takes this job really seriously. So they invite people from the academia, they invite judges, they invite public prosecutors, they invite lawyers. Of course, people from the ministry participate, and they form a working group, and this working group works for a certain period of time. And then at the end of the process, a working group proposes an amendment to the law or to the laws which are necessary to transpose the directive into Croatian law. And anyway, the time came to transpose the directive on the right of access to a lawyer. And finally, I guess it was a mixture of different factors which made it possible to finally try to make a significant change when it came to re-regulating police interrogations of suspects and accused persons in relation to criminal procedure. And the time came to try to effectively guarantee the basic rights of the defense for the suspect and the arrested person while being interrogated by the police. Of course, an important argument why we need to do this were the provisions of the directive on the right of access to a lawyer. I think the most important provision, as far as I can remember, was the one stating that the suspect should have all the rights from the moment when he or she is being interrogated by law enforcement authorities. So this is something which was used to explain that this does not only affect formal interrogation by the public prosecutor or by the police, because the police can also formally interrogate it during the investigation, not during the inquiries, but that these rights should also be guaranteed to the suspect and to the arrested person during the inquiries into the criminal offense. But this was not the only argument. At the same time, judgments from the European Court of Human Rights started coming, because the fact that the police conducted informal interrogations of suspects and arrested persons, of course, gave the police a lot of open space to do certain, maybe not acceptable things during these interrogations, because there was no judicial oversight over these interrogations. Because I told you the statement, which was the direct result of the interrogation, could not be used as evidence before the court, and the court during the proceedings had no insight over what was happening at the police station, because they would say, okay, we don't have anything in the case file, so how can we now establish what happened? This would be extremely complicated. We cannot go back to this. And the judgments from the European Court for Human Rights started appearing when a couple of them. The best known one, probably, it's one of the leading cases on the right of access to a lawyer during the police interrogation, is case Dvorsky, which is also like a peak case when it comes to the development of the jurisprudence of the European Court of Human Rights on the right to access to a lawyer during the police interrogations. And these judgments started appearing stating, clearly indicating that things which are happening in Croatian police stations are not necessarily good and are not in line with the guarantees that should be awarded to suspects and arrested persons during this process. Anyway, and when the main impetus to make these changes came from the academia, and there was a lot of opposition to introduce these changes, of course, from the police, because these possibilities for the police force made their work extremely effective. If you have the possibility to conduct on oversight interrogations of the suspect and the accused person, of course, this creates a lot of possibility to collect the other evidence and to get all the self-incriminatory statements from the suspect and the arrested person you can get. But there was a lot of opposition even from the defense lawyers, because they said, no, we prefer a situation where this is not admitted into evidence. Like, I think a lot of important part of their opposition, and is maybe also the case that they were unwilling to go to the police station because they considered this is not important. What would we do there? Like, we prefer staying home and then coming before the public prosecutor at 2 p.m. or 3 p.m. and not at 2 a.m. or, well, interrogations don't normally take place at 2 a.m., but arrests do. And we also had a practice, this is also not very nice, but of police lawyers, like lawyers who came to the police station and who actually, while being at the police station, defended the interests of the police and not the interests, yes, and not the interests of the suspect and the accused person. So anyway, this situation created a lot of problems in the judicial practice, but all of the practitioners, I would say, except public prosecutors, for whom this possibility to formalize police interrogations meant that they were going to have less work, because something what they normally did would now be handed over to the police. But also the judges were against it because they said, oh my God, this is going to complicate things enormously. Because now all of a sudden we are going to have to check what happened at the police station. We are really going to have to go into these things. But anyway, despite all these oppositions and through very long conversations and arguments being put forward, we finally, in the working group, finally, with the support of the Ministry of Justice, finally, it was agreed that we should regulate this part of police work. And now, I think from 1st January 2018, the rules which regulate police interrogations of the suspect and the arrested person in relation to criminal procedure are similar ones to the rules which regulate the interrogations conducted by the public prosecutor. And these are very sophisticated and very, very formal rules. And not acting by these rules, on the other side, in Croatian law, is sanctioned by very severe procedural sanctions, inadmissibility of the statement or the recording now of the interview, and inadmissibility of all the evidence resulting from the statement. So before this change, maybe you noticed that there was an enormous disparity between police interrogation, which was conducted with no guarantees and totally informally, and public prosecutors' interrogation, which was conducted extremely formally and with extremely severe procedural sections for any unintentional mistakes in the conduct of these actions. And so now we have very formal police interrogations. So I still think we have an imbalanced system in this regard, but we have very formal police interrogations where everything is being audio, video, recorded. Of course, we have problems with ensuring effective access to rights because we don't have lawyers on duty. We don't have the remuneration or the lawyer's fee For these situations, police station work is lower than for some other situations. So there are a lot of deficiencies in the system still, which enable, I would say, effective exercise of this fundamental right for all the suspects and the arrested person. But legally, on the normative level, I would say the situation is much better and much more in line with European law than it was before. Thank you.
Thank you very much, Zoran, for this picture about the Croatian perspective that I think confirms us what I said before. We have to take the status of suspect very seriously. And second lecture I think we can draw is that we also have to pay a lot of attention to informal interrogation, informal investigation, because usually under informality or informality is used by police or by public authorities to bypass procedural guarantees. So we should avoid this. But of course, every system has its own approach and legal tradition. Now we can move to another perspective, the French perspective. The speaker who is going to present her system is Eleonora Cervellera, right? She's a PhD student in criminal procedure at the University of Paris-Nanterre under the supervision of Professor Parisot, who is not here. Eleonora is going to speak about right of defense in France during the inquiry phase, with particularity about the absence of quality of party of the suspected person and limits to the presumption of innocence. Thank you very much. Eleonora, you have the floor.
Good morning, and thank you very much, Professor Di Paolo, for this kind of presentation and for being the chair of our session. And I would like to thank Professor Michele Caianiello and the whole Unibo team for including Professor Rafael Parisot and me in this interesting and important project. And thank you again for giving me the opportunity to present the result of our study today. And it's a great pleasure for me to be here. I would like to focus my presentation on the two main issues that have arisen from the analysis of the transposition of Defense Rights Directive into French law. In particular, the right of defense during the inquiry phase and the limit to the presumption of innocence. To introduce some essential characteristics of the French criminal procedure, the French Code of Criminal Procedure has been adopted in 1957 and has been changed a lot since then, in particular under the influence of the European Convention of Human Rights and under the influence of European Union law. So traditionally, the French criminal procedure is an inquisitorial system. So the trial is secret, written, and non-adversarial. But today things have changed, and the preliminary article of the Code of Criminal Procedure provides that the trial is oral, public, and adversarial. On the contrary, the pre-trial stage remains, as in the past, secret, written, and non-adversarial. So a distinction must be made between the trial strictly understood and the pre-trial stage that remain an inquisitorial system. In our analysis, we have seen that the directive's transposition into French criminal law can be considered generally satisfactory. A distinction must be made between directives that have been transposed into French law and directives that have not been transposed into criminal law. As you can see in the first slide, for the four directives has been transposed into French law as the directive about right to interpretation, right to information, right of access to a lawyer, and directive about procedural safeguard for juvenile defendants. There are some directives that have not been transposed into French law, as the directive on legal aid and the directive on the presumption of innocence, so the 2016-343 directive. We can make two general considerations about transposition. First of all, concerning directives that have not been transposed into French law, they are not perceived as a problem in France, and this is because the French government considers that it is not necessary to transpose directive, and this is because the standards of transposition are considered already satisfied in existing law. And the second consideration that we can make is that the analysis of internal legislation shows a substantial conformity with the European directives, except for the issue that will be discussed during this presentation. The first issues concern the status of the suspect during the inquiry and the consequences in terms of remedies and of right granted. And the second issue concerns the potential breach to the presumption of innocence, in particular for the use of glass boxes and for the lack of remedies in case of breach of the right to remain silent and of the right not to incriminate oneself. Concerning the first issue, so the status of the suspect during the inquiry and the consequences in terms of right granted and remedies, in order to better understand issues involved, it is necessary to distinguish between the two possible frameworks of investigation existing in French law. On one hand, we have the inquiry, l'enquête, that is the investigation carried out by police officers under the supervision of the district prosecutor. The district prosecutor has a judicial status, but is not an independent magistrate, because he is placed under the supervision of the general prosecutor, who in turn is placed under the supervision of the Minister of Justice. And the inquiry is the most common framework of investigation in the country today. And on the other hand, we have a judicial investigation, so l'instruction, that is an investigation carried out by an investigating judge, that is an independent magistrate. And this type of investigation, from a temporal point of view, takes place after the inquiry, and it is necessary in case of, for the most important, for the most serious offenses like crimes, and it's just possible for other offenses when the case is complex. The choice between the two types of investigation has important consequences and effects. The person placed under an investigating phase is considered as a party to the proceeding, so he or she fully enjoys defense right. On the contrary, the person placed under an inquiry is not considered as a party to the proceeding, so he or she doesn't benefit fully defense right. Certainly, rights granted to the person suspect in an inquiry have increased over time, but rights granted to the person suspect in an inquiry remain more strict than during other phase of the proceeding. So, for example, the right to be assisted by a lawyer is fully granted during judicial investigation, and on the contrary, during inquiry phase, this right is granted only if the offense is punished by an imprisonment penalty. Concerning the consequences in terms of remedies, it is important to stress that in French criminal procedure, there are no specific remedies in case of breach of rights established by the directive, but only general remedies. So general remedies that are available in case of infringement of formalities that the Code of Criminal Procedure punishes with nullity. And the issue arises is even more strongly during the inquiry, because during this phase, no remedy are possible at all. And this is because the person suspected in an inquiry is not considered as a party. So he or she cannot contest procedural infringement during this phase. Procedural infringement could only be invoked if the inquiry phase leads to a proceeding or to an investigating phase. So if the person remains a suspect in an inquiry without becoming a party to the proceeding, no remedy are possible at all in case of infringement of right. The second issues that have arisen from the analysis of transposition into French law is the potential breach of the presumption of innocence. It should be noted that the 2016 directive on the presumption of innocence has not been transposed into French law, and there is no ongoing project about transposition. And so this is because the French government considered that the standards of protection was already satisfied in existing law. But some compliance issues do arise. In particular, first of all, the use of glass boxes. And glass boxes are cages that are installed in court when the accused person detained is held during the hearing. And this installation has been contested by several lawyers associations and several bar associations. In particular, for the French union lawyers, the installation of these boxes infringe the right of defense, and in particular, the presumption of innocence of the person caged, and disproportionately affect the fundamental rights of the defendant. And the systematic use of these boxes is contrary to the 2016-343 directive and in general with the European law. So the Union of French Lawyers has contested the installation of these glass boxes by a letter addressed to the European Commission. And the European Commission answered in 2018, considering that it was necessary to analyze the French law before deciding to trigger an infringement procedure before the Court of Justice. And we have no update today about this procedure. From an internal point of view, the internal jurisdiction, so the Court of Cassation and the Conseil d'État, that is the Supreme Administrative Court in France, in 2019 and in 2020 validated the installation of glass boxes, so rejected the appeal of lawyers, considering, first of all, that the use of these boxes could be necessary to prevent the escape of the person accused during the trial, and to assure the security of the participant at this trial. And moreover, the Court of Cassation and the Conseil d'État consider that the Directive 2016-343 does not prohibit the use of glass boxes and authorize physical restraint in case of necessity. So for the internal jurisdiction, the use of glass boxes does not infringe the presumption of innocence and, in general, defense rights. Another source of criticism that have arisen from the analysis of relevant legislation is the lack of specific remedies in case of breach of the right to remain silent or not to incriminate oneself. The right to remain silent plays a significant role in many stages of the proceeding, and during all the procedure, the person has the choice to make a statement, to be interrogated, or to remain silent. And the Court of Cassation has considered that this right, the right to remain silent, must be notified even if the legislation does not foresee explicitly it. Concerning the right not to incriminate oneself, this right is not explicitly provided for in the Code of Criminal Procedure, but it has been recognized through case law. And for example, the Court of Cassation considered that police officers cannot provoke the commission of an offense because it is deemed contrary to the right not to incriminate oneself. The main issues that have arisen concerns the lack of specific provisions and remedies for the assessments or for the statements pronounced by the accused person in breach of his right to remain silent or not incriminate oneself. And the same applies for the evidence that has been obtained in breach of these rights. The case law developed the idea that the evidence or the statement obtained in breach of a fundamental right should lead to the exclusion of the evidence. So, for example, the Court of Cassation has considered that police officers cannot create a fake pedophile network to detect users, and that the evidence obtained through this method cannot be used during the proceeding because constitute an infringement to the right not to incriminate oneself and the right to remain silent. So I think that we can make two general conclusions at the end of this presentation. First of all, concerning the status of the suspect during the inquiry, the lack of specific remedies and the restriction of defense rights during this phase risk to make French law non-compliant with European directives, European defense directives. And so this is why today the question about remedies and about the right granted during the inquiry phase is topically in French law. And as recently proposed at a legislative level, an independent magistrate may reinforce the control during the inquiry and the respect of the rights of defendant during this phase. And this is what the doctrine calls la juridictionnalisation de l'enquête, so the jurisdictionalization of the enquête, of the inquiry. So by introducing an independent magistrate that can reinforce the control of the respect of rights during this phase. And concerning the lack of transposition of the 343/2016 directive on the presumption of innocence, we have said at the beginning of this presentation that the French government did not consider necessary to transpose the directives on the presumption of innocence, because considering that the standard of protection was already satisfied in existing law. But given the several debates on glass boxes and on the lack of remedies in case of breach of right to remain silent and right not to incriminate oneself, it's difficult to understand why there is not a clear law transposing the directive and in general providing for specific remedies in case of breach of the presumption of innocence. So, thank you for your attention.
Thank you, Eleonora, for this perspective from the French perspective. Therefore, very interesting the distinction between enquête and destruction, and especially for the different level of protection of procedural rights. It recalls us discussion we made in Italy before adopting the new code about the models, which is the best model, the accusatorial model, the inquisitorial model, a mixed model as the French model now. Very interesting also the discussion about glass boxes and critical issues about the right to remain silent and of course the right against self-incrimination that should be one of the cornerstones of every criminal justice system. perhaps France could do something to improve and to the level of protection of the accused person, again, in that system. Now we can move to the last speaker and to the Spanish perspective. The last speaker that is connected, Ana Maria Neira Peña. Can you hear us?
Yeah, perfectly.
Okay. Professor Ana Maria Neira Peña is professor at the University of Coruña. She is associate professor in this university, and she has great experience in research in project, European project and national project in the field of mutual recognition principle and procedural rights of the criminal proceeding. She is going to speak about critical issues and positive profiles in the enforcement of presumption of innocence in Spain. I hope we will hear something better and something positive now. Ana Maria, you have the floor. Thank you very much.
Okay, well, many thanks for the presentation. Well, first of all, I'd like to thank the organizers, the Bologna team, for inviting me to take part to this very interesting project, and also for giving me the opportunity to be here at this final conference, even if it's in online format. I have loved to be in Bologna, but this time it couldn't be, so let's see in the future. Well, thank you very much for counting on me, and of course, congratulations for this amazing project. Well, before I start with the core of my presentation, the first question would be, why did I choose this topic for the final conference? Why did I choose presumption of innocence? The reason is that in Spain, both at the legislative and at the jurisprudential levels, there are many shortcomings in relation to these fundamental rights. So firstly, the directive has not been transposed so far in Spain either. Although it's true that there is a draft for a new criminal procedural act that, if it were to enter into force in the future, which currently is uncertain, would significantly improve the current situation. That's the positive side. Secondly, there is no legislative development on the content and on the scope of the right currently in Spain beyond its generic proclamation at the constitutional level. So the Spanish Constitution provides that everyone has been presumed innocent, but then we don't have development legislation stating what's the scope and the content of the right, from when and until when may be claimed this right, against whom, what's the specific content taking as a whole. So this, of course, is an important shortcoming. And thirdly, case law is contrary to the spirit and the letter of the directive in many aspects. So taking into account this situation, I have chosen this topic because this is a matter, we can say, in which much remains to be done. So in order to analyze the Spanish situation, my presentation is structured in 3 different parts, according to the 3 different dimensions of the right to the presumption of innocence. So first, I will address the presumption of innocence as a rule of treatment, secondly, as a rule of evidence, and finally, as a rule of judgment. Well, regarding the first dimension, presumption of innocence as a rule of treatment, here 2 aspects must be distinguished. The ad intra perspective, so the treatment given by the prosecutorial authorities to the defendant, and the ad extra perspective concerns the treatment given by the media or other public authorities not involved in the criminal prosecution. So regarding the first perspective, currently Spanish legislation does not regulate this aspect at all, and case law is not concerned about this aspect either. So case law focuses on the application of the right at the time of sentencing as a rule of evidence and as a rule of judgment, ignoring systematically its application to pre-trial phases, police investigation, judicial investigation, and so on. So in practice, and this is the problem, many excesses are committed. For instance, the appearance of handcuffed detainees at courts, it's very common. The appearance of defendants covering themselves with their clothes at the entrance and at the exit of the tribunals. Unfortunately, police statements asserting the guilt of the defendant are also common in Spain. Does the draft entail any improvements in this respect? Well, yes, because the draft expressly provides that the defendant shall be treated as innocent for the first time in our national legislation. So at least with this draft, we will have the need to respect this aspect of the right will be clearly established in law. Of course, the problem will be to put it into practice. So good practices and adequate training for the police, for investigative judges, and for prosecutorial authorities in order to make this right a reality. Well, in relation to the ad extra perspective, the treatment given by the media, which is not an aspect directly regulated by the directive, but I think that is an important aspect. There are no rules in our criminal procedural code, neither in the new draft, because the explanatory memorandum of this draft provides that it's not the task of the criminal procedural code to regulate the behavior or how journalists should behave in the dissemination of news about criminal proceedings. However, in my opinion, whether the criminal procedural code is the appropriate legal act to regulate this aspect or not, I think that it's necessary to limit the sensationalist and biased treatment given by the media of certain criminal proceedings. And why? Well, because once again, in practice, many excesses are committed. Parallel trials, so those trials in which the media or the press, the journalists act as judges, are commonplace in Spain. And it must be noted that a particularly aggressive media campaign sustained over time, insofar as it is capable of generating a certain state of mind, a certain climate inclined to the guilt or the innocence of the accused, may affect the impartiality of the judge and consequently may affect clearly the presumption of innocence of the defendant. So this matter needs an urgent regulation. Well, the second dimension, the presumption of innocence as a rule of evidence. Once again, there is no express transposition at legislative level in Spain. Nevertheless, at least in general, case law is respectful of this aspect of the right, holding clearly that the burden of proving guilt rests with the prosecution, of course. The problem here arises in connection with the exonerating and mitigating circumstances. Since the Spanish Supreme Court and the Constitutional Court hold that it's up to the defendant to allege and prove such circumstances, exonerating and mitigating circumstances. And at least in my opinion, an interpretation fully respectful of the presumption of innocence should lead to the understanding that it's the prosecutor, the prosecutor office in charge of proving such exonerating and mitigating circumstances, or the non-concurrence of such circumstances. For instance, the non-concurrence of self-defense or psychic alteration and so on. And of course, the doubt about the concurrence of these circumstances should benefit the defendant. Once again, the draft entails an improvement in this respect, because the draft states that the burden of proving guilt corresponds to the prosecuting parties and adds that is projected on the totality of the constituent elements of the crime, both objective and subjective. Of course, at least in my opinion, this is an improvement because now we have nothing, But let's see if this is enough in order to counteract this current majority case law, since the draft refers only to the constituent elements of the crime, leaving aside, at least literally, the mitigating and exonerating factors. Well, the third and last dimension would be the presumption of innocence as a rule of judgment. Here, once again, there is no express reference at legislative level, but the main problem stems from case law. Case law does not include in dubio pro reo principle as a part of the fundamental right to the presumption of innocence. So Supreme Court distinguishes between the fundamental right to the presumption of innocence, which is objective and consequently challengeable before higher courts, and the in dubio pro reo principle, which is a subjective criterion referred to the internal state of mind or the internal thought of the judge, and consequently, in practice, is very, very difficult to challenge, to vigilate over compliance in relation to this principle. So the main consequence is that the breach of the in dubio pro reo principle in practice is not subject to objective control, and it may only be appealed if the first instance court convicts the defendant despite having expressly stated orally or in writing its doubts on the guilt of the accused, but not when it's reasonable to understand that the case offers doubts or presents serious doubts. So does the draft bring about an improvement here? Well, the answer is once again affirmative, because the draft clearly states as a part of the presumption of innocence that any reasonable doubt as to the facts criminally relevant shall be resolved in favor of the accused. So, of course, reasonableness is a more objective criterion than internal doubts or internal thoughts, and consequently makes it easier to supervise compliance with the in dubio pro reo principle and makes it possible to challenge possible non-compliance. The last idea related to this dimension, the presumption of innocence as a rule of judgment, it's related to the value of silence. Once again, we don't have a legislative development beyond the constitutional proclamation. So the Spanish Constitution states that everyone has the right to remain silent and not to incriminate him or herself. But then we don't have a legislation stating what's the content and the scope of this right. And once again, case law is the main problem. So case law has been holding down when incriminating evidence requires an explanation from the defendant, the lack of such explanation may serve as an element of corroboration of the incriminating evidence, which may be used to strengthen or shore up such evidence, which of course is contrary to the letter and to the spirit of the directive. So here the draft also entails a certain improvement, since finally states the specific content of this constitutional right, which is that no detrimental consequences may be drawn from the silence of the defendant or from her refusal to testify. Of course, the fact that the pre-legislature finally has clearly stated that the silence of the defendant cannot be valued as a corroborating element or as an incriminating element or as an additional element to reinforce conviction should be positively valued. As to conclude, well, the first conclusion would be that also in Spain there is still a long way to go with regard to the presumption of innocence, of course. That emphasis must be placed on the presumption of innocence as a rule of treatment, because this is the most forgotten aspect of the right, also in the legislation and in case law. And this implies taking care with the language of pretrial decisions, limiting the use of handcuffs or other physical restraints, and also regulating the informative treatment of criminal proceedings, perhaps outside the directive, outside the criminal procedural code, but it's necessary in order to strengthen the presumption of innocence. The third conclusion would be that establishing a specific standard of proof beyond any reasonable doubt, applicable to all criminal relevant facts, including, of course, exonerating circumstances, at the legislative level, may contribute to strengthening the defendant's rights and to clarify the content of these fundamental rights. Fourth conclusion, it's necessary to review case law. The Spanish case law on in dubio pro reo principle and on the right to silence is unacceptable, and it's urgent to review this case law whether or not the draft is approved. And as a last and general conclusion, I would say that the draft may be an undoubtedly an important step forward in order to strengthen the right to presumption of innocence, but even more important than the draft is the application of the directives by the authorities called upon to implement it, specifically the courts. We must not forget that the directive is already directly applicable, and the national courts must adapt urgently their decisions to it immediately, regardless the action of the national legislature. So many thanks for your attention, and I remain at your disposal for any questions or comments or suggestions. Thank you.
Thank you very much, Anna Maria, for this presentation that remind us the multiple dimensions of the presumption of innocence. You said very well, the presumption of innocence as a rule of treatment, a rule of evidence, especially on the burden of proof, and a rule for the decision of the judge in dubio pro reo, and especially in evaluating the silence of the suspect. Very clear rules from the theoretical point of view, but we should again say very difficult to keep and to ensure in the practice, as the case law you mentioned show us. And we also have to consider the rule of treatment as very difficult to be effective in the media society, but this is another part of the speech we could say. I think that we have 5-10 minutes now for debate or for questions, if there are questions. Sorry, but with these glasses, I can't read the chat. Oh, can you read for me? Thank you.
Is a question for the French system. By Antonio Pugliese, for the question in the chat. I was wondering what happens if the suspect's personal freedom is restricted to some extent during the inquiry, which, as you said, provides for minor guarantees as compared to the instruction. Are there as well problematic aspects of compliance with the directive? Yes, thank you for this interesting question. And certainly the question about the restriction of freedom during the inquiry is one of the most problematic and discussed points in French law. And this is because until 2011, the French Code of Criminal Procedure provides for a very limited, restricted number of rights granted to the person arrested in an inquiry. during an inquiry. And things have changed today, and the number of rights granted to the person placed arrested in an inquiry have been extended, and in particular following several declarations of unconstitutionality pronounced by the French Constitutional Council. So we can say that today rights granted to the person arrested during an inquiry are more or less the same rights that are granted to the person during other stage of the proceeding. So more or less the same rights that are granted to a party to the proceeding. But the problem is that the issues about remedies remain because even if we have extended the number of rights granted to the person placed arrested during an inquiry, there are no possible remedies in case of infringement of these rights, so of the rights of the person arrested during the inquiry, if the inquiry does not lead to a proceeding or to a judicial investigation. So this shows that certainly the extension of rights during the inquiry, and in particular during the restriction of freedom is essential, and it's I think a good way to start to improve our French system. But I think that the only way to make the French law fully compliant with European directives is by acting a general reform that provides for remedies during the inquiry, and a general reform that recognizes the status of a party to the suspect in an inquiry. So if we without a general reform, I think that there will be only partial reform, so not real solutions. So this is what I can say.
Thank you very much. Other questions in the chat or in this room?
Okay. Wojciech Jasiński, I'm an assistant professor at the University of Wrocław, Poland. And it's a great relief I can take off the mask. So 3 exemptions: eating, drinking, and asking questions. I have a question, in fact, to Eleonora, and it was partly answered, I guess, because of the question that was prior at the chart. But can you elaborate more also on the question of access to lawyer during the when the person is arrested? Is there anything you think makes this right non-effective in France? I mean, because I haven't studied French law for some time, but I know that there was a discussion about the limitations when people are placed under garde à vue. So do you think this is, well, I'm not saying this is not in accordance with the directive when it relates to law in books, but I mean law in action, and whether the restrictions that are, and if they are present, they anyhow make this this access not really as effective as it should be from the perspective of defense rights. And the second one, you also mentioned about the restrictions on right to information, and is this somehow not in accordance with the standard that is in the directive? Thank you.
Thank you for your question. Yes, about the access to, as I said at the beginning during my presentation, the number of the rights granted to the person placed in an inquiry remains more stricter than during other phases of the proceeding. So, in particular, the right to the access of a lawyer, and also right of information, because the access to the material of case is fully only during judicial investigation and only during the trial. So no access to the material of the case, just access, not fully, because some documents, we have the access to some documents of the inquiry, but not at the totally of the documents. So certainly, I think that during the restriction of freedom is the point is the phase of the procedure of the inquiry where the rights granted have been extended more. But certainly there are some issues. And about the presence of the lawyer during the privation of liberty, I think that after the declaration of inconstitutionality in 2011, we can say that there is fully access to the defense to a lawyer during the restriction of freedom, but the problem remains during inquiry, because this access is limited for offenses that are punished with an imprisonment penalty. But we cannot restrict freedom of the person placed under an inquiry if the offense is not punished with an imprisonment penalty. So I think that we can consider that the right to access to a lawyer is granted during this phase. Concerning the right to information, this right is, I think, after 2011, fully granted for a person in case of restriction of freedom, but not for a person free during the inquiry. So there are a lot of work to do.
Other questions?
Can you hear me? Okay, I am Marianna Biral, a research fellow here in Bologna and part of the Italian team of the CrossJustice project. I would like to thank all the speakers, and I would like to ask something to Professor Kremens. We learned from your presentation that Polish legislation is not aligned, is not compliant to European prescriptions in respect as for defense rights attached to the suspected person, so before formal charging. But I was wondering about the stance of the case law. Are there obstacles in interpreting the Polish word used for meaning suspect in the light of the European prescriptions, thus broadening the guarantees at the national level? Thank you.
Thank you for this question. Well, the answer is that there are no obstacles, of course, and if the court is ruling the case, decides to do so, the court will be free to do so. However, well, we also have to mention that the discussion, what's the definition of a suspect, and that de facto suspect, so informal suspect, should be also covered by the rights that are attached to the suspect who is formally presented with the rights. This discussion started in 1970s, and during this research and for other purposes, we found many articles and the very vivid discussion that the Polish definition of the suspect is too limiting and that it should be expanded to the earlier stage of the criminal process. However, I must say that the courts are very reluctant, for the reasons that I laid out, to even refer to the directives as such, even in situations when defense counsels are putting on the paper the motion or claim that the EU directive or a certain provision of any of the directives is relevant. So I doubt that there is any obstacle to relate and to expand the definition, but I believe that the attachment, the awareness of the judges is on a very low level. They are so attached to the idea of the formality of presenting the charges, which is, again, perceived as a form of guaranteeing a person to information about the charges. So there are some scholars who deny the idea of expanding the charges to the earlier stage of the criminal process, saying, well, how will, if de facto suspect will get the same rights, how this suspect will learn about what the investigation is about if there is no formal meeting in between the prosecutor and the police. And of course, we know from the Italian system, from the German system, from any other system that is using less formal definition, that this is still possible through some less formal forms of communication between the police, prosecutor, and the suspect, the de facto suspect. So the courts are very reluctant. The courts are not probably even aware of the scope of the definition of the suspect as within the EU directives. And I would say, on behalf of the Polish team, that we were struggling with finding even case law in Poland that is referring to the EU directives, and especially when we were exchanging views with our Dutch colleagues, for example, on one of the meetings and conferences, we were overwhelmed with the number of cases that the database that was so amazingly built throughout this project is so filled out with the cases coming from other systems and from Polish system. But I remember it was also an issue in Croatia that the interest is on a very low level, and despite my opinion that it's not a problem to interpret in this way, I guess the level of interest is so low that it will not happen, and everybody probably would wait for the legislative decisions on to that matter. If I may, I will just refer to one thing regarding to what Zoran has said, that there is this beautiful meeting between lawyers before the deadline is coming in Croatia. We also used to have that. We had the Codification Commission on the criminal law next to the Minister of Justice, which was closed probably in 2015, 2016, and we don't have this forum for the discussion, similar discussion that used to be available for Polish criminal lawyers. So this also shows how the legal discussion in Poland is right now looks. Thank you.
Thank you.
Thank you. There is another question in the chat for Professor Kremens. Has the ECJ, the European Court of Justice, no, AC means European Commission, sorry, announced its intent to initiate an infringement procedure against Poland with regard to the implementation of the EU directives? Thank you.
I think I will need also the help of my colleagues, but as far as I know, the discussion is still on the level with regard generally to the more important, as I would say right now, the problem of general implementation, general lack of obedience of the rule of law in Poland, and not focusing as such on the EU directives. But if there is some information that you know about, so my team is saying that no. So I would say that there are more important, unfortunately, more important issues right now in Poland with regard to the respect for the rule of law, and the European Union Commission is focusing on that issue. And we also should be aware that on the website, when Polish government is reporting what is the level of implementation, the answer is we are in full compliance, similarly to what was said a moment ago about French system, that even if we did not transpose directly, it was transposed per se before even the directives were existing. And perhaps for the European Commission, it might be enough information. And therefore, such projects as the CrossJustice is so important, just to bring a new knowledge and the actual information on the level of implementation in different countries. Thank you.
Thank you very much. Other questions? No questions in the chat. I think that we can close this panel. Before closing, I would like to thanks again all the speakers for their presentation, and of course to the Bologna team for the invitation to all of us. And I think that we can have lunch break. Thank you very much again.
being here today to discuss such a fundamental issue for the European debate on future challenges of judicial cooperation as well as harmonization in the criminal sphere. I believe that CrossJustice is a truly amazing project, and as it develops the interconnections among criminal justice and artificial intelligence, paving the way for a stronger judicial cooperation across Europe, as well as for a stronger protection of human rights. So let me deeply thank Michele Caianiello and his research team for this amazing project. Thank you very much. The topic of this section is particularly relevant because it engages complying with supranational obligations, which, as we all know, allow the member states to gain significant spaces of discretion and a variable margin of appreciation. Those possibilities may conceal a minimalist or a more rigorous approach. And behind this variable transposition is also hidden the actual possibility of respecting the relevant rights and affirming the fundamental guarantees according to a perspective that is not theoretical or illusory, but practical and effective, not formal, but substantial, and really rights sensitive. However, I do not want to steal time from our speaker, so I'm very pleased to introduce you the brilliant European colleagues in the panel who I'm sure are going to discuss the transposition approaches in deep. First, I welcome Dr. Adriano Martufi, who is Assistant Professor of Criminal Law at Leiden University, where he teaches European and Comparative Criminal Law. Am I right? Yes. He is a partner of the CrossJustice project, a team member for Leiden University. Well, Dr. Martufi, please, you have the floor.
Thank you very much, Professor Manes, and many thanks to all our friends and colleagues here in Bologna, and especially to Professor Caianiello for their invitation today and for their guidance throughout this project. I will discuss some of the findings of the Dutch National Report on behalf of our research team at Leiden, and thus on behalf, as you can see in this slide, of Kelly Pitcher, who could not be with us today, and Professor Janemieke Albuquerque, who is joining us online from Leiden. So our presentation today will touch upon some background information on the Dutch criminal justice system and Dutch legal culture to place the findings of our research project into context. Then I will discuss some core findings of our desk research, and I might as well anticipate that the results of our research show that implementation of EU directives in the Netherlands is definitely on the minimalistic side of the spectrum rather than on the progressive side of the spectrum, picking up on the title of this session. And this implementation has encountered a moderate but still fierce resistance, which transpires mostly from the very formalistic and minimalistic style of implementation that I will discuss. Then I will conclude talking about some open questions and possible directions for future research that our investigation has prompted. But first, so let me first give you some background information about the Dutch legal system and Dutch legal culture that I believe might be of interest to fully understand why the reception, the implementation of EU directives on defense rights have been so underwhelming in our perspective, from our point of view. And in doing so, I will use we have been using in this research a methodological standpoint which is slightly and moderately socio-legal in the sense that we have reflected critically on the terminology, on the wording chosen by the Dutch legislature, on the assumption that an analysis of the wording of implementing legislation might in fact unveil some underlying narratives about some, that also highlight some cultural aspects of Dutch criminal law and criminal procedure. So first, let me put the Dutch practice and Dutch law in context a little bit. And first thing we need to know is that the Netherlands are a typically monist jurisdiction from the point of view of international law, in the sense that national statutory legislation can be set aside if, in contrast with international law and international resolutions adopted by supranational organizations like the UN or the EU, and yet no constitutional review is allowed under the Dutch constitution on the acts of parliament, and therefore there is no constitutional court in the Netherlands. In this context, is no coincidence that an important role has been played as a Grundnorm, as a key constitutional principle, set of principles by the ECHR, which is directly applicable in the Dutch legal system, and by the jurisprudence of the Court of Strasbourg. One of the ways in which the legal system has been influenced by the European Convention has to do with consistent interpretation, so a treaty consistent interpretation that aligns statutory legislation through interpretation with the Convention. However, this has had only limited impact on the criminal procedure, and this is proven by the fact that, among other things, the Dutch Code of Criminal Procedure, which is still in force, dates back to 1926 and has undergone only limited reforms during the decades. However, as we speak, a large-scale reform or a project of reform that is referred to as the modernization, the modernisering in Dutch, is currently underway. And at the moment, however, the Dutch criminal procedures preserves the characteristics of the Code of 1926, and therefore a strongly inquisitorial attitude and a focus on truth finding and on material truth more specifically. And this attitude explains, among other things, the centrality of pre-trial investigation in Dutch criminal procedure, and the fact that the main goal of trials is to confirm the findings of the investigation. And if you allow me, the very name of the trial in Dutch, which is onderzoeksterechting, means essentially the continuation of the investigation before the court at trial. So that explains, the very name itself shows how inquisitorial the criminal procedure is, and it is conceived of. Additional elements in this respect are the limited role played by oral evidence and the very frequent use of hearsay evidence, especially of written statements given to the police. And another aspect that I would like to underline is the fact that public prosecutors play a central role and they belong to the judiciary. And in fact, the very fact of them being part of the judiciary has traditionally been conceived of as one of the guarantees of due process rights in the Netherlands. However, the impact and the interpretation of the ECHR has slowly but steadily influenced Dutch law and practice, and defense rights are on the rise, which has raised question as to whether accused and suspects are in fact protected enough under Dutch criminal procedure. And however, the historical background explains, on the other hand, a certain resistance, I would say, to a more adversarial approach that will come with the influence of the ECHR. And indications of this are, among other things, the resistance to incorporate within the Dutch legal system the right to access to a lawyer prior to police interrogation, and the right to confrontation. And as recently as 2021, the European Court of Human Rights has, in fact, condemned the Netherlands for not protecting enough the right to confrontation and the right of the accused to counter-examine witnesses of the prosecution. So let's move on very quickly to the findings of our research. At the beginning of the cross-justice research, we agreed with other team members about different degrees of implementation and on a sort of taxonomy. And I would say that drawing on the tables attached to the implementing legislation, we were able to conclude that 4 out of 6 directives have been, in fact, implemented directly by means of, explicitly by means of new legislation, while 2 others have been deemed implicitly implemented by pre-existing legislation. One interesting aspect, I will say, is that even where the government has proposed a stable new legislation to implement EU directives, it has chosen a very piecemeal approach, limited approach, amending specific provision, mostly of the Code of Criminal Procedure, without a large-scale attempt at reforming the code in this respect, and mostly displaying a very conservative attitude in order to guarantee some sort of continuity with the terminology originally chosen by the code or used by the code and the wording and the spirit of the code. And I will say a few words about that in the conclusion if I have time. But let me move on to the core findings, and I will just go through them very briefly. That have to do with the quality of the implementation, which relate more directly to the topic of this session. And our findings, in fact, show that the transposition in the Netherlands can be safely located on the minimalistic side of the spectrum. So it's therefore a very minimalistic approach to transposition. And here are the few conclusions that I extrapolated from the report. That show how formalistic this implementation has been. Many of the provisions introduced to implement EU directives, in fact, are in keeping with the idea, with the inquisitorial idea that criminal procedure is a system of powers rather than a system of rights or individual or subjective rights. And this provision also carefully avoid most of the time to refer to the prerogatives of the defense as subjective rights that the suspect or the accused person may invoke to make their defense more effective or to increase the equality of arms in criminal proceedings. And rather, if we look at the wording, again, of the legislation that has been introduced to implement EU defense directives, the impression that you get is one of unilateral concessions being made to the suspect by the government, by the prosecuting authorities, or in some cases of prescriptions being framed addressing prosecuting authorities rather than the suspects or the accused. And so briefly, the result of our research showed that the quality of the implementation has been formalistic, minimalistic, and if anything, extremely pragmatic, with a focus on efficiency and reducing the length of trial proceedings. So a few examples of this before moving on to the conclusion of my presentation are represented, in fact, by the way in which the Dutch legislature has implemented the right to access to a lawyer, which shows a great deal of formalism. The provisions implementing the right to access to a lawyer without undue delay, so the right to have access to a defense or a counsel before police interrogation, actually fail to recognize the access to counsel as a subjective right, and they address as a sort of prescription the prosecuting authority. Other provisions which have to do with the right of a defense lawyer to actively participate during police interrogation have not only been extremely restricted by the delegated legislation, which, among other things, prohibits defense lawyers to replies and interact with the police or the prosecutor during police interrogation, but also frames the right to have a lawyer present during interrogation as an extremely dependent right, dependent upon the requests of the suspect himself or herself. And certainly, they do not give the sense of being very protective in nature when it comes to the suspect or the accused person, the suspect here in particular, because we're referring to the pre-trial stage of the investigation. So this is just an example of, or a few examples of formalism that you can see and that I have highlighted in the provisions that we have translated from Dutch into English. And a second element, a second important findings of the report is very much in keeping, I would say, and echoes some of the analysis that we have heard this morning about other jurisdictions and France in particular, namely the lack of effective remedies, and in particular the lack of specific effective remedies targeting the violation of specific defense rights introduced by the directives. There's a reliance on the existing apparatus, so to speak, of general remedies and sanctions against procedural violation, and in particular exclusionary rules for unlawfully obtained evidence, which can only be triggered before, or mostly be triggered before a trial judge or a trial court. And the rationale behind this reliance on exclusionary rules that can only be invoked before the trial court is in fact that the fairness of the pretrial stage can be somehow remedied in view of a general sense of overall fairness of the proceedings during trials and during the appeal stages of the proceedings. But the question that we raise in the report is very much whether this is compliant with Article 47, paragraph 1 of the Charter of Fundamental Rights of the EU, and whether questions about the effective protection of these rights, of these specific rights, can be brought to the fore and possibly result into preliminary questions to the Court of Justice. So again, I refer to the report for more specific information in this respect. And let me conclude with a few thoughts. I hope I still have a couple of minutes to bring my presentation to an end. So we have raised, and we still raise, a few questions that we also asked our practitioners during the national event, which we don't have an answer to at the moment, but also I think point to some interesting directions for future research. Some of them have to do with formalism and the lack of effective remedies, as I said, which very much raise the questions, in our view, as to whether for practitioners, for defense lawyers in particular, this would be an obstacle to exercise defense rights in practice, or whether these lack of a detailed provision, these lack of a language of rights, as we call it in the report, could be somehow remedied by consistent interpretation by national courts. I talked about consistent interpretation at the beginning of my presentation. The second question we raise is whether the continuity of the language chosen by the legislature might, in fact, although it might be of help in terms of legal certainty, because practitioners may be used to some kind of lexicon or terminology, but on the other hand, it may have the effect of perpetuating, of consolidating the inquisitorial attitude of the Dutch criminal procedure, thereby preventing EU defense rights to be fully implemented or to deploy their full potential. And also we asked practitioners, and we received some interesting feedback in this respect, whether the broad nature of EU rules, and there was discussion on this morning as well, could be a refrain or make just practitioners a little bit reluctant to invoke EU directives, and instead feel more comfortable with the Strasbourg jurisprudence and the ECHR, which to a certain degree could be aligned with EU directives and maybe even be regarded as more progressive to a certain degree. And some of the answers we got by practitioners is that they look at the ECHR, and especially among defense lawyers, as the safe pair of ends, as a kind of language that judges will understand, while EU directives will be less palatable or less, comprehensible to a certain degree for Dutch criminal courts. Finally, I would like to raise a point that might also drive our discussion into the next session about automated decision-making, because one of the long-term goals of this project is, of course, applying AI to defense rights. And one of the questions I think might be raised in light of the specific legal culture of each jurisdiction is whether we should avoid, and if so, how we could avoid that some specific cultural characteristics of jurisdictions, like the inquisitorial attitude of criminal proceedings in a country, could somehow frame the way in which AI and algorithms are conceived of or constructed, thereby, again, consolidating and perpetuating a judicial and legal culture that pre-exists. And one of the examples that I would like to make to conclude is that AI is by no means without bias, and actually algorithms can very well incorporate biases, and that's what happened in the Netherlands with the so-called child benefit scandals that brought to the resignation of the last coalition government in the Netherlands in the late 2020, where AI was applied to target taxpayers allegedly in a discriminatory way. And so the question is very much, how can we avoid, and of course I have no answer for this question, but how can we avoid judicial and legal culture to be sort of influential and perpetuating biases within AI mechanism applied to defense rights? So this is an open question that I will leave to the discussion later. And with this, I will thank you very much for your attention and leave the floor to the chair. Thank you very much.
Thank you, Dr. Martuffi. It's a very interesting presentation. There are lots of issues that we could discuss, starting from the Dutch experience. It could be interesting, for example, to analyze how deep is the impact of a different procedural model, inquisitorial or adversary, to the effective transposition of the EU obligations and to real compliance with procedural rights. But I resist the temptation to steal time, and I give immediately the floor to Professor Anne Schneider, who is a full professor at the Heinrich Heine University Düsseldorf, and they have a chair for German, European, and international criminal law. Professor Schneider wrote the CrossJustice National Report on Germany, and I'm very curious to hear her thoughts. Please, you have the floor.
Thank you, Chair, for this kind introduction, and thank you to the whole organizing team for inviting us to Bologna. It's the first time that I'm abroad since, I think, 2019, just because of COVID, and I'm very happy that it's Italy I could come to, because the food and the wine and the company is always the best in Italy, in my opinion. So anyway, I'm going to talk about German law and the German implementation of the directives. And just as a preliminary little correction to the chair, I was not the only one writing the German report, but I prepared it with my colleague Anna Albrecht, who's also here. So I'm going to present our shared work. And this was the introduction, so we can skip to the meat of the presentation. I'm going to talk a bit about the implementation in Germany, so the state of play, and then I'm going to focus on two approaches that our legislator used, which we have called the laissez-faire approach and the literal regulatory approach. I think my colleagues will probably recognize somehow what this might be. And then I'm going to finish with brief conclusions. Actually, I was going to talk about the view foreigners have of Germans, which is that Germany is very efficient and organized. And I would say this is not completely the case with the implementation of these directives. However, having heard some issues in other jurisdictions, I would say we are not that bad. because at least our legislator managed to transpose all 6 directives, but only 2 of them were transposed on time. And it's interesting in comparison to the Polish report that it was the first 2 that were transposed on time, and all other directives were transposed half a year too late. And we don't have the excuse of a political change of climate or anything like this, because our chancellor was chancellor during the whole time. And so I think the reason might lie within the directives, because I think the first 2 directives were the least controversial and the ones that were the easiest to implement, because it basically required a bit more paper, and actually that's not new for Germans to have a bit more bureaucracy. But the other directives would have or have required more substantial changes, and so this is probably the reason why it took longer to implement them. So, and we can look at the, what's this?
I'm not very able to help you.
No, it's fine. We're going to, I want to talk about these 2 approaches, the laissez-faire approach and the literal regulatory approach. The laissez-faire approach is the one that is signified by this picture above. You must imagine that this is the German legislator trying to implement the directives, and laissez-faire means it doesn't do much. Because this is something that we have already heard often today, that many legislators are of the opinion that their law already is compliant with what the directive asks for. And this is because most of the guarantees are already also set down in the European Convention on Human Rights. So laissez-faire means only minimal changes to existing for a very minimalistic approach. But there's also some evidence in German law that the legislator did changes to the law and stuck very much to the wording of the directive in order to comply best with the directive. And actually both these approaches have led to problems in the interpretation of the law, and I'm going to discuss 2 examples and point out some other areas that are problematic. And the first example I want to talk about is the lawyer-client confidentiality as an example for the laissez-faire approach. And you all know Article 4 of the Directive 2013/48 EU, and I've printed it on the slides. So member states shall respect the confidentiality of communication between suspects or accused persons and their lawyer in the exercise of the right to access and so on. And the German legislator pointed out that this right was already fully respected in German law. And if you look at the German law, it's section 148 of the German Code of Criminal Procedure they're talking about. And paragraph 1, the accused shall be entitled to communicate with defense counsel in writing as well as orally, even when he is not at liberty. This is the provision that is supposed to be the confidentiality guarantee. And what is missing in this provision is the word confidentiality. The accused shall be entitled to communicate, but it's not written anywhere that this communication is confidential. It makes sense to interpret it in the way the German courts and scholars and everybody does, that of course this entitlement includes confidential communication with the defense lawyer, but it's not written anywhere. The second problem with the German legislator's assessment is paragraph 2 of this section 148, because this is an exception for terrorist cases. And in these cases, confidentiality is not guaranteed. And this exception is nowhere to be found in the directive. It's found in the recital, but the value of recitals containing exceptions to an unexception, to a general confidentiality clause, it's problematic. In my opinion, the recital is not sufficient to provide for an exception to the rules. So I would say that German law is not compliant with the EU directive. And it gets even more complicated if you look at written communication, because written communication could be seized under German law, at least if you read the provision, because written communication is excluded from seizure, written correspondence between the accused and a person who may refuse to testify. This is a defense lawyer. But these restrictions shall only apply if these objects are in the custody of a person entitled to refuse to testify. So according to the wording of the German law, written correspondence between the defendant and his defense lawyer is only excluded from seizure if it's in the possession of the defense lawyer, but not if it's in the possession of the defendant. This is not the law as it is in Germany, because this section 97 is interpreted in view of section 148 to mean that, of course, written correspondence with the lawyer is confidential and cannot be seized. But I mean, how are you supposed to know this if you're not a German lawyer who has studied criminal procedure law extensively? This is where the CrossJustice project can help, because we explain all this in the database. But I would say that this is not a transparent and clear implementation of this confidentiality guarantee. And similar problems exist with other implementations and other directives. And one example is penal orders. It's a bit difficult to explain. A penal order is a way to end criminal proceedings without a trial. It's a written way. It's for minor criminal offenses. And basically the German law as it is allows it for this to be final and come in effect even without the person having been informed. This is because the problem of penal orders and the special rules were overlooked when implementing the directives 2010 and 2012. Another example is the presumption of innocence. We've already heard a lot about this. German law, the German legislator did the same as others did, and just said, well, of course the presumption of innocence is respected in German law. There's no need to change anything. But there is no rule anywhere written down on the presumption of innocence. It's just something that you have to gather from the Constitution and know that it is respected. So in practice, the German legislator was right, but finding some provision or communicating with foreign lawyers is difficult in this respect. And remedies, there are another topic. The remedies seem to be complicated in nearly every jurisdiction, and the same is true for Germany. They did not enact remedies or some special remedies for violations of the directives. The general remedies are very difficult to find, and there's also no rule on the admissibility of evidence or inadmissibility of evidence that was gathered in breach of the directive. It's the same as in the Netherlands. So it's up to actually the arguments made to make this, to exclude evidence that was gathered in violation of the directives. These are the problems with the laissez-faire approach. The literal regulatory approach leads to different problems. And one example is the translation of judgments. According to the directive, any judgment must be translated because it's an essential document. The German legislator, when implementing this directive, only referred to non-binding judgments. The first problem is that judgment and judgment are not the same. Judgment, as meant in the directive, means any final decision on criminal proceedings. Judgment in German law means final decisions after an oral proceedings. So it's narrower. And there are also court orders in German law, Beschlüsse, which might end proceedings and which are not judgments. So the use of the word from the directive has, because of the context of German law, led to actually a non-compliance with the directive. The other problem is this restriction to non-binding judgments. And in order to understand this, you must know that German judgments are delivered orally and are translated during trial. And the written version usually follows 6 weeks later. But the time for filing an appeal is 1 week. So actually a judgment can become final and binding before the written version is made available to the defendant. And so that's why because the directive is restricted to, well, non-final proceedings, the German legislator chose to restrict the translation to non-binding judgments. And in our opinion, this was a wrong choice, because the spirit of the directive is to inform the person about what actually they are convicted for. And if this judgment is not translated, then how are they to find it out? And there are also some other reasons why the defense rights should apply to these written judgments. It's just the German peculiarity of splitting it off that leads to the situation that this judgment is not translated. However, our Supreme Court did not follow this argument, because they said that this was okay and this was a good interpretation of the directive, and there was no need to ask the European Court of Justice. So let's see how things play out. And there are other problems with this literal regulatory approach when the German legislator tries too much in sticking to the directive. And many problems exist with the directive on legal aid. This is because the system of legal aid comes from the idea that people who are in need of funding can apply for funding to get a good criminal defense. But the German system is based on the idea that particularly serious crimes should be defended, whether the person wants it or not. So it's a system of mandatory defense, and it's completely different reasoning. And when the German legislator tried to implement the directive into the existing system, there were many problems. For example, they implemented rules that only apply to mandatory defense, but not to elected defense, and that the directive applies to both types of defense. Or there's still some obligation to pay fees if you are convicted, even if you have this sort of mandatory defense. This is a difficult topic, but this is a point where you can see that it just didn't work out to try to implement the directive into the existing system. The legislator ought to have changed the system in order to comply with the directive. And the same problem exists for juvenile defendants and children, because they should have had mandatory defense in any case, and the German legislator did not do this because it didn't fit the system. So altogether, you can say both approaches, the laissez-faire approach and the literal regulatory approach, can lead to problems. Although, actually, I should stress that the German legislator did not do a really bad job, because many changes were okay, and the assessment that no changes were needed was also often okay. So I wouldn't say that the whole German law is completely in breach of EU law, but there are some instances where it could have been better. And because always, if changes were required, the approaches were just problematic because it wasn't thought through enough. So actually, I think the German legislator should put more effort into implementing the EU directives and think a bit more about problems with existing law and make some necessary changes as they can look up in the CrossJustice project. Many thanks for your attention.
Thank you, Professor Anne Schneider, for your very interesting and deep analysis on both the two aspects, laissez-faire approach and literal regulatory approach. And thank you also for respecting the time so that we could have a place and room for question and answer. Now I give the room to Dr. Costa, Miguel João Costa, and Professor Pedro Caeiro, but Professor Pedro Caeiro is not with us today, from the University of Coimbra. Thank you for being here, and please, you have the room. Miguel João Costa comes from the University of Coimbra and wrote the National Report on Portugal. Please, you have the room.
Thank you very much, Professor Vittorio. I would like to start by greeting my, is it working or? I think so. I would like to start by greeting my fellow speakers of this panel, whom I had the pleasure to know beforehand. I would like also to salute everyone in the room, and above all, I would like to thank very much the organization of the conference and the management of the project for the amazing work that they have done, and also to thank them for giving me the opportunity to present our work here. Also, for personal reasons, it's a great pleasure for me to be here in Bologna. So for all possible reasons, it's really a joy for me to be here before you, delivering this presentation. As Professor Vittorio said, I was one of the reporters for Portugal. The other reporter was Professor Pedro Caeiro, who could not be present here. So I have the task of presenting our findings. I will be focusing on some specific aspects concerning the transposition of the directives in Portugal. The EU directives mark the first moment when EU legislation has been enacted specifically aimed at protecting citizens against punitive power by the member states without any specific transnational EU elements. So it's a sort of a constitutional, a foundational moment in EU law, this harmonization of this increase in procedural rights, regardless of any direct transnational EU connection. So, which is yet another reason why this project is so important. In the face of such an important moment in EU law history, how did the Portuguese legislator react? Well, mainly in a passive way. So the Portuguese legislator has considered that most of the norms of the directives were already covered by pre-existing legislation, and so it decided that only one of the 6 directives required explicit implementation. So I've heard some of my colleagues also in the morning, but maybe especially in this panel, whose member states have explicitly implemented at least a few of those directives, and even so they have been reluctant to call this a progressive approach. So what can I say about my own member state? It falls within the dichotomy that has been established for the purposes of this panel between minimalistic and progressive. My member state certainly falls, without any doubt, within the minimalistic approach. Only one directive has been implemented, namely the one on juvenile defendants. Maybe the two approaches, I'm just saying this off the top of my head and also after hearing my fellow speakers, maybe the two approaches are not completely incompatible, in the sense that if the legal system as it already was in place is progressive, then you are free to take a minimalistic approach because it's just not necessary. But I wouldn't expect this to be the case in most situations, and I don't think this was quite the case in Portugal, although the situation is not particularly problematic either. I will try to be clear about my view as to the levels of implementation that we have attained in Portugal. But so, because none of the directives, apart from one, has been explicitly implemented, it's only natural that we find a significant number of deficiencies of implementation, which can take on basically the shape of two different things. In some cases, we find actual implementation gaps, norms in the directives that have simply not been implemented into the Portuguese legal system. And we find, more than anything, many cases where we have serious doubts and we have to struggle in interpretation to determine whether or not the provisions in the directives have been implemented. I would say that this modality is the most representative one. There are many cases where it's difficult to determine whether or not the norms in the directives have been implemented. Moreover, and also unlike the case in some fellow member states, case law is also extremely thin. Explicit reference to the directives is quite rare, and in the rare cases where we find explicit reference to the directives, that's basically aimed at just saying that there's no problem anyway because our law already complies with them. So basically it's a replication of the assumptions made by the legislator. Although I should say that around 70% of the cases that do make explicit reference to the directives have been delivered over the last 2.5 years or so. So maybe it's not too optimistic on my part to assume that a new trend may be emerging of increased reference by the courts to the directives. And then there is yet a third type of implementation problem, as far as we could see, which relates not really directly to national law, but which relates to difficulties in interpretation of European law itself, of the directives themselves. In some cases, it's not fully clear what the directive is requiring from the member states. And this applies, of course, to all member states, but maybe the situation is more problematic in those cases where the member state did not enact explicit legislation, where it could somehow replicate some of the concepts used in the directives, which in turn could then gain some life of their own in the national legal system, interpreted by the courts and so on. But let me try to illustrate this type of problem that I mean by problems concerning the interpretation of the directives themselves. For instance, Article 3, Paragraph 2 of the Directive on Access to a Lawyer provides for a right of access to a lawyer in a number of procedural acts. This is, of course, one of the, I would say, emblematic provisions in all the directives. It's been widely addressed here today, and I'm not going to be an exception. The Portuguese law entitles defendants to a right of access to a lawyer in all of the cases mentioned in Article 3, Paragraph 2. And actually, in many of these cases, it's not just even a right in the subjective sense of the term, but also the presence of the lawyer is mandatory. Even if the defendant would not wish for a lawyer to be present, the law requires a lawyer to be present. That is the case, for instance, in any interrogation carried out by the public prosecution or a judge. However, not all the cases listed in Article 3, Paragraph 2 of the directive are cases where Portuguese law imposes the presence of the lawyer. For instance, it does not impose the presence of a lawyer in interrogations carried out by the police, which is also, as we've seen, a hot topic. We've seen that today. And the difference, then again, this was addressed, for instance, in the previous panel, the difference between interrogations before the public prosecution and or a judge and the police is that the statements made before the police cannot be used later on in the trial as evidence. Now, I note that statements made before the police, the relevance of these statements lies beyond the question whether or not they can be used as evidence later in trial. But I would say that for different reasons, which maybe I do not have time to address here, in the Portuguese legal system, the statements made before by the defendant before the police do not bear such a weight as it seemed to me to be the case in other member states, towards the final outcome of the procedure. So ultimately, the most important factor is indeed whether or not they can be used as evidence later in trial. But so the question is, when the directive provides for the right of access to a lawyer, does it require the defendant to simply have a right to have a lawyer present, or does it require member states to proactively guarantee, perhaps to make it mandatory for a lawyer to be present in those procedural acts? If the answer is A, then Portugal does not comply. If the answer is B, then Portugal, rather the other way around. If it's not mandatory, Portugal complies. Otherwise, there are some cases where it does not. And as far as I'm concerned, I don't think this is fully clear just yet what the scope of the directive is in this regard. And incidentally, also off the top of my head, since the problem in Portuguese law is whether the statements can be used as evidence or not later in trial, actually making it mandatory to have a lawyer present in interrogations before the police would have a counterproductive effect, because we wouldn't be protecting that much in addition to what we already have, and it might be an open invitation for the legislator to then admit evidence statements made before the police in the early stages, where right now this is not possible. It would be one of those cases of over-implementation, if you will, where like the legislator takes a ride along the EU legislator, and it takes the directives to do things that it already probably wanted to do, but had no real good justification to do. So another example of doubts which relate also to the interpretation of the directives themselves. It's the second and final example that I bring. Trials in absentia. Article 8, paragraph 2 of the Directive on Presumption of Innocence requires that the defendant has been informed of the date of the trial. I quote it. So in Portugal, the situation concerning trials in absentia is as follows. Very early in the criminal procedure, the suspect, which is very quickly constituted as a formal party to the procedure, must provide to the authorities truthful information about his or her place of residence. And he is informed, when he does so, he is informed that he has a duty to report any change in his address during the course of the procedures, and that he will be notified by regular mail throughout the procedure of any relevant procedural act to that address. And he is informed that if he fails to receive this notification by regular mail, then he can be legitimately tried in absentia. So the defendant is not required to sign any reception form confirming that he actually got knowledge that his trial was going to take place. In fact, this solution was developed not too long ago in reaction to what was perceived as a problem, a profound problem in Portuguese criminal procedure, where defendants would try to avoid signing the reception form, and this way the trial could never be appointed, the date for the trial, and then they would never be tried. And so we would have criminal procedures that would be excessively long. And so this ingenious, I would say, solution was created whereby kind of the burden of the responsibility for being informed of the date of the trial was shifted to the defendant himself. It's tricky. And so what this means that it is theoretically possible that a defendant is not aware that his trial is going to take place because he might not receive the notification for a reason other than being actively avoiding being notified of it. And so the question for European law is, when the directive says that the defendant must have been informed, does this require actual confirmed knowledge, objective knowledge of the date of the trial, or can the defendant be presumed to have this knowledge if the state sought to provide this knowledge to him, but this was not possible for reasons attributable to the defendant himself? If the answer is A, then Portugal does not comply. If the answer is B, then Portugal complies. So I think the point is made as far as this type of problems are concerned. So, all things considered, in our study, we have ranked the implementation problems in Portugal according to quantity and quality, and we have concluded that we have basically four groups of directives, or four groups of four clusters of problems. We have situations where we have few directives regarding which we have few and not very serious problems. This would be the best scenario, just a few and not very serious. Then we have the situation where the directive has many but not very serious implementation problems. Then few but serious implementation problems. So the middle ones, we gave preference to the qualitative criterion. That's why it ranks a bit worse than the former. And then the worst case is where we find numerous and some of them serious implementation problems. This would be the case of the directive on the right of access to a lawyer, precisely. And in fact, more recently, we have received confirmation that the directive on access to a lawyer is indeed the most problematic for Portugal, as the Commission initiated infringement proceedings against Portugal concerning this directive late 2021. So, involving the issue of the derogation of the right of access to a lawyer and to have a third party informed upon deprivation of liberty in a, not only but mainly in a case where the defendant is being prosecuted or investigated for terrorism. But I guess I don't have time to go into detail. But so it was, so it confirmed the somehow the assessment that we had made for the purpose of the project, although of course it was with sadness that we realized that these infringement proceedings are taking place. So, but more than, since it's not possible for me to provide you with a list of the problems that we found or the gray areas that we find in implementation of the directives in Portugal, I would like to conclude my intervention with a something of a more abstract, of course, necessarily also a more subjective analysis of what we believe are the causes and the nature of these implementation problems in Portugal. Maybe it's not specific to, maybe this tentative explanation that we provide is not specific to Portugal, but maybe it has some parallel also for other member states. I wouldn't know. And this explanation draws on a historical analysis of Portuguese criminal procedure across the 20th century. So Portugal was under an authoritarian regime until relatively late in the 20th century, until the 70s. And it was only in the 80s that a fully fledged new democratic code of criminal procedure was enacted. Of course, many things were changed immediately after the revolution in the 70s, but a fully fledged code was only enacted in 1987. At this time, other European countries were already concerned with rebalancing individual rights with emerging threats such as terrorism and highly organized and transnational crime, and Portugal was still enacting the first clearly protective criminal code, right? And the code was devised in outright antagonism with the former authoritarian state of affairs. And so it was a set of rules that indeed was and still is, I think, very protective of individual rights. In fact, in many cases, the Portuguese criminal procedure goes further than the directives. I think this probably happens a bit in some cases in all member states, but it's also true certainly for Portugal. In many cases, it goes further than the directives. But so what this recent history might mean is that the legal community in Portugal perceives its criminal procedure tradition to be protective or even lenient in some cases. And this probably helps to explain why the legislator and the courts and even legal scholarship, which should normally be expected to be more critical than the former, to assume that Portuguese law complies with minimum standards in terms of criminal procedure. Because I do not think, and I think this separates Portugal maybe from other member states, I don't think there's an attitude of resistance in Portugal in either sector, either in government or in the judiciary or in legal literature, against European law in general, in European criminal law. For instance, there is no resistance whatsoever to the implementation of mutual recognition legal instruments, implementation and effective application. It's very difficult to even find the European arrest warrant that has been refused from Portugal. They are generally granted to the executing member states. So there's a clear commitment in Portugal to the European project as far as European criminal law is concerned. Of course, there are differences between mutual recognition and harmonization, which partly explain the difference in attitude, and I cannot go into that. We all know that. But the difference is overstated in the case of Portugal. I mean, those reasons that make this difference between mutual recognition and harmonization are not sufficient to explain this passiveness in relation to the implementation of the directive. So I would assume that it relates that this tentative explanation might be the piece that was missing, that helps to explain this passivity or passiveness in the implementation of the directives. And so I would conclude by saying that the fact that a criminal procedure in a certain member state can be considered as satisfactory or even as good, as protective, is not a reason for that member state not to remain open to more ambitious goals, as is the case now with the EU, which is bringing forward higher standards. Why not remain open to that, even if you think that what we already have is good enough? One thing does not just justify the other, and that more self-reflection is necessary. And this is also why a platform such as the one developed in this project may be of great avail. I suppose the more passive the legislator is, the more important it is to reach out directly to to the legal actors, to the judiciary, to the prosecutors, to everyone else involved in the criminal justice system, and maybe change can be brought from there, as was mentioned in another intervention, in a more sort of bottom-up approach than a top-down one. And so, to conclude, as I started, by commending this project for the tool that it has provided, and now it will be up also to us in our member states to spread the word, which I will gladly be doing in my member state. Thank you very much.
Thank you, Professor Dr. Miguel João Costa. It's very interesting to compare your different experience. I think that each of you is giving us a really peculiar point of view, and starting from your viewpoints, the problem, the issue of transposition approaches and implementation problem is getting more and more interesting, complex, and challenging maybe. But now I finally leave the floor to Dottoressa Maria Vittoria Catanzariti, a research associate at the Robert Schuman Center for Advanced Studies, representing here the European University Institute. So happy welcome here. The European University Institute is a partner of this project, and I'm very glad to have you here. Thank you, Maria Vittoria. You have the floor, please.
Can you hear me? Do you mind if I wear the mask? Okay, thank you very much. Thank you, Chair, for the kind presentation, and thank you, the organizer, Professor Caianello, and also Professor Lasagni and Professor Contissa for this kind invitation, which I'm very happy to have accepted, despite the very hard times that we all have lived. And it's a great joy to meet together again. And just a couple of words about the task of UI within this project. Thank you, Julia. Because today I will intervene on a different note, but it's important to shed light for a minute about the task of UI within this project. UI was very, very happy to be part of the supervision process of the national reports, and I'm very happy to be in a good company with Miguel João Costa and Anne Schneider, not to mention Adriano, just because UI was responsible of 4 national reports within the project, so the Portuguese, the German, the Swedish, and the Romanian report. And we were really happy and proud to be part of this process of supervision, which was of a great quality, not just to be sincere, really, because it's right to say things as they are when we are very good results in a research. And UI was also responsible of a UI training, a transnational training with national and foreign legal professionals last years, which was somehow successful and brought together academics and legal practitioners, asking whether the implementation measures of the 6 directives on procedural rights were, in a sense, facing shortcomings or positive findings at national level, and was also responsible of drafting a user manual, which is a very practical guideline based on case sheets and very practical scenarios that draw from the 6 procedural directives. So today I will intervene on a different note because things, of course, go ahead, and together with my colleagues, we had a chance to discuss a bit about the positive consequences, arguably positive consequences of data-driven law in this sense. And this is really an experimental conceptualization, experimental reflection that was convened in a chapter which is included in the book, which is another finding of this project, which will be published by Brill. And it's about an idea. This idea is regards the role of data protection towards procedural rights. So I decided to entitle this presentation Procedural Rights Through the Lenses of Data Protection, which is the focus of this reflection. I don't know if... Okay. So the focus is based on 3 basic aspects. First of all, suspects and accused persons can be overlapping with data subjects under the data protection tools. There is an interplay of Directive 13 on information rights and Directive, the so-called Law Enforcement Directive in the framework of data protection reform on the data processing for investigation, and given also to the fact that there is an increasing large-scale gathering deriving from the access by public sector data to personal data on a large scale, there is also a blurring of legal boundaries in a sense. These legal boundaries, of course, are many, and they are not only jurisdictional because of the cross-border nature of data, but there are also a boundary, for example, between individual and a collective dimension, because we know that, of course, law enforcement authorities are increasingly accessing personal information, not only on a targeted basis, but also on a collective basis. So the boundary between the collective and individual dimension is also blurred. There's also a blurring of legal boundary regarding substantial rights and procedural rights. This is the focus of this short presentation. So the hypothesis is that data protection can be a trigger for a better procedural rights protection. This is, in a sense, the way in which the European Court of Justice in the last decade, at least in the last decade, has tried to intend things, not only in Europe, but arguably globally. And this kind of hypothesis is supported by some reflection. First of all, to what extent data can be used as evidence and in general trials? Second, suspects or accused person can be data subject, but this has, in a sense, substantial meaning, going beyond the labels of information rights that are, of course, included both in the Directive on Information Rights and in the Law Enforcement Directive. And there is also a very tricky point, which is part of some shortcomings that have been addressed by the European Court of Justice case law, but not only by this, also on a legislative layer, is not clear enough whether an individual may be subject to an investigation without knowing if their data is processed. Of course, there are similarities in the rationales of these different legal tools. And I refer in particular to the access to the material of the case and information rights and access rights. So the really tricky point is the following. If the material of the case encompasses certain data records regarding the suspected persons, then access to the material of the case easily becomes also a right to access by data subjects. So this is, in a sense, the worry about. And we can easily confront the text of the directives, and we can easily realize that labels are quite similar. For example, we have, of course, Article 4 of the Directive 13 of the on information rights, which is on the letter of rights, and there is a parallel between letter of rights, which has to include the access to the material of the case, with the information rights under the law enforcement directive. But parallels are also others and are related to access rights and limitation to access rights in the case of investigations. And there are also other safeguards which are more detailed, in a sense, in the law enforcement directive, and regard particularly the access to logs of the file that can be accessed by the data subjects. The point is that in the information rights directive, we don't have a guarantee such as the one provided by Article 44 of the Law Enforcement Directive. And the idea is that if data subjects' rights are infringed as a result of an unlawful processing, this particular case is not addressed by the Information Rights Directive. So in this sense, Article 44 of the Law Enforcement Directive can be envisaged as the good way to address the right to an effective remedy in case in which the violation of law enforcement directive substantiates in unlawful processing. You are maybe all aware of the data protection saga with respect to data retention cases. And this saga is very long. It started with the case Digital Rights, then Tele2, Ministerio Fiscale, and Opinion PNR. I cannot go in detail in this presentation, but this is very interesting because data retention was intended by the Court of Justice of the European Union as the linkage concept to data protection safeguards in order to expand certain protection, certain safeguards, and refer these safeguards to other areas of the law. This is interesting. And just briefly to summarize the main findings of this jurisprudence strand, the first point was, of course, to address the specific criteria to assess the legitimacy of data gathering. So there were elaborated precise criteria on the presence of a serious crime in some of these cases, strictly necessary measures to combat serious crime, judicial or independent administrative review authorization, information rights of data subject as necessary safeguard for a lawful processing and lawful data retention, and data retention located in Europe. Second point was the fact that the national legislation cannot permit, for the purpose of the fight to crime, the general and indiscriminate retention of all traffic and location data of all subscribers and users. This was the first phase, what I call the first phase of the data retention saga, because it is interesting because it opened up to a second phase, which for the purpose of this reflection is maybe more peculiar. And what is new in the CJEU's reasoning in the last couple of years. So we have basically three cases which expanded really incredibly the role of data protection as a standard setter of other protection in other areas of the law. The technical way in which these cases provided this was to go beyond the exemption of national security. The Court of Justice was really courageous in saying that national security sometimes has nothing to do with data retention because the indiscriminate use of data cannot justify in any event the link between national security and data processing. But in detail, what these cases have said. La Quadrature du Net say that national criminal courts cannot use information and evidence obtained by means of the general and indiscriminate retention or traffic or location data in breach of EU law. And we are talking about, in particular, Article 7 and 8 of the Charter of Fundamental Rights, so data retention in violation of the Charter of Fundamental Rights. We have a second case released, I guess, the same day, so Privacy International, that extended the conclusion of La Quadrature du Net also to handovers, so also to service providers. So this is very, very interesting. And a third case, which is a very complex case, but I cannot summarize in detail as just some spots here. So the National Criminal Court cannot use information and evidence obtained by means of the general indiscriminate retention or traffic, but also stands to data access by competent authorities in breach of EU law. So this is a very strong limitation to law enforcement authorities in this sense, we can see that fair trial and adversarial principle, I like to quote a very good book on this, which is an American book, Adversarial Legalism by Bob Kagan, but this is really one of the first time that the Court of Justice has the courage to use this concept, adversarial principle. So adversarial principle are really protected when national criminal courts cannot use information and evidence as a general indiscriminate retention of traffic and location data, and this is not on the full scrutiny of a court, and is not on the full knowledge of a suspect, of an accused person, who cannot defend himself or herself before this this massive use of data. Which are the principles that I can single out from this new strand of case law? GDPR does not only apply to public authority that carry out law enforcement operation, but it applies to service providers that hand over traffic and location data to law enforcement authorities. This is a very salient point because it goes beyond what is the public activity of law enforcement authorities, and it addresses specifically the cooperation dimension between private actors and public actors in accessing private sector data. Second point is that the generalized and indiscriminate data retention does not have any link with the exemption provided by Article 23 of GDPR, which says that data subject rights can be curtailed, in a sense, if we deal with law enforcement operation. Third point, a court must disregard information and evidence obtained by means of the general and indiscriminate retention of traffic and location data in breach of EU law in the context of criminal proceedings against persons suspected of having committed criminal offenses. So this is really something that is new in the constellation of European law. Just to conclude, I want to bring to your attention some reflection in order to see and possibly think about which is the way forward and what we expect from the future. So first of all, data protection safeguards have been an object of a meta-judicial reasoning in order to expand parts of EU law towards other areas. So there is maybe a risk to overload a phantomatic data protection zone. And of course, this is very visible if we think about the global reach of EU law through data protection as standard set and the whole that has been the judicial activism and after the EU cloud adoption, for example, by United States. If you think in terms of geopolitical order, these things, of course, acquire a specific weight. But I feel to conclude with a humble reflection that pertains to this. So the law should then be aware enough of the instrumental use of technicalities to preserve those principles and rights that technicalities address. What does it mean? That a very strong law in the positive sense of the term does not tolerate forcing. So we should be aware of the instrumental use of data protection in this case, but of other possible principles in order to expand certain safeguards, but it's after all always law, so it's the best or the worst side of the law is the good or the positive side. So thank you very much for your attention.
Thank you. Thank you, Dottoressa Catanzariti, for your brilliant speech and Dottoressa Alessandra Sant'Angelo, University of Bologna, homemade.
So many thanks. I'll try my best to answer this question very briefly. So there are a lot of topics, and no, unfortunately, what we have acknowledged by asking questions to the practitioners, and among them we had judges and prosecutors is that directives and their implementation are not frequently applied in the case law, so nor in lower courts case law, neither in the case law of the Supreme Court, even less, I would say. And so, if anything, the reference is the reference to the case law, in the case law to the directives, is as formalistic as its implementation. So it's purely cosmetic, as I think I mentioned in one of my slides. So rather cosmetic and not substantial, which may give the impression to practitioners that it doesn't really make much sense to invoke EU directives, and it, would be probably a better solution to go with a safe pair of hands of this ECHR, which will speak the same language that judges are used to. And yes, on the other hand, the upcoming legislation in the Netherlands is very much geared towards implementing the Strasbourg case law, which of course is long overdue. Whether and to what extent the modernization of the Dutch Code of Criminal Procedure will also review some of the legislative changes that have been made to implement EU directives is still unknown, but it could be expected that this will happen in a sense by making EU directives and the whole criminal procedure more adversarial. So that is the short answer, not that short, unfortunately, to your question.
Thank you, Dr. Martuffi. We also have a question for Maria Vittoria, I think in the chat. Can you exactly read it?
I can read it.
Okay. Please.
Okay. Sorry. Okay. So someone, Isadora, asks whether there could be a relation between data subjects' rights on information and the use of artificial intelligence in the law enforcement domain. As opposed to the GDPR, it seems that law enforcement directive does not include the use of automated means of processing among the information that should be provided to the data subject. Do you think that this gap could curtail the positive effects the data protection legislation could have on fair trial standards and the rights of the suspect accused? Thank you. So thank you, Isadora. If I may, there is an equivalent provision in the Law Enforcement Directive as Article 11 of the directive, which is basically the same, of course, with a set of safeguards which is not possible to warranty in the law enforcement domain. But basically, the right is the right to human intervention, and it's the only right, possible right in the field of artificial intelligence and data processing, either in law enforcement and in civil matters. And this means that accused or suspect in this specific case can have the right to be judged by a person. So artificial intelligence can be only considered as a means of support of judicial reasoning, but not, of course, the core of the judicial decision. And the person has the right to obtain not only the clarification about the algorithmic code, but also the readability and the explainability of the code in this sense. So, of course, the discourse is very complex and long. There is a very complex administrative case law, but if you want, we can interact afterwards also via email. Thank you very much.
We have another question, if you can read it.
Yes, sure. That's a question from Irene Milazzo, that's like Isadora, is also a PhD student at the University of Bologna. It's a question concerning spontaneous statements made by the suspect to the police. The Italian Court of Cassation has explicitly excluded any contrast with the directive on the right to information, arguing that the duty to inform suspects on the right to silence, on the right to a lawyer promptly leaves states a certain margin of discretion as for the moment in which such information shall be given. So do you agree with this conclusion, or shall we use as parameter for not applying the directive the fact that such statements cannot be used at trial, as was stressed before by Dr. Costa and by the Court of Cassation? And that's the question.
Yes, it is a question
And
I
then
think
there is
addressed to any of the panelists. So who wants to discuss? Answer?
I missed out the last bit. I missed out the connection between the with the Portuguese legal system. Which right? The right to remain silent. And the lawyer, no. If that came across from what I said, then that's not what I meant. Certainly not for the right to remain silent. That should be there from the outset. At least, of course, there's the problem of the shift here from the status of simple suspect and the status of formal defendant in the proceeding. It's fair for the authorities to expect an average citizen or someone against whom there's a slight suspicion to cooperate, to provide statements. It's only when a certain level of suspicion befalls upon the person that the person should be fully entitled to remain completely silent. So I guess the point here in terms of when these rights should be sort of triggered, activated, concerns an aspect that has been focused in some of the presentations that have taken place in the morning. How promptly must a simple suspect have his or her procedural status shift to a formal defendant? That must take place very early in the proceeding. If it does, then I'm okay with the fact that the right to remain silent is only triggered as of that moment. If that only happens later on in the proceeding, that you have to compensate for that somehow, perhaps you would need to recognize this right to the mere suspect. So I think there's an interplay here between the concept of, and apparently this varies a lot from legal system to legal system, of suspect and accused and formal defendant and the moment of enjoyment of the right. Regarding the use of evidence later in trial, no, I also didn't exactly mean that as long as those statements cannot be used as evidence, it is irrelevant for the person to have access to a lawyer in the procedural act. No, I think the person should always have the right to have access to a lawyer. And my point in relation to the Portuguese legal system is that since the interrogations made by the police do not bear such an influence on the final outcome of the proceedings in terms of conviction or acquittal as in other legal systems, I do not think it is necessary to make the presence of the lawyer mandatory. But the right should always exist if the person wishes to be represented by a lawyer. And then my incidental point was that in situations like that of my member state, actually making the presence of the lawyer mandatory might be an invitation for the legislator to actually decrease the procedural position of the person by then making his evidence, his statements be used as evidence later in trial. So I don't know if this addresses properly the question, or I hope so.
Thank you, Dr. Miguel. I think we are a bit late, so I will close this session not before having thanked you all for your brilliant speeches, and I'm sure I'm not only expressing my thoughts when I say that it was a really interesting session that gave us lots of ideas from many different perspectives. So once more, thank you. And now let's enjoy 10 minutes, only 10 minutes of coffee break. Thank you all.
So welcome back to the last session of our conference. This last session is devoted to computing and legal informatics. I must say that our project has been an example of how collaboration between jurists and computer scientists can be successfully developed. Often it is assumed that jurists, lawyers, and computer science cannot really understand each other and cooperate. They believe in different worlds. The jurists working with their eyes looking into the past, and computer scientists imagining a new future. But in this case, I think the collaboration has been very successful, and the collaboration has involved, I would say, three disciplines. There has been law, and we have our great experts in procedural law, criminal procedure. Then we have legal informatics, and then we have computer scientists. And these three different skills have merged, I would say, in an ideal way in this project, where we have established a great collaboration, scientific collaboration, as well as a very friendly interaction. I would like to thank, in particular, Giuseppe Contisa and Giulia Lasagni, who have been the kind of connecting energy, connecting network, putting together all the different trends of our project. So without further ado, I'm very happy to give the floor to our first speaker. There will be an online presentation by Professor Monica Palmirani, who is now appearing on our screens. There is no need to present her because she is very well known as a leading expert in legal informatics, has worked ranges from the management of legal documents into artificial intelligence and law. Professor Palmirani has been with us at the University of Bologna for many years, and we are very proud to have her with us. So please, Monica, you have the floor.
Thank you so much, Professor Sartor, dear Giovanni, and thank you to the organizer and in general to this very relevant project that, as you said, join and merge different disciplines together. We are taking great inspiration from the output and the outcomes of this project, also for two new projects called Artificial Intelligence for Justice, a UN University for Justice, Italian projects funded by the Regione Emilia-Romagna, the first and the second by the Ministry of Justice of Italy. And my presentation briefly wanted to introduce our methodology. And as Professor Sartor said before, and also my colleagues can present later on, we believe in a hybrid AI methodology where different kinds of technology are merged together in order to mitigate some potential risk coming from only to one of these technologies. So in our approach in these two projects, we use, first of all, legal XML for modeling the structure of the document, data analytics for understanding phenomena of the data, and also phenomena that can be detected inside of the databases. And on the top of that, we can put symbolic and not symbolic artificial intelligence techniques. We encountered in our experiments different issues, especially when we apply machine learning in the legal domain. We detected the problem that machine learning is focused on a granular sentence, but in the legal domain, we needed to understand also the structure of the document and to relate each other piece of the text inside of the law or inside of a case law. So we needed to combine obligation with exception, duty with the penalty. So a pure ML approach is not enough. Additionally, we have a problem of the content and the context. Also, machine learning alone without a semantic context is quite problematic because we needed to add other important elements like jurisdiction, temporal parameters. And again, also the past versus future is a very important pillar to take in consideration in order to create a model where the new events can emerge, respect the past, and also internal and external information should be detected. I give an example. If we have Article 3, the machine learning can detect immediately the differences between Article 13 because there is only a little distance between the two tokens. But obviously in the legal domain, Article 3, Article 13 can talk about completely different topics, and we needed to detect the origin of the external information and to inject inside of the model. And also the evolution of the time, so modification of the law can influence the analysis of the case law. So for instance, in our model, we try to understand if the case law is based on abrogated law, and in case of abrogation of the law as a pillar of the decision, the final decision, we can apply some mathematical evaluation of the case, and so we can have a dynamic model. We have some example here. So if you ask to artificial intelligence if a UK citizen is still in Europe, probably the past influence too much the decision, and so it is possible that an artificial intelligence can not take in consideration the very recent Brexit event. And also there is a problem of unique case law like Schrems 1 and Schrems 2 that are very brilliant decision but unique in the scenario of the European of the Justice Court. And finally, also we need also to take in consideration some problem of transparency in terms of explanation of the result of the artificial intelligence behavior, and also to explain the output of the artificial intelligence. What we intend to do inside of artificial intelligence for justice and University for Justice is the following. We intended to apply hybrid AI for document automation, so to detect patterns of some templates inside of the case law, so to isolate a frequent portion of the language used frequently by the judge, and to understand the meaning in terms of impact inside of the drafting of the judgments. We intend also to apply clustering inside of the case law in order to support the judge with the visualization of the similar case, or to pre-classify case law in order to help the judge to elaborate pre-exam or pre-admissibility or inadmissibility of the case law, like in the Constitutional Court, on a High Court, or in the appeal, and so to help the judge to pre-classify the case law and predict the length and complexity of the case law for better organized agenda of the judge, and so to have an impact in the management of the organization point of view. And finally, we wanted to detect the similarity of the case law. We already apply similar techniques in the legislation. So this is a similarity index calculated inside of implementation of a European directive, Italian implementation, and we calculated how much the Italian implementation are close to the European directive. And we applied also analysis of a language in order to detect how much a legal text, in particular legislation, is close to such policy defined at the European level. In this case, is an index for calculate how much a law is close to the digital transformation, digital ready, so-called index. And finally, we detected inside of the last 10 years of European legislation the derogations, and we connected with the destination in order to create clustering of derogation of the law and to propose in a visual way using also the semantic classification of irrevocable. using these kind of tools applied to case law, we intend to create also a dashboard for the human being readless and to apply some important principle like human in the loop and human in command. So this is a project, and these are the main goals that we are working with the hybrid AI.
Thank you very much, Monica, for this great presentation. When we have you have shown us the prospects for legal informatics and artificial intelligence in the law. Within our projects, we have not yet realized all of these objectives. So don't worry, as you are going to see, we are still moving a small step forward. But it will fit. It fits within the vision that you have just sketched. Thanks a lot for being with us. Now I'm very happy to give the floor to our next speaker, Professor Luigi Di Caro from the University of Turin. We have an ongoing long collaboration with Luigi, and we have much appreciated his very high competence in computing, linguistics, and also in legal informatics, since he has been working in this domain for many years with great results in a number of projects. We are also very happy to have him as a friend, and we enjoyed very much the collaboration with him throughout these and other projects. So thanks for being with us, Luigi, and you have the floor.
Okay. Can you hear me? Yes. Okay. So thank you very much, Giovanni, for this presentation, this introduction. And thanks to all of you, and especially to Giuseppe and Giulia and Galileo for all the support during these 2 years and a half. And it was very good to collaborate together in these years, and I hope to keep collaborating with you along the next futures and projects. So with this presentation, I will talk about some of the results we obtained in the CrossJustice project. And the name of this presentation is Analogical Definitions and Harmonization of Laws. So basically, these are the two main works we have made at the University of Turin within the project. And let me also introduce my colleagues at the University of Turin, Emilio, David, and Hio Humphreys, which helped me a lot in these years. Okay, so the two objectives are, as you see here. So the first one was about the creation of an ontology of definitions. And the second one was about the exploitation of textual similarity techniques to measure somehow how European directives are implemented and with which kind of harmonization among the implementations. So, okay, why an ontology? Okay, of course, this is the basic notion of ontology and legal and ontology from the perspective of computer scientists. So to help legal practitioners understand the contextual meanings of terms, this is very important, especially when terms have not just different meanings, but they change over time and they can be different across countries. And of course, we had to provide some supporting systems and knowledge model for the creation of rule ontology and reasoning processes. Okay, so we started from the data we had. So the 6 directives of the project, which are here listed here. And so basically, we started from looking at these, the articles and the recitals. These are just some numbers behind the data. And what we wanted to do was to first analyze the complexity of the data and to understand which kind of definitions were contained in the directives. And surprisingly, what we found is that classical definitions, so the classical way we can think about definitions like this, X means Y, or X has the meaning of Y, or X refers to Y, something like that, which are very known to be present in dictionaries and vocabularies. There were very few definitions of this kind in our data set. Most of the time, so here, for instance, an example, the term lawyer in this directive refers to any person who blah, blah, blah. This is very classical definition, but most of the times definitions are somehow imprecise or incomplete or hidden and spread out over the text. And so they are not clearly marked out as definitions in the directives. For instance, only I guess on 2 out of the 6 directives, there is a specific section on definitions, okay, with few definitions, classical definitions. And the other 4 definitions, 4 directives, there are no sections of this kind. And surprisingly, this kind of non-classical definitions are more frequent than the classical ones. And this is very important when we want to model definitions, we want to extract them, and we want to structure this knowledge to support the work of legal practitioners and create, of course, some ontologies out of them. And so our effort was threefold, let's say. First, we wanted to identify and collect all the definitions, classical and non-classical, from all the 6 directives. And then we studied a bit the literature about how to model definitions in text. And we refined these models according to the data at disposal. And so basically we merged and create new classes of definitions. And then when we defined this model of definitions, we created a methodology for ontology building with a specific tool, which was Web Protégé. Of course, we don't have 1 hour of time, right, Julia, for discussing all these types of definitions, but there were many. And here I just present some of them. And this is an incomplete list, and I will show even just few examples of definitions. For instance, definitions by reference. I just put here an example. Okay, definitions for this, the principle, blah, 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 apply explicitly to directive X. Okay, this is a kind of definition, so you need to retrieve to identify the reference, retrieve the content, and to extract the definition out of it. Or for instance, non-example definition. Of course, these labels, so we basically invented these definitions, but there are some similarity with, of course, with the literature. The non-example definition is when you define concepts by saying, okay, this is not the case. This should not be considered. Okay, this is another type of definition that requires analogical reasoning. It is not very clear from the definitions. At least a computer may find some difficulties in extracting this kind of knowledge. Or again, parameter definition. So where you find list of parameters that concur. So basically, that can define the context of the definition of the concepts, okay, under definition, and so forth. Par definition, a typical example. So where when you have a typical example or atypical examples for defining concepts. These are very different ways to define things. And this is very interesting, not just for the CrossJustice projects and the applications, but also from for the scientific community, because we are used to think about lexical syntactic patterns to extract things and maybe even recent neural models to extract things out of text. But this is a very complex matter. And so first we need to define all the types of definition that we can try to extract examples and again examples, and then maybe we can train something that some model, machine learning or deep learning models to extract and facilitate the work of creating ontologies, dictionaries, and concepts in context for supporting any work of legal practitioners. But let's go back to the, okay, so of course this is the third part. I will not go into the details even in this part, because so basically once we identified the definitions and we labeled all the definitions on all the directives in 3 languages, which were time consuming, we had to think about how to represent as computer scientists this knowledge into machines. And so we created a model, an XML model with entries and concepts and relationships for the creation of an ontology. I have no time for going to the details, but there is a deliverable. I think it is published, publicly available, and we are submitting a research article on this. And of course, there is the manual part of creating an ontology with a specific tool, which was Web Protégé. This is just a screen to show you that we actually worked. Okay, so something about objective number 2. I want to be very brief. And a second aspect addressed by our Department of Computer Science in Turin was about harmonization. So harmonization is very crucial because basically it supports reasoning on how things are implemented and where, and which are similarities and differences across countries. So our idea was, okay, of course, starting from the annotations we had in this project. So we took the transposition tables for all the directives and made some numerical analysis. For instance, it is a kind of analytical way to proceed. So basically, we found out that, for instance, in Bulgaria, there were a lot of annotations with respect to France, for instance. So there were some differences also at that level. And then we took into consideration the different types of transposition. For instance, explicitly transposed, de facto, or non-national implementation. So basically, implementation gaps. And, oops, what I've done. So we studied a bit the distribution of all these types across countries. There were many differences, and this could be also interesting to make some reasoning. So why one country implements in one way, or in general, if some country have a lot of de facto or indirect implementations, and why. Of course, we just went in the surface of the problem, but I think it could be all these things can deserve some kind of analysis from a comparative perspective, let's say. And our aim was to apply standard natural language processing technologies. I just mentioned some of the techniques from the text preprocessing, vectorialization, network modeling of citations, which are things we have made physically on the data set, dimensionality reduction, applying cosine similarity, so similarity measures to measure how harmonized were the text, okay, so the lexical, at the lexical level, let's say even some Latin semantics behind because we use the dimensionality reduction to find differences and similarities across countries per article, at article level, at directive level, and so forth. Trying to extract candidate useful information out of this. For instance, creating matrices or heat maps to extract similar implementations, at least at the lexical level, or large differences across countries. And these tools, connecting maybe with something said by Monica before, visualization tools can be of help also in this case and within the harmonization work. So I think I finished, and thank you for your attention.
So thank you very much, Luigi, for this presentation where I think besides showing us some important outputs of the project, in particular your work on definition, you have also shown, I think, something that is very important for jurists nowadays, which is that through the kind of technologies that have been used within our project, new information can be extracted from legal sources of which we jurists may not be aware. So the new possibilities of let's say empirical legal research that are today provided by these new kind of linguistic and computational tools that you have shown to us. So thanks a lot for that. I move now in the next presentation where we have Galileo Saltore and Marco Billi, two young researchers who have worked on this project with a lot of commitment during the whole of the project. And I'm very happy to give the floor to them, a lot of enthusiasm, for their presentation, which is on expert systems for supporting the decision-making projects. So the kind of artificial intelligence tool which was embedded in the system that has been developed in the project.
Okay. Thank you. And thank you all for being here. I'll just briefly introduce and then we'll switch to some demos and examples of the platform, which may be more interesting at this point. I just wanted to briefly go back to what we said earlier today, and start by saying that our system is not a black box, but is built with explainability as one of the main goals. So we want to, we already have the rules because we have the legal sources, and we have the legal sources, as we will see later on in the next presentation. We have the legal sources with useful comments, with the national implementations all organized. So we already have the initial data. What we need is to identify the outcome, identify the relation between different legal systems, and find out what can happen in a specific case. So in this sense, we're building an expert system that supports decision making. So we can build a system that can be useful to lawyers or to judges, but also in the legislative drafting case, it can help to visualize, to identify what changes may be, what consequences may arise from changes in legal norms. So So again, we're not trying to replace anyone. We want to build a system in which the human is still in control, in which the judge, the legal professional, the legal student, scholar can find data that might be complicated, especially in the European scenario where you have to traverse different legal systems, with a symbolic knowledge base, which is modeled to reflect how the legal text has been written initially. So we're trying to be as close as possible to the original source. And we also want to enable the users of the platform to clearly see what is the reasoning process that the automated system makes. So why it gives a certain answer. These are the main objectives of our part. And for this, we started from the legal text with all the comments and the details added on the platform. And we identified the different parts of the text of the article. Here you can see an example. So we find all the different propositions, all the logical connectives, and we try to take away all the irrelevant terms that are not necessary for the representation that we want. So for a purely logic representation of what the article intended, and then we take this pseudo code and we translate it in Prolog, a logic-based programming language, with following a set of guidelines that we decided based on the input from the legal experts of the project, on the ontology developed during the course of the project, and on all the previous experience, both legal and technical. And so this can be fairly simple as in this example, but it can also be very complicated because, as we discussed previously, there can be many issues. For example, with to maintain isomorphism, we have to identify the different parts, but it may be unclear. It may be unclear, so we may have issues with vagueness, so concepts that are not clearly identified, or things that are written in an ambiguous way. So you can have different definitions, and in this case, the ontology can help to give the system a set of definitions that are based on the legal text. But this is also something that can be useful in the legislative drafting phase, because if you can identify where possible issues of vagueness and ambiguity may arise, you can either rewrite the norm, or you can try and solve these issues. And the best way to do this is to keep, as was in the previous slide, keep isomorphism to try and represent the norm as close as possible to the original text. So you're keeping the good and the bad of the original text. You're keeping also the issues of vagueness that you can then try to solve by either defining the meaning of words or the meaning of certain statements, or by addressing the issue in another way. And so this can be enhanced, and this type of representation, as we will see in a few moments, can help to identify conflict between different national legal systems, and also in relation to the European directive. So you can see where either in this case a right is not granted in a national legal system, or if that right is granted, you can go further and see for which reasons. So the reasons may differ as well. So these are all important things that we addressed in the course of the project. And just another thing, and then I'll leave to Marco. We touched earlier on the issue of case law and of opinions, be it by judges or other legal opinions. So the system that we're building can always be enhanced with other laws, other norms, with with decisions and case law. So it can continue to develop, adding complexity, but also enabling a clearer view of what the law wanted to state. And I think that now I can pass to Marco. Thank you.
Thank you. So now, just one of the last guidelines that we have to follow when writing and actually deciding to what exactly goes in the system is how to leave power to the judge, of course, because as in all criminal system especially, the judge plays a pretty big part in the whole proceeding process. So we have to state clearly what are the requirements for the application of laws, as well as leave enough room to the judge to be able to work with this reasoning, to work with the facts that are needed in order for the system to work, as well as build his own reasoning, his own argumentation on top of those principles. For example, here we have our own predicate that we have decided to use whenever the law itself states that the judge can take a decision to that effect. For example, we are going to see an example really soon about what exactly constitutes an essential document. Such a decision is not clearly defined in the system, just there are a few examples that are provided to us by the directive. And for this reason, we need to have enough room, to leave enough room for the judge to work within the limits of the source law, which is in this case the directive 2010/64, without getting too deep into what exactly are the laws applicable to this particular phase. So the next slide, we're gonna take a look at how exactly, concretely, we decided to write our system. First of all, we have decided to split up the articles that we found in the directive, as well as the national and national member state laws, which are, first of all, the main rights. So those all rights that are specifically granted by the directives and by the national laws. And furthermore, we have these two differences that we have decided to utilize. These are our own definitions. They are not found anywhere. It's just something that we, as we can say informatics, have decided to use in order to create a better structure of the system, which are auxiliary rights, which are just rights that directly regulate the legal sphere through either a temporal or subjective link. And also we have some attributes, certain attributes that are not rights. They're just properties of these rights, and there's those either irrespective of the presence, or they're just left up to the general authority to decide. Again, this distinction is not something that the directive tells us there is. It's just something that we, as informatics, have decided makes for a better structure of the purpose of our system. And furthermore, this is the distinction that we have made in the different laws. We have our own set of all the code in a single module, and we have sub-modules that are made up of the different directives. Each different directive, each different sub-module has their own sub-modules, which are made up of the directive itself and all the articles that are the transposition of that directive. These articles have the ones that are being given to us by the legal professionals, which is our teams of legal experts, and we will see that being a big help in also helping us understand what the law itself says. And I think now we can take a look at how our platform works and a little bit of an examples that we can make. Perfect. I hope it can be seen now. Wonderful. So now we have this form, and a user in this form has to insert in our system all the facts about his own case. One of the things that we have tried to achieve with this cross-justice reasoning tool is to reach a balance between it being simple enough to be used by any citizen in the member state, as well as getting more and more complex as more information is added in order to be useful also for judges and legal professionals. As it's our hope that it can also be used and implemented in the courts as well sometime, we'll see. So just to showcase one of little example that we can work, we can say that we have a person named Mario. Mario is 30 years of age. He's been accused of a certain crime, and thus he is subject to criminal proceedings. Furthermore, we can say that poor Mario has been caught committing a crime in the Netherlands. And since we are in the Netherlands, the language of the proceedings is of course Dutch. Our friend Mario, though, is an Italian citizen, and Mario is not very good with the languages, so he can only speak Italian and nothing else. He has also been issued a charge. We have to check this check mark, have any documents been issued, and we have to select that the person has been charged officially with a crime with an official document. We can also take a look at this check mark down here, which is have the judge declared a document to be essential. This is basically what I was saying before about leaving discretionary power to the judge, because the judge itself, of course, cannot count on the directive itself to tell him whenever a document is essential. So we leave the discretion, we leave the power to the judge to say, well, there isn't a document that is one of those here, but there is another document that is essential for the proceedings. So we select that we also want to see an explanation for the result of the system, and we submit our own form, and it takes a little bit to work, of course. Incredible technology, the speed. It's unbelievable. I mean, it was working so fast before.
Let's see what happens now.
Are we going to crash everything right now? It would be pretty funny. Gali?
The server is not very fast.
The server is not very fast.
Let's hope that's the only problem.
There is still hope.
There is still hope. We hope. Oh my God, come on. It's unbelievable.
Let's try again.
Let's try it again. Let's go super speed this time and not take... We are connected. It says we are connected. But it's just spend too much time explaining stuff.
Our server is actually a desktop machine at the university, so that, yes, a phone would
After
be
all
more
this
powerful,
time.
So.
Or what can you do with that? Oh, finally,
Okay.
Thank God. Whew. So close. So now we can see that the person has indeed the right to translation of this document according to the directive, Directive 2010/64 and Article 3.1. What does that article state? First of all, we can see the full text of the article itself. We can see that the article regards this, and in particular, an essential document. And why does our friend Mario have the right to translation of an essential document? It has the right according to Article 3.1, because the language of the proceeding is in Dutch, and that's a fact, something that the system has found to be true, something that the person itself has stated in the form that is true. And according to Article 3.2, Mario is asking, Mario is concerned an essential document. The case of Mario concerns an essential document. According to Article 3.2, because the person has been charged with something. And the document, the charge, is in fact, and that's something, again, we have stated to the system, that is an essential document. Furthermore, Mario does not speak Dutch, because that's another of the requirements of Article 3.1. The system does not see that Mario is in fact a Dutch speaker, and thus the system says that Mario has the right to translation. Furthermore, we can also see the distinction between auxiliaries and properties of such rights. We can see, for example, that the cost of the translator, according to Article 4, should be up to the state. And we can see instead that the form of this translation can also be oral if such an oral proceeding does not prejudice the fairness of the proceedings. Again, this is something that right now is all written in code, but we hope in the future to provide with a more natural language explanation, so something that you can just read in English and have a more easily understood by also citizens, because of course we hope that such a system is not just an helpful tool for legal professionals, but it can also bring citizens itself closer to the legal language. Furthermore, we can also now try another example and hope it doesn't break everything again, and see that there is this other button on the right. That's for national facts. These are all facts that are only present, something that we've only found to be true for national laws, that are the transposition of laws of the directive. These facts are all facts that can be quite maybe hard also for just a citizen that is not a legal professional to understand, and this is the reason why we put them on a different page also, not to have a clear distinction, a clear mix between the two. We can try and make maybe another test, and hope it doesn't absolutely destroy everything. Maybe we can say, for example, that the person is a state on detention, maybe is deprived of liberty. Yeah, we should also remove the other one first. Let's clear everything up. Let's see. Person accused. This is something I tried before, and it did work, but will it work now? Let's see how long it takes for this to work. It was quite a nice example. But if it doesn't work, we'll just have to live with whatever we can and leave it all up to you. Also,
it's a successful experiment.
Yes, I mean that was already more than we could ask for.
Too much.
Yes, indeed. In this form, also, I don't know if you caught that. There is a form that is left for comments for everybody that uses this system. We would be really thankful if you guys could take a look at it and try and also interact with the system and give us some useful feedback out of it. And yeah, I don't think we can push for more from this website. Hmm? Let's try this. Just the most. Oh, it does really work. Incredible. Nice. Let's just do an easy example then. We can see, for example, that the person has the right to access of a lawyer in the directive, according to Article 3. And the person has also the right to access a lawyer according to Italian legal system, and especially Articles 103, 56 of Italian Code, and Article 97.1. So yeah, this is just a brief introduction into the system, how the system works. And you can see these red icons on the right. These are used to showcase the conformity between the two legal systems, and it will give a red light only if the same right is expressly recognized in both legal systems using the same facts, the same status conditions that the person has added in the form. Whenever there is even only a little bit of a difference between the two, it will not give the red light right now. Again, this is something that can be further implemented with other legal sources, but for now, that's all we can find. And I wouldn't want to ask anything more from our system.
I think this is enough.
Yes, indeed.
So thank you very much. Sorry. I think I have to repeat something now. So I'm very happy to introduce Risto Konstantinov. Risto is the head of APIS Europe, a leading company in the management of legal documents and more generally on services concerning legal tech. And we have worked with Risto and his company in this and in other projects, and we have always appreciated his competence, his concreteness. When Risto says that APIS is going to do something, then they always deliver, which is not to be assumed in all cases, also when interacting with legal tech companies. So it's very good that you are with us, Risto, and I give the floor to you.
Thank you very much, Professor Sartor. It's a real honor for me to be here today and to have the really pleasant task to demonstrate you the CrossJustice platform. But first of all, I have to share my screen. Maybe I will need from the organizers. I'm not allowed maybe to share my screen. Okay, maybe this one, yes. So let's work now. Thank you, Galileo. IT expertise is always needed. I confess that I have a legal background, but not in the area of criminal procedural rights. Okay, so the help was really needed. So. Just a few things that I would like that you know about the platform. First of all, this platform is working and it's free. But let's check the gateway. Okay, it's work. Okay, I'm joking. You can find the platform on CrossJustice, the name of the project, .eu. And on this homepage of the platform, you have a brief presentation of its modules. There are two of them, the legal database module and the advisory module. Another important thing that you should remember is that most of the legal content provided by this system is in English as lingua franca of our days, and this gives the opportunity of legal professionals across Europe to use this system. And finally, it's a system that, of course, we hope it will be used also by law students, non-governmental organizations, even by EU citizens. But the system is specialized service. It is directed mainly to legal professionals. Its aim is to provide advice and support on the effectiveness of criminal procedural rights as guaranteed by EU acquis, and also, as you can use so today, to help them identify critical gaps, but also solutions in a comparative perspective. So from the home screen of the platform, you can directly start the modules. I will begin with the presentation of the legal database module. On the home screen of the module, there is a direct link to the text of the 6 directives. But on the left side, you can see an impressive collection of different documents that might be useful for legal professionals working in this field. There are 4 groups of documents. I will shortly present them. First of all, you have access to national legislation and national case law. In this legal field, I mean defense rights. So the national legislation, these are pieces of national legislation which transposed the requirements of the 6 directives, and the decisions of the national courts give us impression on the real application of these directives and national transposing measures. Then we have a collection of EU legislation and judgments of the Court of Justice of the EU. And here we decided to extend the content scope. So we included here pieces of EU legislation and judgments of the Court of Justice in the broader area of judicial cooperation in criminal matters. And you can find all cases of the Court of Justice and relevant legislative acts here. Then we included also documents in the area of international human rights law. These are conventions and additional protocols, but also we included here some documents that belong to the so-called soft law. These are recommendations and standard minimum rules of the United Nations and the Council of Europe. We have also in our database an impressive selection of all relevant cases of the European Court of Human Rights which are related to the topic of the project. And finally, we have, cannot be said document collection maybe exactly, but a digest with references to research articles, e-learning tools, handbooks and practical guides, reports, and research studies. Of course, documents from the CrossJustice project, but also from many other projects. This is also a good selection with references to such sources of information. There are many things to show in this module and as content and as functionalities, but I will stress on focus on three issues. First of all, I do recommend you to have a look at the impressive collection of national case law from the 11 EU member states covered by the project. These are more than 700 decisions of national courts, and each decision is supplied with a summary in English. So even if you don't speak the respective national language, you can find the main legal issues which this case refers to in respect to criminal procedural rights. I will open just as an example one of these cases. This is of a case of the Corte Cassazione, Italian Court of Cassation. You can see the text of the summary in English. It is also available in Italian language. This is valid for all cases. The summaries are in the language of the case and in English. And important information given by the national CrossJustice researcher. For instance, classification according to the concepts in Eurovoctesaurus, a classification according to the rights of accused or the suspect, and a reference to the core EU and national provisions which have been cited in this case. And finally, you have a link to the full text of the judgment on the site of the court or the legal portal which has published this decision. One of the ways how you can search national case law from the advanced search, you can choose the classifier according to rights of the accused or the suspect and choose a particular right, for instance, legal aid or a right to have access to the file, a right of retrial, etc. I will choose just as an example one of these. For instance, right to information and perform the search. Okay, we receive now a list of 114 cases relevant to this right. We can then choose a jurisdiction, for instance, Italy, and there are 10 cases which refer to this right. And in this way, you can read the national case law. Another issue that I would like to focus is the way how we interlink information between different documents and between different sources. As an example, I'm opening the directive in legal aid. And when we browse the text of the articles, we can see above each article these three icons. The first one gives us references from other documents to this article or a particular element of the article. For instance, paragraph 1 of Article 4. And now we receive a quite targeted result, 3 documents which refer particularly to paragraph 1 of Article 4. And the first one is a decision of the Chamber Court in Berlin. So I open the text of this judgment. Again, there is a summary written by the CrossJustice legal expert. And again, a link to the full text of the judgment if you would like to read the full text. The second button gives us the opportunity to read the relevant recitals of the directive which relate to the text of Article 4. And finally, we have also an icon that gives us the opportunity to check the national transposing measures, particularly for this article, and to choose one of the 11 countries covered by the project. In this example, I will choose Germany. And this is a reference to the other module, the advisory module, where this information is provided. And so we can see now the information about the national implementation in Germany. But I will continue with this in a few minutes with the presentation of this module. And finally, I have chosen to focus on the national reports that were presented today in 2 sessions. Of course, they are available in PDF format on the web page of the project, but we included the text of the national reports also in the legal database module, however, in HTML format. Why? Because in this way you can read the text of the report and make use of the links to the cited pieces of EU and national legislation, to the cited decisions of national courts. So here you have a link, and in this way you can easily find the respective decision. So that's enough for this module. I will continue now with the presentation of the advisory module. This is the home page of this module. It has 3 functionality modes, 3 ways how the user can communicate with this module and receive detailed information. These are the single case assessment mode, mass testing mode, and automated reasoner assessment, which was just presented by Galileo and Marco. So I will present only the first 2. The single case assessment mode, the idea here is in communication with the user to understand more about a particular case. Somehow it is similar to the automated reasoner assessment that was presented, but it is more simple and does not provide automated response. So the first step is the user is asked to answer several questions, for instance, about the age of the person that is suspected or accused. And I will choose for this example adult. The person is adult. Does the person fall into the category of vulnerable person? I will choose no. Which is the country where the criminal proceeding takes place? I will choose Italy for my example. Is the person a national of the country in which the criminal proceeding takes place? No. Does the person understand the language of the criminal proceedings? I will choose no. Does the person have resources to pay for assistance for a lawyer? I will choose yes. Okay. And does the person have a status of a requested person under the European arrest warrant proceeding? I will choose no. Finally, the phase is pre-trial and the person is arrested or detained by law enforcement agencies. So the second step is that the user receives a list of relevant criminal procedural rights relevant to the case. And for each right, there is additional list of aspects that are relevant for this right. For instance, information about the accusation. And now we have more detailed information, the text of the articles of the directive that regulate this right, the related recitals, the related cases of the Court of Justice, and the text of the national transpositions, and comments from the national legal experts. And just 2 additional minutes, please, for the mass testing functionality, because maybe this is the most important achievement of the project. here the user can choose either a directive or a specific criminal procedural right. I will choose Directive 800 from 2016 and compare the national implementations of one or two countries. If we choose one country, for instance, let's choose France, and we will receive this information article by article, but at the beginning there is something we call transposition map for the articles, so we can see which are explicitly transposed, which were de facto implemented because there was already national framework for some of the rights, which provisions do not require specific transposition, and especially there is information on the transposition gaps, articles that there are no national implementation. For instance, Article 5, paragraph 5, and we can open this article and see why there is no national transposition. The other modes which give us the opportunity to make comparison between two countries, I will choose Bulgaria and Italy. Again, we can see the text of the article in the directive and make comparison between two countries, and from here we can change and then compare other countries, and in this way we have full access to the impressive legal research done by CrossJustice legal experts. Thank you, and sorry. I ran out of time.
Thank you very much, Risto, for this presentation. As you have seen, we have little time, but the platform is very rich, and I think it can be used for many purposes by user practitioners, also for training. I think both law students and practitioners. I think it is a very useful learning environment. So let us move on to the last presentation for today. I have the great honor of introducing Professor Kevin Ashley. Kevin is a professor in intelligent system at the University of Pittsburgh and at the School of Law. He has been a leading researcher on artificial intelligence and law for many years. In particular, he has been really a great expert in case-based reasoning and legal analytics. He wrote also the leading textbook for legal analytics. Is editor of the Artificial Intelligence and Law Journal, so really a top scholar in our domain. So without further ado, I will give the floor to Kevin, whose presentation is entitled Applying Text Analytic Methods to Drug Interdiction Auto-Stop Cases. So thanks very much for being with us, Kevin.
Grazie Giovanni e buona serata a tutti. That's the extent of my Italian, I'm afraid. I'm grateful for this invitation to speak at the CrossJustice conference. I only wish I could be with you in person in Bologna. And I understand that Giuseppe will be operating my overheads. Let me know if that's correct.
Yes, this is correct. Sì, vuole il suo overhead. Okay, just a second, Kevin, we get organized.
Thank you. Okay.
You should see the slides now, and we are ready to move on. Yes,
Very
perfect.
good. Okay, thank you.
Thank you very much.
My colleagues and I have recently begun a project in a criminal procedural rights domain. We are applying text analytic methods to drug interdiction auto-stop cases. Next slide, please. Within the last year, we have created a Center for Text Analytic Methods in Legal Studies at the University of Pittsburgh with support from Pitt Momentum Funds. We're taking advantage of legal text analytics and applying them to perform empirical legal studies. Legal text analytics, or text mining, employs natural language processing, machine learning, and other computational techniques to extract meanings automatically from archives of legal documents, including case decisions. Our aim at the center is to apply these new techniques in machine learning and natural language processing to analyze legal cases from newly available digital repositories in order to evaluate socially relevant legal hypotheses in unprecedented ways. Next slide, please. Why is this a good time to apply text analytics in empirical legal studies? Higher resolution text analytic techniques is one reason. There are new ways for representing case texts for machine learning using word, sentence, and document embeddings and transformer-based language models. These retain semantic information while still being computationally tractable. This increases the kinds of meanings that can be extracted from the texts. Second, new comprehensive sources of legal text data have become available for research. For example, the Harvard Law School Case Law Access Project's data comprising all official book-published US legal cases from all federal and state courts. This data set, comprising more than 6.7 million cases, is available to academic researchers. Together, these enable us to evaluate new kinds of legal hypotheses. For example, we can use machine learning and natural language processing to study drug interdiction auto-stop cases in entirely new ways. Next slide, please. Here's the problem. In the United States, police officers regularly stop motorists for violating a traffic law, maybe running a stop sign or driving with a broken taillight. An officer then detains the vehicle based on suspicion that the motorist has drugs in the car. This is a search, and under the Fourth Amendment of the US Constitution, the legality of the search of the car depends on whether the officer's suspicion was reasonable. If not, the evidence resulting from the search can be suppressed. This procedure has led to thousands of cases at the state and federal levels, including at the United States Supreme Court. It also lies at the root of the phenomenon of driving while black. These stops often result in prosecutions of black drivers and sometimes violent altercations with the police. Next slide, please. Here's a picture of that traffic stop process. When an officer stops a vehicle for a traffic offense, the general rule is that the officer may detain the motorist for only as long as it takes legitimately to process the traffic offense. This may include checking the driver's license and the car's plates. The officer may approach the vehicle and return to his squad car as many times as necessary to process the traffic offense, for example, to write a ticket. If the officer wants to extend the stop beyond that, the officer must have reasonable suspicion, based on articulable facts that a crime has been committed. If the officer observes sufficient factors of suspicion, for example, driver nervousness or inconsistent stories or the use of masking agents, the officer has reasonable suspicion and then can prolong the detention, order a canine search, and determine if there's probable cause for an arrest. That's the top line on the right. If the officer observes no factors of suspicion, or the factors are insufficient for reasonable suspicion, then the detention should end. The driver may be ticketed for the traffic offense, but they should be free to leave. The questions, of course, are what are these factors of suspicion, and when are they sufficient for an officer to have reasonable suspicion? Next slide, please. In reading these cases, we find that courts rely on certain factors to assess the reasonableness of officers' suspicion. For example, as I mentioned, driver's nervousness, the use of a rental car, the use of masking agents like those little trees in by the rear view mirror to cover up the odor of drugs, prior convictions, or travel to cities or hubs known for drug activity. For these Diaz cases, that's how I'll refer to them as for short, we have identified 5 clusters of a total of 34 factors regarding reasonable suspicion. These cover occupant behavior, occupant status, travel plans, vehicle status, and vehicle contents. Those are the factors of suspicion, but when are they sufficient for an officer to have reasonable suspicion? What is their importance or weight, either singly or in combination? Those, of course, are difficult questions to answer. There are nearly 40,000 published decisions involving the legality of auto stop searches. Judges, lawyers, and police officers cannot possibly read every one of the cases. They cannot determine how courts in the aggregate view each suspicious factor an officer has identified. But processing large amounts of text is exactly what machines can do quite well. Next slide, please. We hypothesize that we can use machine learning and natural language processing to identify the factors that courts employed in drug interdiction auto stop case texts, assign weights to those factors, and assess the likelihoods that courts will find facts sufficient for search. We may also be able to identify implicit racial bias in case language. If so, we could answer the question, when are the factors sufficient for an officer to have reasonable suspicion? If we can also identify implicit racial bias in court decisions, we can explore statistical relationships of racial information, case outcomes, and factor weights. We could note differences in factor weights and outcomes across jurisdictional lines and their relationships to racial bias. Next slide, please. In the center, this is one of several research questions that we hope to address. We've developed a work cycle on the right for analyzing such research questions. It begins with formulating a hypothesis. Then we assemble the legal textual data. We develop a type system and guidelines for annotating case texts and design a text processing pipeline. We select cases at random for the training and test sets. We train human annotators to annotate the training and test sets, monitoring how well the annotators agree and resolving any conflicts in the annotation. We process the training set through the pipeline to train a machine learning model, and then we process the held out test set through the pipeline in order to evaluate the machine learning model. And finally, we evaluate the hypothesis given the machine learning model's results. And if we're lucky, we could prepare some papers for publication. Let me focus briefly on the annotation task. Next slide, please. Text annotation involves marking up the texts of cases to identify instances of semantic types of information mentioned in the texts that are relevant for analyzing the hypothesis. For example, we are interested in the factors of suspicion relevant to the issue of reasonable suspicion. The goal is to annotate enough examples of mentions of these factors so that a machine learning model can learn to identify factor mentions in cases that it has not yet seen. We will employ Gloss, an online annotation environment designed by my colleague, Jaromir Savelka. Gloss makes annotating as convenient as highlighting in different colors. Here is an example of how we annotated a case text, the case of State of North Dakota versus Aden. We highlighted a sentence using a pop-up menu to select the appropriate factor with which to annotate the text, and we did that repeatedly for the full court's analysis. The case text with annotations is shown in the middle column. A partial list of factors color-coded by cluster is at the left, and a map of the full text on the right. Next slide, please. Successful machine learning requires that humans can annotate the targeted concepts in a consistent manner. We always have at least 2 humans annotating the same documents. In our case, the human annotators are law students. A detailed annotation guideline and a factor glossary help to ensure that multiple human annotators achieve sufficiently high inter-annotator agreement. In addition, we monitor the annotations to resolve any disagreements. As shown here, our tool enables side-by-side comparison of texts marked up by 2 annotators. Then the annotators discuss and resolve any disagreements in the annotation, often with the guidance of one of the law professors on the team. To ensure sufficient inter-annotator agreement, we then measure agreement with Cohen's kappa. This metric corrects for the likelihood that the distribution of agreement results from chance rather than from real differences in the data. Next slide, please. We conducted a preliminary experiment with 40 cases involving a determination of whether reasonable suspicion was present. We applied the machine learning algorithm, logistic regression, to train a model to identify 5 factors. Here on the left, you see drug cities and hubs, masking agents, nervousness, prior convictions, and rental car, as well as the court's conclusion that suspicion was present. We annotated 520 sentences and divided them at random into a training set of 50%, 25% into a validation set, and 25% into a test set. Here, I'm reporting the results on training on the 260 annotated sentences in the training set and testing on the 130 annotated sentences in the test set. The model classified these sentences in the test set in terms of the 5 factors and conclusion. And as shown, the F1 scores, which combine precision and recall into one number, ranged from 0.89 to 0.97, encouraging evidence of the task's feasibility. Of course, we have yet to show that the model can discriminate between a sentence that is an instance of a factor of suspicion and the many more sentences that are not. And we're going to try that next. Next slide, please. Well, what about identifying racial information in the auto-stop cases? Here we need to distinguish between explicit references to the defendant's race and latent or implicit racial information. We have observed some explicit references. For example, in the Aiden case that I showed you, a dissenting judge said, "What the majority opinion does not mention is that the two women in the car with out-of-state license plates are Black. In my opinion, the appellants were the subjects of a blatant case of driving while Black." We're not sure how frequently we will find these explicit references, but we're starting to annotate the cases for racial information. Latent or implicit racial information or bias is harder to tease out, but conceivably there is a subtle method. Given word embeddings, vectors associated with two terms that share similar semantic meaning are similar. Researchers such as Rice and his team have used this property to measure racial bias in legal texts. They identified 4 concept types: African American names, white names, pleasant concepts, and unpleasant concepts. They determined the relative association of the African American category with the pleasant and unpleasant categories, and then compared that to the association of the white category with the pleasant and unpleasant categories. All of this using vector similarity. We think it's worth trying. Next slide, please. If we can identify factor weights and racial information, we can investigate relationships among racial information and implicit racial bias in Diaz cases, and case outcomes, legal merits as measured in terms of factor weights, geolocations such as blue states versus red states, time periods, and types of court, such as state and local courts versus federal court, or appellate courts versus trial courts. Findings about these matters would inform policymaking. Our empirical analysis identifying factors and weights could add certainty to a legal domain plagued with uncertain decision-making. Conceivably, we could demonstrate the need for reducing racial disparities in police conduct, in drug interdiction, automobile stops, and even in the judicial review of police conduct. And for these matters, we could provide real, solid evidence. Next slide, please. Of course, we still have some important questions to answer before our machine learning can work. Do we have enough cases to learn to identify factors? Will our annotators achieve high enough inter-rater reliability? Will we be able to identify factors with sufficient certainty? And of course, we face similar questions regarding identifying explicit and implicit racial bias. Next slide, please. We are at the very early stage of our work. We are cutting our teeth on the auto-stop cases. As we conduct this work cycle, we are preparing ourselves conceptually to apply similar work cycles to other research questions. These include focusing on racial discrimination complaints, criminal sentencing, gender discrimination cases, and judicial treatment of no-knock search cases. That's an interesting category. The no-knock search cases are another vexed legal area in which Black people are often the victims of overzealous police tactics, and we hope to apply similar techniques. Next slide, please. I'm afraid it's too soon in this research to offer any conclusions, but I'm happy to take questions.
Okay, so thank you very much, Kevin, for this, for sharing with us this new project that you have, which is so interesting and shows the possible development of legal informatics and also its contribution to social justice. So thanks a lot. So I'm very happy to take any question. The time, the hour is late, but if you have any question concerning our system or also Professor Hash's presentation, we will be very happy to take them. Okay, maybe maybe I can make a question that bridges the two domains. I think that a key issue for this kind of empirical legal inquiries is to have access to material that is relevant, and this is a problem also for our project, where if we want to have access to the materials of lower court or investigation before coming to a judicial decision, this is a big issue. I would like, maybe we can start with you, Kevin, and you tell us how the US judiciary makes approaches this kind of issue, making available materials for research.
Yes. Your audience may know that we have large commercial databases of cases available from Thomson West and from LexisNexis. And in general, it's very difficult to have access to those on a large scale for purposes of research. That's why the advent of the Harvard CAPS project is such a resource. As I mentioned, it has over 6 million cases. One has to enter into an agreement with respect to research uses, and then one can access large quantities of cases very, very conveniently. Some issues may arise when one publishes, you know, in the field of text analytics and machine learning. There's the tradition of publishing one's data, and we are working through what limitations there may well be with respect to that. The Harvard data, at least parts of it, are subject to various restrictive agreements that they've entered into and that the users have to agree to. But so far, I think that we'll be able to patch a path through for even that problem.
Thank you very much, Kevin. I don't know, Risto, do you want to say something on how you plan to, how you succeeded in getting the materials, or what material you could not get because of obstacles?
Generally, the problem with access to legal information is huge for some countries. I know, for instance, that in Italy, not all judgments of courts are publicly available. In Bulgaria, this is quite different. Actually, we have all this information publicly available. The only, sorry if you cannot hear me well. In Bulgaria, we have all the judgments made publicly available. Exception was made for several years for some judgments in criminal cases, because it was decided that even if the data is anonymized, still the persons can still be identified somehow. But in other countries, there is such problem, and this was somehow a problem also of CrossJustice researchers, and maybe that's why for some countries we have more cases in selection, and for others surprisingly not. in Bulgaria, the problem which becomes now obvious is that with the anonymization, our courts make many mistakes because they give this work to software companies that are not specialized in this field. And in some judgments, is anonymized not only personal data, but for example, the names of the courts, the names of public institutions, which is somehow a problem for access to information, to public information. But
maybe if you come here.
I have a question for Professor Ashley, because actually I find it very interesting to try to reduce bias by using AI and standardized procedures. But I was wondering how you could make sure that the data is not biased. So if one factor is the nervousness of the driver, couldn't maybe police officers think black people are more nervous, or could they maybe even be more often nervous because they are afraid of police officers? So do you have any ideas on how to reduce this data bias or whatever it's called?
Yeah, that's a very good question. We are working with the texts of the cases. The cases are reporting the findings of the judges. The judges might introduce bias. The evidence provided by the police might introduce bias. And there is a limit to what one can correct for, because we're stuck with the texts. However, if we are able to identify factors in the cases, and if we are able to then compute statistically the weights of the factors individually and in combination, it's possible that one could one would have a metric for assessing the merits of a decision, and it's possible that one could then field some kind of a system that the police could use that would guide their decision making, and possibly decrease the bias in their reporting. For example, if they're not describing the phenomena in text, but rather using a menu where weights are available and so forth, that could start to create a record. And then one, through careful monitoring of these records for different police over a period of time, determine trends that indicate bias, and perhaps address this question right at the source. But that is a very problematic possibility. It suggests the possibility of gaming of the system. Right now, we're going to just sort of content ourselves with identifying the factors and coming up with the weights and making these sorts of comparisons across jurisdictions, and at least then we'll have some documented, concrete evidence to present to policymakers.
Thank you very much. Are there other questions? Okay. So I would like to make a question myself to Marco and Galileo. So did you test, you made a logical representation of the legislation. did you test with your lawyer colleagues, at least, how easy it was for them to understand? Because you said it is transparent, people can understand the logic, but what is your, did you make any check, and what was your experience?
Okay, so the system is a step forward. It might need some further development to make it more understandable, but I think that what the legal experts could agree on is that it can help in finding all the different, in comparing and finding the interactions between the different legal systems, and we are looking at making the explanation more understandable, more user-friendly, and more.
Would you read the logical statement? Okay. Thank you very much. Any further question? Sorry. Any further question? Maybe I can put a question to Kevin. Kevin, just to go in the opposite direction with regard to the previous question, isn't it possible that your system overemphasizes biases? Because for what I understand, when negative language, you assume that that person is involved, and then bias happens. So if now, whenever the judge is angry with somebody, then you assume that a black person is involved. Obviously, you're going to get that black person are going to be treated worse than other people. Is this a possible issue or not?
I think it is an issue. We're feeling our way with respect to identifying racial bias. And the thing that I think could be helpful is that the judges are repeat performers. So we'll have multiple examples of their handling of these sorts of cases. And thus we could identify racial bias using that second method that I was describing to you across a series of data points. So it won't hopefully be determined by a particular situation. And we'll see.
Okay, great. Thanks a lot. Giuseppe, as a comment, please come here, Giuseppe.
I have a question for Kevin Ashley. Concerning the methodology you have adopted, do you think that your approach can be generalized to focus on other kinds of biases or prejudice that may be implicit in decisions or legal texts?
I'm not planning to do the work myself, but I noted in the literature, the other teams are applying text analytics to legal cases and identifying gender bias on the part of judges, and taking advantage of information that's publicly available about judges, their gender, how cases are assigned in jurisdictions, and putting this together to try to draw conclusions based on gender bias. So I think the answer is yes, it could conceivably apply in other areas.
I'm sorry. Thank you very much, Kevin. So I think that maybe time has come to conclude our conference. I would like to thank everybody, the speakers, all speakers in this event, and also the public, which has been with us up to the end of this very long day. The conference has been very interesting. We had, I think, a great interaction. In particular, I would like to thank Professor Caianiello, who was the organizer, who was oversighting all this experience, and Giuseppe and Giulia, who have been and Giuseppe and Giulia. So I would like, before finishing, I would like to invite here Giuseppe and Giulia for a few conclusive words.
Okay, so all good things come to an end, especially on Friday evening. So just a few words to conclude this conference. Very few words to recap what we have said today and try to connect some dots in the sessions that we had in the morning and in the afternoon. So in the first version, we have seen what is the importance of a proactive approach coming from courts, lawyers, European institutions, national institutions, in order to provide, let's say, the impetus for the harmonization, for a common understanding, awareness, for making these safeguards effective. Then in session 2 and session 3, we presented, let's say, the core part of the legal analysis that we carried out in the CrossJustice project. So in sessions 2, we focused on two main specific issues concerning who is the suspect and also the problem of the presumption of innocence. And here we saw how some issues concerning, for example, the interpretation of the European directives and the interpretation of the national implementation might hamper this work of harmonization, and in some critical situation also they constitute a critical problem, a structural problem for the national law, and may bring in some ways us to question whether or not the national law is overall, let's say, compliant. In the third session, we moved the perspective, let's say, to the work of the legislator, looking at the different approaches that have been used so far the issues, the gaps, but also, let's say, some ways in which we can look some new perspective. For example, the perspective of the data protection. And I see a connection here between the issues that we analyzed, the critical issues that we analyzed in the 2 sessions, and what has been produced, developed, delivered in the context of the CrossJustice project from a technical point of view. That is, for example, the issues of interpreting legal concept and the connection with the work made by our natural language processing experts, and the work done by those that analyzed the legal reasoning in search for a technical solution that was also preserving, let's say, the legal values coming from the source legal provisions. And here I can trace a link also to what has been done in session 1. That is the idea that a technology can complement, can support the work of legal professionals, lawyers, judges. That is a technology that is in some ways enhancing the activity of decision making or the activity of policy making also. And so not to relegate the humans to a very residual role, but instead to promote their role. So this is what I think can be a good way of connecting the legal research and the technical research in this area and other areas of the law. Very quickly, also the result of what we are delivering at the CrossJustice project. We have already discussed many of these things: the platform, the advancement that we have made. We think that we have made in our models, in our computable models of the law and the legal reasoning, the national legal reports that we have just very quickly discussed here. And an important comparative legal studies across the 11 jurisdictions covered by the project. One additional result that we are just completing right now is a set of policy recommendations. So the idea that we think that we can give our little contribution, not only enumerating the list of issues and problems, but maybe at the end of this journey of 2.5 years, let's say, tackling the problem from different perspective with a multidisciplinary approach, something that can be made looking at the work of policy makers, professionals, judges, and also citizens in some ways. So, okay, so, and further, let's say, outcome of the project that is, let's say, also an outcome that we hope will survive after the project is a book that we are publishing, in which we collect the results and further additional material that is in some ways inspired by the research that we carried out in 2.5 years. Coming soon. I think that we don't need to cross the fingers anymore, because we are approaching the publication of the book. Okay, I'll leave the floor to Julia now.
Very, very quickly, because we know the time is late. What is the future perspective? Because the idea is not just to comment today and be happy about the end of this research, but also to see from where we can start from here. And this is just a starting point. We want to see this research as a starting point for the future researches that will come. We are already working together to try to find new ways to apply the knowledge that we have developed, or try to develop in these months and these years, actually, to other fields of law, in criminal procedure, potentially could be also beyond criminal procedures, of course. and to see how the reasoning and methodologies developed can be improved to meet better the needs of the legal professionals and potentially also all the legislator and the citizens. And to be honest, also it is that this research was real fun, and then we just don't want to stop working together and having these events together, because it's just so nice to do that. And with that in mind, what we aim to do, and we think this is, as a final remark, it's also important to stress out, is a research that is aware of the context in which research operates today. It is a complex context, and therefore the research has to have the capacity to make it a structural feature, the capacity to put different knowledge and domain of knowledge together to allow people to communicate effectively between different legal cultures, between legal culture and computer science, informatics, and that has to be done not as an extemporaneous thing, but really as a systemic feature of the research. This is something we very much believe in. And this is something that could allow us to overcome barriers, linguistic barriers, and to look at what unites us even in the problems, the common problems we have together, kind of exemplificatory that we talked about today much about the presumption of innocence, and therefore seeing really what keeps us together, not just what divides us, what makes it difficult to talk and dialogue together. And that we think as a kind of final message is in particular important today, not just for our legal research, also considering the context and the dramatic news we are living in, we are watching in these days. And that is, we think, essential for the development of an effective and not just an illusory safeguarding legal system, but also as our future as Europeans, which kind of community we want to build together. Therefore, the idea is also to promote the research. That's what we are committed to, that it's not just about theoretical issues, which we all love as academics, but also that doesn't fear to address the challenges that comes from practice. So tries to produce something that is really of help to the legal actors and the practitioners in making those rights really more effective, as we hope that this platform contributes to do and will contribute to do. In this sense, we are very much eager to further disseminate that, and we kindly invite you to continue to do that if you think it's worth. And last point, that is also something that we perhaps were not so aware at the beginning of our research, but we are increasingly aware of, is that we need to abandon an idea of facing digital technologies as something we just need to defend us from. That is sometimes still the perspective of criminal lawyers to a certain extent, and it is about time to be bold and to find new innovative solutions that take the opportunities that digital technologies and artificial intelligence, of course, gave us to create new ways of safeguarding fundamental rights that perhaps were not even foreseeable a few years ago. So that's the time to be bold. That's the time to look really forward and to try to make a further step in the next research. And of course, being creative and also being scientifically rigorous, it's something that is much easier to do when you have a work that is done together. And that's why we want to finish this conference with a thank you that is not really a formal thank you, also because, you know, we are not very formal as persons. So a thank you really to all the guests, the distinguished guests that were with us today, and also to the CrossJustice partners that work so much and with such enthusiasm for 2.5 years. It has been really a pleasure. So the team of the University of Wrocław, the team of the University of Zagreb, the team of the University of Leiden, the team of the University of Torino, the European University Institute, and of course APIS Europe, that made all this much more concrete. Thank you very much to the national rapporteur that, although being external to the project, contributed so much to this result. And thank you also to all the people that attended this event and also the previous workshop at the national level. And thank you for all your feedbacks, because one of the reasons why the project and the platform, I think, have improved a lot, it's also because of your feedbacks. And then finally, of course, let us just name. We couldn't name now for time constraints all the people in the project, but let us name those without whom really we wouldn't have arrived here in the status we arrived today, for sure. That is the great team of the University of Bologna. And really, they work so much to make this whole project possible, not just a conference. So thank you very much to Alessandra Sant'Angelo, to Galileo Sartor, to Marianna Biral, to Marco Billi. Really, this project wouldn't have been possible without you. And we thank you all very much, and enjoy the weekend, I guess.